Code officer, madam. Code officer, madam.
MFA.
ಯಾರು ಇದು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅಂದಿದ್ದು? ಯಾರು ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ?
Madam,
ಯಾರ ಕೇಳಿದ್ರು?
ಅದೇ ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ. ನೋಬಡಿ ಈಸ್ ಕನೆಕ್ಟೆಡ್. ಯಾರು ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲಪ್ಪ.
Wait.
ಹಾ
ma'am, MFA fresh matter.
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ ಡೈರೆಕ್ಷನ್ಸ್ ಇದೆ.
Court officer, madam. Court officer, madam. Madam.
ಹೇಳಿ. ಹಲೋ ಸರ್, ಹೇಳಿ ಏನ್ ಬೇಕು? ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ ಅಂದ್ರೆ ಎಲ್ಲಿ ಕೇಳಿಸುತ್ತೆ?
ಮೇಡಮ್ ಅವರು ಮೋಸ್ಟ್ಲಿ ಟೆಸ್ಟ್ ಮಾಡ್ತಾರೆ.
ನೋ ಮೆಮೋಸ್.
No memo. MFA.
Court officer, madam. Madam.
ಸರ್ ಹೇಳಿ.
MFA 661 of 2024.
ಹಾ
ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ ಅದು.
ಹಾ
ಇವತ್ತಿಗೆ ಡೇಟ್ ಇದು ಲಿಸ್ಟೇ ಆಗಿಲ್ಲ ಅದು.
ಯಾವತ್ತು ಲಿಸ್ಟ್ ಇತ್ತು ಸರ್ ಅದು?
ಲಾಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಇತ್ತು ಮೇಡಮ್.
ಹೋಗಿ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ನೋಡಿ ಫೈಲ್ ಏನಾಗಿದೆ.
ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿತ್ತು ಅದು ಮ್ಯಾಟರ್ ಲಾಸ್ಟ್ ಟೈಮ್.
ಕರೆಕ್ಟ್ ಸರ್, ನನ್ಗೆ ಈಗ ಲಿಸ್ಟ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ವಾಟ್ ಐ ಕ್ಯಾನ್ ಡೂ, ಯು ಗೋ ಟು ದ ಬ್ರಾಂಚ್, ವಾಟ್ ಹ್ಯಾಪನ್ಸ್ ಟು ಯುವರ್ ಫೈಲ್, ಯು ವೆರಿಫೈ ಇಟ್ ದೇರ್.
ಓಕೆ, ಯಾಕೆಂದ್ರೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲ ಕಂಪ್ಲೈ ಆಗಿದೆ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲ ಕಂಪ್ಲೈ ಆಗಿದೆ. ಹಿಯರಿಂಗ್ ಅಡ್ಮಿಷನ್ ಬರ್ಬೇಕಾಗಿತ್ತು.
ಅದೇ ಸರ್, ನೀವು ಹೋಗಿ ಒಂದ್ಸತಿ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ವೈ ಇಟ್ ಈಸ್ ನಾಟ್ ಪೋಸ್ಟೆಡ್ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ ಅಂತ ಅಲ್ಲಿ ಕೇಸ್ ವರ್ಕರ್ ಇರ್ತಾರೆ, ಕೇಳಿ ಅವ್ರು.
ಸರಿ,
ಓಕೆ
ಮೆನ್ಷನಿಂಗ್ ಮಾಡ್ಬೇಕಾ ಮೇಡಮ್ ಮುಂದೆ? ಏನ್ ಮೇಡಮ್
ಹೇಳಿ ಸರ್.
ಮೆನ್ಷನಿಂಗ್ ಮಾಡ್ಬೋದಾ?
ಒಂದ್ಸತಿ ನೋಡಿ ಅಲ್ಲಿ 2 ಡೇಟ್
ಸರಿ.
ಗಿವನ್ ಮ್ಯಾಟರ್ ಮಾಡಿಫೈ ಆಗಿದೆ.
ಆಹಾ,
Because that stenographer gone on
Uh-huh.
leave for
Sorry.
2 date given matters, date has been modified to 22. ನೀವು ಇದ್ರಲ್ಲಿ ಒಂದ್ಸತಿ ವೆಬ್ ಇದ್ರಲ್ಲಿ ನೋಡಿ.
21st August ಅಂತಾನೆ ತೋರಿಸ್ತಾ ಇದೆ ಕೇಸ್ ಸ್ಟೇಟಸ್ ನೋಡಿದ್ರೆ.
ಇನ್ನೊಂದ್ಸರಿ ನೋಡಿ, ನೆನ್ನೆ ಮಾಡಿಫೈ ಆಗಿರ್ಬೇಕದು.
ನೆನ್ನೆ ಮಾಡಿಫೈ ಆಗಿರ್ಬೇಕಾ?
1, 2, 3 ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಡೇಟ್ ಮಾಡಿಫೈ ಆಗಿ 22nd ಹೋಗಿದೆ.
ಹೌದಾ?
ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಇದೆಯಾ ನಿಮ್ದು ಅಂತ ನೋಡಿ. ಯಾವತ್ ಪೋಸ್ಟ್ ಆಗಿತ್ತು ನಿಮ್ದು?
21st ಅಂತ ಪೋಸ್ಟ್ ಆಗಿದೆ.
ಅಲ್ಲ ಸರ್, ಯಾವತ್ತು ಪೋಸ್ಟ್ ಆಗಿದ್ದು?
ಲಾಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಮೇಡಮ್.
ಆ?
ಲಾಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಅಂದ್ರೆ 20ನೇ ತಾರೀಕು.
20ನೇ ತಾರೀಕಾ?
ಅಲ್ಲ
ಏನ್
20
ನಂಬರ್
ಅಲ್ಲ
ನಂಬರ್
20 ಅಲ್ಲ,
ಹೇಳಿ.
ಸಾರಿ
ನಿಮ್ ನಂಬರ್
20 ಅಲ್ಲ.
ಹೇಳಿ ಸರ್. ನಂಬರ್ ಹೇಳಿ
MFA
ನಿಮ್ದು.
661 MFA 661
ಆಫ್
2024 661 of 2024.
ಓಕೆ, ಐ ವಿಲ್ ಸಿ, ವೇಟ್ ಸರ್.
ಓಕೆ ಮೇಡಮ್.
Memo 20.
Fresh
Fresh ಅಲ್ಲ ma'am? 20.
ಇದ್ದಾರೆ, ಅವ್ರಿಗೆ ಕರೆದು ಡೈರೆಕ್ಷನ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಮೇಡಮ್. ಸೊ ಅವ್ರಿಗೆ ಹೋಗಿ ಹೇಳಿ ನೀವು.
23.
ಏನಾಗಿದೆ ಅದು?
ಅದು idea ಇಲ್ಲ ma'am, ಗೊತ್ತಿಲ್ಲ ಅದೇನಾಗಿದೆ ಅಂತ.
ಗೊತ್ತಿಲ್ಲ ಅಂತ ನಾವೇ.
ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ.
ಗೊತ್ತಿಲ್ಲ ಅಂತ ನಾವು
ನಾನು ಓದಿಲ್ಲ.
ತಗೊಳಲ್ಲ. ಅಪ್ ಟು 2020 ಅಡ್ವಾನ್ಸ್ಮೆಂಟ್ಸ್ ಆಗಿದೆ. ಗೋಲ್ಡ್ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಅಡ್ವಾನ್ಸ್ಮೆಂಟ್ಸ್ ಇದೆ ನೋಡಿ, ಅಲ್ಲಿ ಹೋಗಿ ನೋಡಿ. ಯಾವ್ದೋ ಫೈಲೇ ಹೋಗಿಲ್ಲ ಅನ್ಕೊಳ್ಳಿ.
ಮೇಡಮ್ ಲಾಸ್ಟ್ ಡೇಟ್ 13th August ಇತ್ತು. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ 21st August ಅಂತ ಇವತ್ತಿನ ಡೇಟೇ ತೋರಿಸ್ತಾ ಇದೆ.
ಅಡ್ಮಿಷನ್ ಇದೆ.
ಒಂದು ನಿಮಿಷ ಸರ್, ಐ ವಿಲ್ ಸಿ. ಯಾವತ್ತು? 20ನೇ ತಾರೀಕಾ? ಯಾವತ್ತು ಹೇಳಿದ್ ನೀವು?
13th August ಇಂದ 21ನೇ ತಾರೀಕು.
ಒಂದ್ ನಿಮಿಷ
13 ಇಂದ 21.
ತಗೋ.
ಏರ್ಟೆಲ್.
ಪೋಸ್ಟ್ ಆಗಿತ್ತ ಅದು?
ಹೌದು, 13ನೇ ತಾರೀಕು ಕೋರ್ಟ್ ಮುಂದೆ ಪೋಸ್ಟ್ ಆಗಿತ್ತು.
ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ ನಿಮ್ದು ಅವತ್ತು?
ಅವತ್ತು ಸೀರಿಯಲ್ ನಂಬರ್ ಐ ಥಿಂಕ್ 15, 16 ಆ ತರ ಇದ್ದಿರ್ಬೇಕು ಮೇಡಮ್. 15 ಇದ್ದಿರ್ಬೇಕು.
Verify it in the branch. 21/8 ಅಂತ ಡೇಟ್ ಇದೆ, ಪೋಸ್ಟ್ ಮಾಡಿಲ್ಲ. ಯಾರಿಗೆ ಹೇಳಿದ್ರು ಬೆಳಗ್ಗೆ ನಮ್ಗೆ ತಲೆ ಕೆಟ್ಟು ಗೊಬ್ಬರ. ಇಲ್ಲಿ ಫೈಲ್ ಹೋಗಿದ್ಯೇನೋ ಯಾರಿಗಾಗಿತ್ತು ಅರ್ಜಿ ರಿಕ್ವೆಸ್ಟ್ ಆಗ್ತದೆ. ಯಾವತ್ತು 13ನೇ ತಾರೀಕು? 651.
ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಇತ್ತು ಮೇಡಮ್ ಅವತ್ತು.
ಸರ್, ಅದು ಬ್ರಾಂಚ್ ಫೈಲ್ ಹೋಗಿದೆ. ನೀವು ಒಂದ್ ಸ್ವಲ್ಪ ಆ ಬ್ರಾಂಚ್ ಅವ್ರಿಗೆ ಹೇಳಿ, ನಾಳೆ ಏನಾದ್ರು ಲಿಸ್ಟ್ ಮಾಡಕ್ ಹೇಳಿ.
ಸರಿ ಮೇಡಮ್.
ನೀವು ಇವಾಗ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ಕೊಟ್ಟು ಫೋರ್ಸ್ ಆಗ್ಲಿಲ್ವಾ? ಅವ್ರಿಗೆ ಸರ್ ವಿಡ್ರಾಯಲ್ ಅಂತ ಬರ್ದಿರ್ತೀರಾ, ಆದ್ರೂ ಅವರು ಬರ್ದಿದ್ದೀರಾ ಅಲ್ವಾ? ಸಬ್ಮಿಟ್ ಮಾಡಿ ನೋಡೋಣ. ಅವ್ರು 2 ಮೆಮೊ ಕಳಿಸಿದ್ದಾರೆ. ವಿಡ್ರಾ ಮಾಡ್ಕೊತೀನಿ ಪೋಸ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಹೇಳಿದ್ರೆ ನಮ್ಗೆ ಆಯ್ತು. ಫೈಲ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಕಳಿಸ್ಬೇಕಲ್ಲ ಮೆಮೊ ಮಾಡ್ಕೊಂಡಾದ್ಮೇಲೆ ಎಲ್ಲ ಇದು ತಗೊಂಡು ಅದು ಇದು ಮೆಮೊಗೂ ಕೊಡಿ, ಯಾರು ರಿಸೀವ್ ಮಾಡಿ ಅನ್ನೋದನ್ನ ಒಂದೇನು ಮೂವ್ ಮಾಡಿದ್ದಲ್ವಾ ಇವರು? ಯಾವತ್ತು ಮೂವ್ ಮಾಡಿ ಸರ್ ನೀವು? ಮಂಡೇ ಅಲ್ಲ? ಮಂಡೇ ನೋಡೋದು ಇದೆಯಾ? 1408 ಇದೆ ಮೇಡಮ್. ಯಾವತ್ತಿಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ? 20ಕ್ಕೆ. 19ಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ, 20ಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀವಿ. ನಾನು ರಿಸೀವ್ ಮಾಡಿದ್ದಾರೆ. ನೀವು ಮಾಡಿದ್ರಂತೆ.
GMFC cases interim maintenance ನ ಚಾಲೆಂಜ್
ಕತೆ ನಮ್ಗೆ
ಸರ್. GMFC ಅಂದ್ರೆ interim maintenance ಅವಾರ್ಡ್ ಮಾಡಿತ್ತಲ್ಲ, ಅದನ್ನ ಚಾಲೆಂಜ್ ಅದನ್ನ ಏನಾದ್ರು ಒಂದು ಕತೆ ಗಟ್ಟಿ ಹೇಳ್ಬೇಕಿಲ್ಲ. ನಿಮ್ಗೆ ಇಂಟರ್ನೆಟ್ ವರ್ಕ್ ಆಗ್ತಿಲ್ಲ? ಇಲ್ಲ, ಅದೇ ನಾನು ನೋಡ್ಬೋದು.
$661 of ಯಾವ year ಅದು? 24 MFA. MFA 661 of 23 and 24 ಇದೊಂದು ಡೇಟ್ ಪೋಸ್ಟ್ ಮಾಡಲಿಲ್ಲ ಅಂತ ಯಾಕೆ? ಪೋರ್ಟಲ್ 21. ನಿಮ್ಮಲ್ಲಿ ಫೋನ್ ಎತ್ತಕ್ಕೆ ಏನು ಇವ್ರೆ? ನಿಮ್ಮಲ್ಲಿ 840 ನಾವು ಬರೀ ಫೋನ್ ಎತ್ಕೊಂಡು ನಿಂತ್ಕೊಳ್ಳೋದೇ ಆಗುತ್ತೆ ನನ್ ಬೆಳಗ್ಗೆಯಿಂದ. ಇನ್ನೊಂದು ಬರ್ಕೊಳ್ಳಿ, MFA 1408 ಅವರು ಮೆಮೊ ಫಾರ್ ವಿಡ್ರಾಯಲ್ ಅಂತ ಸ್ಲೀಪ್ ಹಾಕ್ತಿದ್ದಾರೆ. ವಿಡ್ರಾಯಲ್ ಪುಟಪ್ ಮಾಡಕ್ಕೆ ಏನು ನಿಮಗೆ? ಪುಟಪ್ ಆಗಿಲ್ಲ. ನಾನು ನೆಕ್ಸ್ಟ್ ನನಗೆ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಆಗ್ತದೆ ಕೋರ್ಟಲ್ಲಿ. ಐ ವಿಲ್ ಪ್ಲೇಸ್ ಇಟ್ ಬಿಫೋರ್ ದಿ ಇದು ಅಷ್ಟೇ. ನಾನು ಮೇಡಮ್ ಮುಂದೆ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀನಿ. ಈ ತರ ಎಲ್ಲ ನಿಮ್ಗೆ ಸುಮ್ಮನೆ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಕ್ರಿಯೇಟ್ 1408 withdrawal memo moved on Monday. Date is given on Tuesday. When the file is not with you ಅಂತ ಅಂದಾಗ ಫೈಲ್ ಎಲ್ಲಿದೆಯೋ ಅಲ್ಲಿ ಮೆಮೊನಾದ್ರು ಕಳಿಸ್ಬೇಕಾನೆ ನೀವು. ಏನೋ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಲ್ಲ ನೀವು, ಸುಮ್ಮನೆ ಇರಿಸ್ಕೊಂಡು ಅಲ್ಲಿ ಡಸ್ಟ್ಬಿನ್ ಹಾಕೊಂಡ್ಬಿಡ್ತೀರಾ. ಮತ್ತೆ ಏನ್ ಮಾಡ್ತಾರೆ ನಿಮ್ ಕೇಸ್ ವರ್ಕರ್ಸ್? ನಾನು ಮಧ್ಯಾಹ್ನ 1:30 ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀನಿ, ಕರೀರಿ ನಿಮ್ ಕೇಸ್ ವರ್ಕರ್. 661 ಅರೌಂಡ್ ಡೇಟ್ ಮ್ಯಾಟರ್ ಆಗ್ತಿಲ್ಲ. ಕೇಳಿ ಎಲ್ಲ ಕೇಳಿ. ನಾನು ದಿನ ಬೆಳಗ್ಗೆ 10:30 ಬಂದ್ರೆ 3/4 ಗಂಟೆ ಕತೆ ಹೇಳೋದೇ ಆಗುತ್ತೆ ಎಲ್ಲ ಬ್ರಾಂಚ್. ನಾನು ಇಲ್ಲಿ ನಮ್ ಕೆಲಸ ಮಾಡಿದ್ರೆ ನಿಮ್ ಕೆಲಸಗಳಿಗೆ ನಾನು ಕತೆ ಹೇಳ್ಕೊಂಡ್ಕೊಳ್ಳ. 2ರಲ್ಲಿ 1 ಬೇಕು ನನಗೆ. ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ 1:30ಗೆ. ಕೊಡೋ ನಾಳೆಗೆ ಇನ್ನೊಂದ್ಸತಿ ಪೋಸ್ಟ್ ಮಾಡಿ ಸರ್. ಅಲ್ಲಿ ಒಂದ್ಸತಿ ಹೋಗಿ ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಇದೆ ಅನ್ಸುತ್ತೆ. ಸ್ಕೂಟ್ನಿ ಬರ್ದಿದ್ದಾರೆ ಪಾಪ ಅವರು, ಅವತ್ತು ಬರ್ದಿದ್ರು ಅನ್ಸುತ್ತೆ. ಸ್ಕೂಟ್ನಿನಲ್ಲಿ ಇದೆಯಾ ಸರ್? ಮೆಮೋಸ್ ಎಲ್ಲ ಫ್ರೆಶ್ ಮಾಡಿದ್ರೆ ಸಬ್ಮಿಷನ್ ಸರ್. ಮೆಮೋಸ್ ಯಾವ್ದು ಓಲ್ಡ್ ಆದ್ರೆ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ಅಪ್ ಟು 2020 ಅಡ್ವಾನ್ಸ್ ಲಿಸ್ಟ್ ಆಗಿದೆ. ಓಲ್ಡೆಸ್ಟ್ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಪೋಸ್ಟ್ ಹಾಕ್ಬೇಕಂತ 23 ಅದಕ್ಕೆ
ಹೌದಾ
ಸಬ್ಮಿಟ್ ಮಾಡಿ.
ಕಲಿಗ್ದು ಯಾರು
ಅದೇನೆ ನಾವೇನ್ ಮಾಡೋಣ ಸರ್, ಈಗ ಎಲ್ಲ ಕೇಳ್ತಾರೆ ಮೇಡಮ್ ವಾಟ್ ಈಸ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ, ನೀವು ಹೇಳಕ್ ರೆಡಿ ಇರ್ಬೇಕಷ್ಟೇ. ನಿಮ್ದು ಹೇಳಿ ಸರ್. ಫ್ರೆಶ್ 21 ಹೇಳಿ, ಅಲ್ಲಿ ಹೇಳಿದೀವಿ ನಾವು. ಅಡ್ವಾನ್ಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಅನ್ಸುತ್ತೆ ನಿಮ್ದು. FC ಮ್ಯಾಟ್ರ್ ಅಲ್ವಾ? FC 21 ಅಡ್ವಾನ್ಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ. ಅವ್ರಿಗೆ ಹೇಳಿ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಹೋಗಿ ಅಡ್ವಾನ್ಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಆ ಫೈಲ್ಸ್ ಎಲ್ಲ ಇರುತ್ತೆ. ಬೋರ್ಡ್ ಅಲ್ಲಿ ಕೊಡಿ. ಅವರು ನಮ್ ಕೇಸ್ ವರ್ಕರ್ ಇದ್ದಾರೆ, ನಮ್ ಕೋರ್ಟ್ ಮಾಡೋ ಕೇಸ್ ವರ್ಕರ್ ಹೋಗ್ಬಿಟ್ಟು ಅಡ್ವಾನ್ಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಫೈಲ್ ಇದು 2021 ಅವ್ರಿಗೂ FC ಅಡ್ವಾನ್ಸ್ ಲಿಸ್ಟ್ ಇದೆ, ಅವ್ರ ಹತ್ರ ಹೇಳ್ಬಿಟ್ಟು ತಗೊಂಡು
ಬೋರ್ಡ್ ಅಲ್ಲಿ ಕೇಳಿದಾಗ ಕೋರ್ಟ್ ಮುಂದೆ ಮೂವ್ ಮಾಡಿ ಫ್ರೆಶ್ ಮಾಡಿ.
ಫ್ರೆಶ್ ಮೇಕರ್ಸ್ ಅಲ್ಲ ಸರ್, ಅವ್ರಿಗೆ ಅಡ್ವಾನ್ಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ರೆ ಮಾಡ್ತಾರೆ. ಹೋಗಿ ಹೇಳಿ ಸರ್.
22 ಇದೆಯಾ ಮೇಡಮ್?
21 ಅಲ್ಲಿ ಇದೆ, ಅಡ್ವಾನ್ಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಫೈಲ್ಸ್.
22 ಇದೆಯಾ?
ಹೋಗಿ ಹೇಳಿ ಅವ್ರ ಕೇಸ್ ವರ್ಕರ್, ಅವ್ರು ಯಾರು SO ಇರ್ತಾರೆ ಬೋರ್ಡ್ ಅಲ್ಲಿ, ಅವ್ರಿಗೆ ಹೇಳಿ.
22 ಮೇಡಮ್?
22 ಇಲ್ಲ ಸರ್, ಇನ್ನು ಅಪ್ ಟು 21 FC.
Yes.
A fresh matter, my lord, all the office objections were complied. It's, listed date is given on 29th in the family court and they're pushing in for maintenance.
Take that and please verify why it is not listed. Once it is, yes.
In LAC MFA, my lord, CP has been filed as indigent person. That CP came to be allowed. In view of the allowing CP, the MFA is required to be recalled.
Required to be?
We have filed IA for recalling the order dated, which has been dismissed for non-payment of court fee. For payment of court fee, CP has been filed. CP came to be allowed.
Take that on Tuesday.
My lord, respondent is issued, said that the execution petition
Huh?
for the trial court, execution petition.
Next,
Hmm.
28.
Coming up 31st, my lord.
Which year is,
The petition is 2021.
that's a whole difficulty. What is the urgency for 2021 matter? Post on Wednesday. Yes. So RPFC, finally it has to be heard. In every case, this is what would be the interim order. Out of the way, no reason to take it now. 20, we'll take those matters also. There are matters still pending for admission. Huh? You're getting 20,000 at least. There are cases and cases where they're not even getting, not an urgency for that. Yes, give a date after 4 weeks. Yes. Yes.
My lord,
So,
my lords, in family court, we are adjourning this matter for advancing every month, my lord, because they are giving 2 months once. They already deposited the amount, and every month we are advancing the case. She is already on record, but I filed a memo for posting more than 10 times, but it's not appearing. It's a matter for.
Which year?
He is suffering from sinus problem.
Which,
Kindly have it on.
then in that case, every alternative person in Bangalore will suffer with sinus. It is the reason.
Family court
Which year is
already-
that? Which year is that? Which year is that petition?
Oh, she's already in record.
which year?
24, my lord. But there it is in 22, MC is 22.
Writ petition or RPFC?
Writ petition.
Take it next Thursday. Yes.
Thursday,
For consideration of
31st.
20.
No, fine. You can't ask for this thing and not. Whatever Thursday I said, it will be.
For
Yes.
consideration of mediation report, ma'am.
Huh?
For consideration of mediation report, ma'am. It's settled between the parties.
It is settled tomorrow. Yes. It will come. All the bundle. That should be. Yes. Take that also.
ಇವತ್ತೇನಾ? Today.
No, take that also. Why the matter is not listed after complying with the office objections, find out. Which year? It is,
ಎರಡು ಅಲ್ವಾ?
take that tomorrow. Yes.
Family court matter. Yes,
Mhm.
tomorrow. Family court matter, the petitioner's petition right to see the order was rejected.
Tomorrow. Yes.
Tomorrow.
Call the list.
Page wise adjournment, page 1, serial number 1 and 2.
We have challenged order 39 rule 1 and we have filed LRFK. Kindly have it in the next day.
What is the urgency for that?
What has happened is we have filed
Which year is that?
24 months.
Next week.
Next Thursday.
Hold this matter on 2nd of September.
Second of.
Yes.
Page wise adjournment, page 1, serial number 1, 2, page 2, serial number 3, 4, page 3, 5 to 8.
Hmm.
Settlement talks are going.
What is it?
And the respondent in this case. Case is between the children and the parents for the maintenance. So negotiation is going on. So Your Honor, may just for 2 weeks.
For the petitioner, settlement talks are going on.
Yes, it's submitted, it is submitted by both the councils that There is a likelihood of settlement post this matter on 18th of September. Yes,
Till number 6 ಅಲ್ಲ sir. Page number 4, till number 9 to 17.
Serial number 15, almost matter is settled. They have paid a 50% amount of to the funding. Another 50% amount has to be paid already. It will take time. 2 weeks.
at the request of the counsel for the appellant, post this matter after 2 weeks,
Both, two of them.
15 and 15, yes. Yeah, yes.
Okay. Page number 5, serial number 18 to 20. Page 6, serial number 21 to 28.
My lord, 23, my lord. I appear for respondent, my lord. I informed the petitioner side. The thing is, my lord had asked us to file an affidavit. Party is illegal, my lord. He needs to
I
travel.
think this is a second time submission of yours about parties ill.
No, madam. My lord, this is my first time, my lord. Last time we had argued the matter. My lord had asked to file an affidavit. My lord, have it on next Wednesday, my lord. He is not could, he couldn't travel from Mangalore, my lord. Hence could not file. I would inform.
Finally, at the request of learned also the respondent, each time is granted,
Both matter. 20 and.
or else the matter will be heard on merits of it. No further.
Serial number
Date, my
22, my lords.
22.
Serial number 22. It's the petitioner is now a resident of Australia. The proceedings before the family court are run for restitution of conjugal rights. We had filed an application seeking permission to lead evidence by way of video conference. That application was rejected. And it's challenging that the present writ petition is filed. Lords, I don't know the latest status, my lords, between the parties. May I request a week's time, my lords? I'll ascertain and have it next week.
You appear?
Respondent, you are. The petition can be allowed, you are. They have no objection.
Please,
When the matter comes, we'll pass on.
Yes, you are.
please.
Direction ಆಗ್ಬೋದು
Date
sir.
may be given.
My lords,
Matter on 10th of September, this matter earlier one, yes.
my
Will
lords,
be heard.
Page number 7.
That's what now, right now I can't allow, I have to pass an order for that. Let the
Yes.
matter read, yes,
Page
my
number
lords, the serial number 25, my lords.
yes.
I am for the petitioner. I have informed the other side, my lords. If permissible, 2 weeks time, my lords, I have to furnish a DD. The party was unable to gather funds. He is seeking another 10 days, my lords. Any week, any
I
day in the
remember
first
this
week.
case, you argued extensively,
yes.
then it is adjourned.
Yes, my lords. He could not gather
By the
funds.
time you argue, you argue this matter, the court will forget everything. All the,
No,
again.
certainly not. That's
At the
not
request of
the
the
intention,
counsel
my
for
lords.
the
I just want.
petitioner, post this matter after 2 weeks for further adjournments, post on 10th of September.
My lords, a date may be fixed, my lords.
10th of September,
Oh, much obliged. Much
Yes.
obliged.
Page number 7, serial number 29 to 32, page 8, 33 to 35, page 9, 36, 37, page 10, page 12, serial number 38.
My lords, serial number 38, months. I am for the appellant, months. A week's time may be given. My lords. Senior is not well, my lords.
it's being there in the list. If you're not interested, what to do, post this matter on 24th of September.
Interim order may be extended.
Oh, interim order is there. Then we will have it, post this matter on Tuesday.
Next Tuesday,
No
27.
further adjournments.
Much of it. Interim order may be
Page
extended.
number,
Interim order extended, interim order granted earlier is extended till then.
page 13, serial number 39 to 43, 44, serial number 4, page number 14,
40?
40 in person.
Hmm. Give that list of advocates. We'll appoint somebody.
Legal services.
Wait for your turn, we will appoint.
The page number 14, serial number 45 to 47, page 15, 48 to 50.
Yes, call the list.
My lordships on submission, my lordship.
Page 1,
Page number 3, serial number 6, my lordships. I forgot to tell, interim order is there, my lordships. I forgot to mention that, my lordships.
Yes.
Much obliged, my lordship.
Page number 1, serial number 1, Balraj for petitioner, Devraj G.
Respondent.
My lord.
Yes. What are those judgments?
The family court.
Hmm.
Because the family court, we have 4 IAs,
Hmm.
A number 18 to 21. Wherein the court has allowed the IA first.
Hmm.
And on the review application, it has reviewed the matter, which is not, which is which lacks jurisdiction to the family court. One. Second, the thing is, 4 IAs.
Eighteen to 21.
18 to 21. Eighteen.
Yes.
The neighbor has been summoned to verify the signature.
Where is improved order?
Improved order.
Page 130.
1?
130.
Orders.
Page 130, there is nothing.
Page number what that is? 130. The order passed on IA number.
3rd January 2024.
Please, please.
That's on 133. Yes.
The one is the family court cannot review. It has reviewed. It lacks jurisdiction to do so.
What is review?
Once it was my application, all 4 years have been allowed in the family court. Later,
No, I remember.
Yes, yes.
Where is that, order allowing your applications?
in the order sheet, it is just, it is in the order sheet.
Page number?
According to my page number is 128.
That
Yes.
is allowed on 129. Yes, the court has called for a report from the
Yes.
learned judge.
Page number 120.
He filed a petition to review the order.
Yes, I have filed objection.
He has filed a petition to review the order.
Yes,
Hmm.
that has been allowed.
Hmm.
So against that order, I prefer.
So according to you, it cannot be reviewed.
Yes, it cannot be reviewed. It can be recalled. It cannot be reviewed.
It can be?
Recalled, it cannot be reviewed.
Hmm.
It is very clear section.
Hmm.
Only judgment and degree can be reviewed. Not the order.
Give that CPC. One on four. Yes. What do you say?
It's an appeal or an order. But the applications, normally any application for issuing the summons. I'm the last person to oppose because the burden is on the petitioner. My last look into the application, what they are seeking for the summons.
No, we are on the scope of review.
Review, yes. Lord, sir, if
According
my
to
lords
that
look
is
into Section
permissible.
114A, my lords,
Section?
114, review, power of the review.
Hmm.
Subject as aforesaid, any person considering himself agreed a decree or order,
Hmm. 1 minute.
please.
Hmm.
114A, my lords.
Yes.
My lords, by a decree or order from which an appeal is allowed by this court, but from which no appeal has been preferred. I have not preferred any appeal against the order passed by the court. 17.2 is the order which has been passed allowing the application. I brought to the notice of the court saying that, my lords, by apparent on the face of the record, these applications, what they have been seeking for an issue, being 2013 matter, my lords, issuing a notice to the Attorney General of Singapore and my lords to Delhi principal to Delhi Public School. What purpose would be served? Because the petition is the ground on the adultery. Lord, if he has to prove his case, issuing a summons to the Attorney General and getting the passport, my lord, this is the problem. Then the court said that you know what has to be done. I filed a review application very next day, my lords. Not even I've taken a breathing time. They filed their objections. The matter has been heard. One, my lords, the technical, my lords, the court, when they have passed an impugned order, it should have passed on the basis of a review. But the court has said that, my lords, on order on IA number 18 to 21. The quota should, because the review application is to recall the order written 17.2. But in that way, my lords, yes, the impugned order suffered the lacunae. But my lords, end of the day, my lords, in looking at the justice is concerned, lords, application filing by them. If this application has been, let us assume for an argument's sake, if this court issues the summons to the general.
No, but there is a difficulty. While reviewing an order, the reasoning of it would be different. While allowing a petition on the face of it is a altogether a different aspect.
Please.
So court has to give the reason why it is reviewing
It
its
has given
order.
the reason.
No,
The
no.
impugned order,
Earlier, why it allowed and why it has now reviewed.
lords, earlier, that is what my side. My lords, if my lords come to page number 128, according to me, my lords, if the page number is for subject to corrections.
Hmm.
The impugned order which has been passed on
Page number
17 to
128.
20. My lord, this order has been passed on the first round with the calling cases. If my lords look the impugned order, heard on IA number 18 to 21, as the counsel for the petitioner intended to examine the witness and also to summon the document in the application are hereby allowed. Objection filed by the respondent that is entitled to produce all the documents. But the very next day, the order sheet has not been produced here, but have the order sheet.
No,
Yes.
in the order impugned, what is the reasoning given by the court?
My lords, if my lords, please come to reasoning according to me, my lords, in my page number is 133. Subject to corrections, my lord.
Yes, para number?
Para number 6, my lords,
Yes.
the application starts, may I read, my lord, if my lords permit me? Or shall I take my lords to the page 134 in the same para?
Impugned order.
In spite of the same, when the case is set down for the cross-examination or order be won, he comes up with his
No,
application.
please point out at the finding, where did the court say that in view of so and so reasons, the court is reviewing its order?
That has not been found. I have to admit, my lords, I can't do. But the intention, my lords, the application, if my lords
Intention is
permit me, my lords, I'll
immediate.
pass on the order sheet. What had
Have
happened?
it.
Yes, if my lords, please come to the order sheet, which is at page, the dated. I'll just make that point, my lords. My lords rightly said, nowhere in the impugned order that word reviewing the order dated 72 has not been forthcoming. What I'll just point
The
out, my lords,
application
is-
filed under 114 so and
Yes,
so
yes, yes.
is hereby allowed and the order passed by this court on 17 to 2023 is stand recalled
Yes,
so as to hear afresh.
yes.
Where is that order?
Recalling the order, my lords. If my lords.
For that, no reasoning is required.
Yes.
Just like that, it will recall the order.
If my lords comes to order dated 24/2/2023, my lords,
24,
2/2023,
that's the impugned order.
not my lords.
2/2023.
The trial court, the record is
24,
2/2023. Shall I pass on?
Order date. 3/1.
I can make it easy, my lords. 17/2/2023 is the impugned order. The next day is 24/2/2023. My lords, I made a submission date, my lord, apparently on the face of the record, the application filed may not support in any way for both the parties, the summons which has been sought for. Then I made a submission, my lord, that I'm going to file my review application. On 1/3/2023.
They admit that they have filed.
I filed an application for review and the court has accepted and they have filed an objection. On 14/3/2023, the court has heard on the review application.
No.
After that, my lord, the
No,
court has
court
not.
has heard on the
Yes,
review application.
Yes.
No, the grounds for review, there are limited grounds for a review of the order. Where are they? No, in this,
No, I understood, my lord,
uh,
that lacuna, my lord, in passing that impugned order. The court should have said, my lord, my review application has been allowed, but considering this ground is concerned, that is not forthcoming. My lords. May I request, my lord, because by face on that, my lord, I can say, it may be remanded back, my lords, giving opportunity to hear the afresh on matter. The
That can
second
be.
ground is, my lords, matter being 2013.
it shall be disposed of within a period of,
2 months, my lords.
yes.
Great.
Okay, ಇದು expect ಮಾಡಿದ್ದೇನೆ.
Agreed with the orders passed in IA numbers 18 to 21 dated 3rd January 2024. The petitioner wife is before this court. Petitioner husband is before this court. The husband has the MC number 94 of 2013 is filed by the husband
Please.
seeking divorce on the ground of adultery. And the wife had filed MC number 6164 of 2017 seeking divorce on the ground of cruelty and desertion.
Please.
In that, and the matter is coming up for the cross-examination of the wife. The applications 18 to 21 are filed. Those applications are, where do you get that?
But, page number 89 is the application number 19, page number, according to my mother, because that is the page number what they are given. Page number 79 is IA number 80.
IA number 18 is filed to issue summons to the manager, Raj Mahal Vilas Hospital, Sanjay Nagar, Bangalore, to produce and speak regarding all the medical records pertaining to the wife, pertaining to the husband and respondent
Pertaining
number,
to the son of the petitioner.
pertaining to the son of the
Please.
petitioner. IA number 19 was pertaining to issuing summons to the witness in order to cross-examine them. IA number 20 was if issuing summons to the principal, Delhi Public School, Bangalore, to provide documents pertaining to their son. Then IA number 21 was pertaining to issue summons to the Attorney General of Chambers, Singapore, through the Advocate General of India to produce copy of Form 14A with all supporting documents being submitted by Bharati Ramraju, holder of Indian passport, for procuring visit visa to Singapore during 2019. Initially, these applications were heard by the court on 17/2/2023. But therein, the court has allowed the application on cost of ₹500 each by overruling the objections filed by the respondent. And it is observed that the party is entitled to produce all evidence available to him to prove his case. Thereafter, the present, the impugned order came to be passed, whereby all the applications that were filed by the husband, that is, IA numbers 18 to 21, are dismissed. Aggrieved thereby, the husband is before this court. Then counsel appearing for the husband submits that when the court, by order dated 17/2/2023, had dismissed had allowed the applications IA numbers 18 to 21. Now the court cannot pass an order dated 3rd January 2024. He submits that the court had no power to review its order. And the only remedy available is to file an appeal against the order. The court at best can recall the order. The land counsel appearing for the respondent by submits that. In fact, when the applications were allowed without giving any reasons, immediately the wife had filed IA under order 18 rule 17 and another application under order 18 rule 17 that is
So the
151.
two application has been filed by the petitions. I filed only the review.
The respondent is referring to the husband.
So petition is referring to the husband.
The husband had filed
Please.
two IAs under order 18 rule 17 along with documents, and the wife had filed an application under 114 to review the order. The court, by order dated 1/3/2023, observes that heard both applications for recall and protection of documents are allowed on cost of rupees 200 each. For objection to review application, call on 14/3/2024. Then on 26/7/2023, an order is passed whereby the application filed under section 114, read with section 151 CPC is allowed, and the order passed by the court on 17/2/2023 is stand recalled. So as to hear afresh the IA number 18 to IA number 21, the matter was directed to be listed on 28/7/2023. It is submitted with the land counsel that the court has every power to review its order, and the court had on an application filed by the applicant, that is the wife, had reviewed the order. It is submitted that on the face of it, the applications, that is I number 18 to 21, cannot be allowed. And while passing an order on 17/2/2023, the court had failed to give any reasoning, and realizing the mistake or the committed by the court, had reviewed its order. He submits that there is no bar for the court to review its own order. Next para, having heard the counsels on either side, the material on record. The report this court has called for a report from the learned judge, and a report is placed before the court. As per the same, an order is passed on 17/2/2023, and INs 18 to 21 are allowed. Then the wife had filed an application seeking review of the order. On 26/7/2023, the court has recalled its order. It says a wider separate order. There is no separate order.
because when my lord was dictating, I heard that my lord, the 17-2 order after filing a review application, the court has allowed that application and said that 17-2 order has been recalled. Now again, the matter has to set up to hear afresh. on the
Afresh.
order.
But
Yes,
even for recalling also, there is no order, just if recalled.
that is what they like.
What did you write? On? Court had recalled its order. And the court had posted the matters on 28/7/2023 to hear afresh I number 18 to I number 21 on merits. The manner in which the impugned order is passed and the procedure that is followed by the court is not in consonance with the provision, with the procedure. When an application is filed to review the order, then the court has to give reasons why why the order is reviewed. The court had recalled the order. Even for recalling the order, no reasons were given. Now the court had considered the same afresh. The procedure that is adopted by the court is unknown to law, and either on the first instance or on the second instance, for passing the order, for passing an order, there is no reasoning. For reviewing an order or recalling an order, there is no reasoning given by the court. Every order of the court should have the reasoning, and just like that, orders cannot be passed and also cannot be recalled. In that view of the matter, and also in the interest of substantial justice to both the parties. The order impugned dated so-and-so by so-and-so is set aside. Next, the court shall consider the application on the merits of it. The court should pass an order on the review petition on the merits of it. 3. This is the one MC is filed in the year 2013, and it's almost 11 years. Both the MCs shall be disposed of within 4 months from the date of receipt of the copy of the order. Both the parties shall not ask for unnecessary adjournments.
That's to hear on IA number 18 to 21 or to hear on to review to hear on.
It has to be, because it's already allowed.
Yes, so it has to be afresh on 18 to 20.
Not afresh. It should be on a review petition. What has happened to the review? When it has passed an order, why it is reviewing it? It should give reasons.
Please.
Disposed of.
Sale number 2. But for appellant, yes, Muslim.
I'm sorry on that day, my lord, passed over and subsequent to that,
Yes,
and earlier responded, was not there.
yes.
My respected petition before this honorable court that the suit, my lord, that is miscellaneous petition under section 92, read with section 71 of the Trust Act, has been filed before the, my lord, Chitradurga. As against, my lord, the.
What are these 2 appeals?
2 appeals. One is, my lord, order 1 rule 8 application, my lord, came to be rejected. And another appeal is order 39 rule 1 and 2.
No, let's see MFA.
MFA 9404 of 2012 as order as against order 1 rule 8.
Order 1 rule 8.
Yes, ma'am.
Hmm.
And another miscellaneous appeal, my lord, 9403 is as against order 39 rule 1 and 2. CPC.
Now first let us see the second one.
Second one is, my lord, 9403 of
Do
2.
that.
This is, my lord, the as against order 39.
Impugned order.
My lord, first matter we will take, because if I am succeeded in the order 1 rule 8, if this honorable court holds that the petition or plaint or miscellaneous, whatever called, that is miscellaneous petition that we have filed, that is as a procedure under section 92, along with order 1 rule 8,
with 39(1) and 2 CPC with 2 sets of my lord plaint which we have filed.
Please come to that order.
Okay, come, I'll see, I'll come to the order. Kindly see, my lord, in page number 51. This is order starts from, my lord, impugned order starts from, my lord, kindly see, impugned order at in page number 33. Order so and so, so and so, so and so, order 1, rule 8, read with section 151 of CPC, IA under order 39, rule 2. Then kindly come to, my lord, in page number 51. The ground in which, my lord, this is, my lord, I'll make submission insofar as petitioners are the devotee of the first respondent mutt. First respondent mutt is situated at Chitradurga, and it is a Veeraseva mutt, and that is, my lord, Veeraseva Lingayats mutt. That is this mutt has started in the year of 1917, my lord, and subsequent to that there are various Pitadipati. This is called Shunya Pita mutt. And this is, my lord, the propagating the Hindu religion, that is, so subcaste is, my lord, Veeraseva Lingayat. And, my lord, the first respondent established various education institutions, and, my lord, the medical college, and also, my lord, that the children's school and all these things that they have got education institution. There is a mutt. And this is huge property which is, my lord, devoted by the devotees. This is a public trust which is not in dispute. My respectful submission is before this honorable court that after, my lord, this present Pitadipati, my lord, with great respect to my learned friend, I can submit that after filing this suit, my lord, during the pendency of this appeal, various properties has been sold. Thereafter, the FOCSO case has been registered. Now his first respondent, Matadipati, is, my lord, is in jail under FOCSO case. And there is various allegations which is, my lord, made against him. And that is altogether different from the facts of the case. The lordship has to consider as to whether that I have, my lord, instituted the suit under section 92 along with the compliance is the question. Therefore, I'll draw your lordship's attention to in page number 51 of the order. In page number 51, para 32. Your lordship got it, my lord? The procedure followed. Can I read, my lord?
1 minute. Where is your application?
Application, my lord, which I'll draw this, and I'll application also has been.
Just to understand the case. First.
Yes, yes.
We come to the application.
Yes. Kindly see the application which is filed is, my lord, is at kindly see. Just a minute. The order sheet has been
At
filed.
127?
Yes, one second.
It is at 127?
Yes, yes, yes. Yes. 149, page 149.
What is this at 130?
Page 130. Page 130 is, my lord, miscellaneous petition.
Oh, that's what we will see. What is it? What is your case?
My case is, my lord, my respectful submission that, my lord, that there is a misappropriation of fund. Various properties has been sold by the Pitadipati, and this is a public trust. And, my lord, since, my lord, we have sought various prayer. Kindly see in page number, my lord. Prayer in page number 139. Declare that in page number 139, prayer which is sought in the miscellaneous petition for declaration that the defendant is unfit and unsuitable to continue Pitadipati and to remove him from the place of Pitadhyaksha or Matadipati of the defendant for appointment of new.
All these mutts in the state are run by, they come under which purview?
Section 92.
No, they don't come under the charitable institutions. Charitable institutions.
Section 92 may kindly be seen. This is a public trust which is not in dispute. Therefore,
Yes, sir, for the understanding I'm asking,
please,
these won't come under the charitable institutions,
charitable institution only.
not under the endo, the.
No, no,
Karnataka
no. This is
Government and
private institution. This is private trust. Public trust, but not, my lord, comes under Mujurai department or government department, endowment. Kindly see, this is the prayer which we have sought. The prayer which we,
For the declaration that he is unfit and unsuitable to
yes.
continue as
Now,
Matrimonial.
by virtue of his act, my lord, the already it is declared, because, my lord, the subsequent, he was
Appointment on new Matadipati of defendant number
yes,
1.
first is, my lord, already decided. Now Basawaradhya has been appointed by virtue of criminal activities. Then, my lord, for framing scheme, proper
Yes, I've
administration.
seen that.
Yes.
Hmm.
Then, my lord, along with this, my lord, that we have schedule may kindly be seen. He has sold various numbers, various properties of mud, and separate paperwork has been filed to show that, my lord, this is the public property which has been sold by the mud. Even though having a source of, my lord, 10 crores per month, my lord, because various institutions are there, my lord.
All these properties are sold from which year to which year?
There are so many, my lord, paperwork which you have produced. This is, my lord, from 2009 onwards, my lord, that's sold, and we have filed all the sale deeds, and defendants are.
2009 to which, from which year to which
I'll,
year?
I'll show, because, my lord, that I have seen so many documents which is placed. This is, my lord,
You must have stated in your plaint also.
yes,
From where it started.
plain. Yes,
That is your miscellaneous petition.
yes.
You said about, I think, 2009 to.
Yes, I'll.
So from 2009 till you file the suit.
Yes.
Hmm.
The various properties which is sold, and the document is, that is not in dispute before this honorable court. At
Yes,
this point.
that is the prayer. Then now come to the application. That is
Yes.
IA.
My respectful submission is, my lord, yes, I'll show your lordships too.
First is IA number 2.
IA number 2. That's order 1, rule 8. Kindly seeing page number 149. For the reasons sworn in the accompanying of affixed affidavit, it's humbly pray this honorable court may be pleased to kindly pleased to grant leave to the applicant plaintiffs to file annexed suit in the case in the interest of justice. This is, my lord, the application which is filed. My lord, kindly affidavit also supported in that case. My lord, kindly see next, my lord, order sheet which is produced. I'll bring your lordship's notice to the order sheet, which is, my lord, typed by the court, which is, my lord, immediately after filing the case, because they can't dispute now. Kindly take ink page number 114. 114 may kindly be seen. Can I make service? 114 order sheet. Along with, my lord, the miscellaneous petition under section 92 read with 73 of the Trust Act, my lord, that has been registered as miscellaneous petition, and IA also has been numbered, and subsequent 2 set of plaint has been, my lord, submitted along with memo to the court, which is not in dispute. Kindly see the operative portion of the order. ink page number 32. Ink page number, sorry, 51, para 32. The operative portion of the order. Before that, my lord, this miscellaneous petition along with IA 192 came to be filed before the district judge. For 2 years after issuance of the notice, this application has not been considered by the trial court. Then, my lord, I have approached this honorable court and filed a writ petition. Operative portion of the order is at ink page number 187.
When was it registered as a public trust?
This is registered, my lord, in the year of 1972. And my lord, thereafterwards, once again amended in the year of 2010. That is not a
Is that the trust deed is dated 29/6/1973.
73.
Creating a trust for all the affairs and properties of the mutt and its aim and objects, and created an absolute power in favor of the Peethadipati of the mutt.
That is, my lord, the 2010 that they are saying. This is the,
73.
please, my lord.
1973, they are saying that.
Yeah, no, 1973, that is not the Peethadipati, that is amendment has been made after coming to this. Swami, if at all that is required, my lord, that trust deed, we will place.
Whole issue, whether it's a public trust or not.
That is not in dispute at all.
They're not, they are disputing it.
No, my lord, insofar as the
Their
public
objection-
trust is concerned, they are not disputing that.
Come to the objections filed by them.
That is our first objection.
Yes, my lord.
At para number 8.
Para number 8, yes. Then, my lord, the trust deed has to be seen by your lordship, and these properties, they have to place before this honorable court the accumulation of the property, whether that independent source, and all these things has to be decided. It is a pure public trust, and there is no iota. We will place that trust deed also before, if your lordship is going to on merits.
Now, please come to the order. By the
Order, I'll come.
I report, I
See the
dismiss-
ink page number 32. 32 is the important.
Yeah.
32, para 32, ink page number 51. From that, my lord, starts. The procedure to be followed by the petitioner to file suit. Your lordship got 32, ink page number 51, para 32, internal para. The procedure following by the petitioner to file suit when the relief comes under section 92, then they have to come up with the independent separate application under section 92 CPC, setting up the fulfillment of ingredients mentioned in section 92 to file application, thereby seeking leave or permission of the court to institute the suit. Then such application filed under section 92 of CPC has to be accompanied with the plain. Meaning thereby the main application filed under section 92 CPC at outset will be registered as miscellaneous case. For an argument's sake, the miscellaneous application filed under section 92 CPC, if the leave of the court granted or permission granted, then the plaint which is accompanied will be registered as original suit. I'll make this point clear at this point. Then my lord, come to page 55. Reason for dismissal. Page 37. This is the procedure which they are saying, which is followed by me. Kindly come to ink page number 55, para 37. Then finding has been given. This is, my lord, procedure has been initiated. Then, my lord, finding has been given in ink page number, my lord, 55. para 37.
On technicalities, it is dismissed.
Yes. My respectful submission is this court, my lord. Para 37 says, my lord, that yes, they have filed plaint, then that is also there in the original record has been called for. That is in page, my lord. The plaint which is filed is, my lord, your lordship's record, trial court records, my lord, in page number 271 to 284, that plaint along with memo filed is there available. This honorable court earlier directed to produce that, then I have verified in the order sheet and original records that is available. Page also that I am giving. My respect to kindly see in page number 37, my lord, that is clear that on technical basis, my lord, the leave has not been granted by virtue of rejection of order 1 rule 8. Rest of the things has been, my lord, rejected. Kindly see this honorable court, my lord, time and then held by referring the Supreme Court decisions. The on technicality, section 92 suit, the court has to look into only whether we have filed and whether prima facie the case is made out. Kindly see, then, my lord, I'll come to the points, the facts of the case. That is ILR 1992 Karnataka 549. Section 92, your lordship got page 2 of my compilation.
Yes.
The section 92 does not confine itself to the parties to the application. It applies to the entire management of the trust, which shall be binding all the people. Thereby, in very concept of the application under section 92 CPC, there is no necessity of invoking order 1 rule 8 of CPC. All these suits under section 92 CPC are representative capacity. And that being so, the scope under order 1 rule 8 is not called for. Then, my lord, kindly see para 8 and 9, which, my lord, clearly stipulates that if the court comes to conclusion prima facie, the technical aspect cannot be considered. My lord, kindly see para 6. Para 6 in page number 4. My respectful submission is, yes, there is no dispute regarding 2 set of plaint which is filed, which is available on record. The learned judge says that 2 sets is not as on the date of the
Para 6.
para 6. A perusal of section 92 makes it clear that entertainment of application under section 92, the respondent should be charitable institution or religious institution, and the persons who move the application must have interest in the trust and must have obtained the leave of the court, or such application can be moved by the Advocate General once leave granted. And after inquiry, the court are entitled to grant any relief which under section 6. One more, section 92 does not confine itself to the parties to the application. It applies to the entire management of the trust, which shall be binding on all the people. Thereby, in the very concept of the application under section 92 CPC, there is no necessary invoking order 1 rule 8 of CPC. This review affirmed by division bench judgment of the Mumbai High Court, reported year 1941 Mumbai to so and so and so and so held. My respectful submission is, I have, despite of that, I have made application. I am not saying that even I have made an application on technical ground, it is rejected. And, my lord, your lordship can remind the matter. And, my lord, consider as on the date of passing of the order, whether 2 sets of, my lord, plaint is available. That's all to be considered. Insofar as under order 39 rule 1 and 2, by virtue of dismissal of, my lord, this application, my lord, came to be rejected. Therefore, this is the only crux of the issue, is whether, my lord, procedure, technical procedure is followed. Then, my lord, kindly see next document, the next judgment. That is, my lord, MFA 100/2007, page 9. Page 9. Section 92, leave to sue. Prima facie case of breach of trust, whether made out. The court is not required to embark upon detail of examination of material as if it is examination evidence. Maintainability suit under section CPC depend upon the allegation in the plaint. Specific allegation is made, mortgage is created subject to so into mortgage without taking necessary permission of the court. Prima facie case breach of trust is made out. Leave can be granted. The court ought to have, my lord, consider whether I have made prima facie case, document has been produced, and all these things has to be considered. But court has considered technical issue. Then, my lord, kindly see in the same judgment, my lord, the court has considered para 16, elaborately discussed as to whether the order 1 rule 8 is to be considered, or, my lord, the prima facie has to be considered, whether technical aspect has to be considered, has been elaborately discussed, my lord, which finding has been given in para 16. 17 also. Can I read that, my lord? My lord, another judgment decision, my lord, that I have quoted, my lord, in the compilation, ILR 99 Karnataka 20, that is in page number 5 of compilation. The plaintiff member of the unregistered club was issued with notice for non-payment of bills. Remanded subsequent to remove from the membership of non-payment for non-necessary parties, suit for declaration, permanent injunction, dismissed, held. Technical must not interfere with justice. The plaintiff must be given an opportunity to remove difficulties and remind the matter for fresh consideration. My lord, this is as, my lord, prima facie, my lord, before this honorable court on technical issues, it is rejected. And, my lord, on merits, my lord, if your lordship reminded the matter, my learned friend also will be offered opportunity, and let them consider all prima facie case as per the decision, and, my lord, pass appropriate order on merits.
What do you say?
The outside, but the allegation made by
No, we are not at the stage of considering the allegations.
no,
No, it's for the court to no, let's not go,
because-
court is not going into all that.
not at the first instance, my lord, the argument was commenced by stating that the Matadipati is now.
That's not relevant for this application, and the court is also.
I'm withdrawing that argument.
Court is also
Even, my
not
lord,
considering.
the allegation is made against the chief minister of the state now. By the other parties, my lord, which my lords are aware. That doesn't mean, my lord, that the chief minister is held guilty as of now. No, he is still under consideration.
But
It has to be done.
as on today, as against charge sheet has not been filed.
Yes.
My respect, first, as against first response, charge sheet has been filed, trial is going on.
Yes, I will face the trial. That is a separate aspect altogether. Now, my lord, insofar as the present application is concerned, kindly see, my lord, the paperwork what has been given to me. Kindly turn to the order sheet maintained by the trial court. First day's order. Lord, the page 81 is what has been
Mr.
given.
Counsel, before you proceed with the matter,
Please.
no, they have filed a petition before the court, miscellaneous petition, and they need to have the leave of the court. No, if some technicalities are there, the court should tell them to comply with it. On that ground, the court cannot dismiss it. Now, unless and until a leave is granted, they cannot come up with all these interlocutory applications for injunction and all. The court was right on that point. Now, we will remand this matter, and if it is in accordance with law, it shall be considered by the court, notwithstanding all these technicalities, without going into any of these aspects.
My lord, that is there, my lord, but still, I have 2 points, my lord, to be made on how, my lord, the petitions came to be filed and how they are, my lord, the petitioners are at loggerheads with this Matadipati.
But that is true. No,
Yes.
but that is not the scope of this petition.
Yes, yes, I understand.
So unnecessarily, instead of burdening the court with all that, now the simple issue is, now their application under order 1 rule 8 is dismissed.
No, I'm guarded, my lord, with the judgment of the Honorable Apex Court in saying that while appreciating a petition under section 92, that is suit under section 92, prerequisite condition is that leave of these
Court is required.
is required. Only then, my lord, all other.
No, the court has not granted the leave, not refused to give the leave, but it said not on the merits of it, on some technicality,
That technical reasons, my lord, is on their own fault.
which
It is
can
not-
always be rectified when
Yes,
it
my
is
lord.
not a, it is not a personal interest, when it is in a public
I
interest.
will show, my lord, that is their personal interest. I will show, my lord. to the
You
court.
show it to the trial court.
My lord, prima facie here, my lord, it is of the year 2012, my lord, now it has been heard.
What to do, that's done.
Yes,
Even after continuous insistence of this court, now it is being
Yes.
heard today.
Yes,
So we will do it.
yes, my lord.
Because you will have, there are hierarchy of courts where it has to be done, it has to be done. Let the trial court take a call and you appear before the trial court. And whatever you want to submit, you submit.
Yes, my lord.
Let the
Before-
trial court consider all that.
Yes, my lord. Before that, my lord, I will read only two points, my lord, and then my lords may kindly turn to page 122, my lord, of the.
You filed your objections before the trial court.
I will do.
You have, no, you have already filed. And the trial court, while giving permission, that's where the court's discretion is. Whether it is a public interest or in the interest of a public trust, or it is their personal interest, all that you place before the court. I'll direct the court to consider all that, because it is, no, even if you tell the court and the court is convinced, the court cannot do anything right now. Because that's not the reason why the court had dismissed it. Had the court allowed their application, then I can hear all that, what you are saying, but not at this stage.
No, my lord, I understand that, my lord, but even, my lord, while stepping into the court, not first thing, my lord, as normally to be done, not the miscellaneous petition is to be filed, accompanied by the plaintiff, my lord, is the normal procedure. What they do, my lord, is that, because already they have done it is on record, I will show that, my lord, 2 minutes. Kindly permit me to say that, my lord, for 2 minutes. Kindly turn to page 122.
You can tell the court, yes. Yes.
122, my lord, of the paper book, what has been given. It says on 29/6/2010, my lord, it's filed. Plaintiff under section 92, read with so-and-so is filed, and the relief sought for is done. Lord, the learned judge, along with that, my lord, 3 applications are filed. One, to take the petition on board. Second, my lord, under order 1, rule 8, to seek leave of the court to file the issue. And then application order that no loan. Then the court's order is this: peruse the materials on record and the section 92 of CPC and section 91 of the Trust Act, as per the memo filed by the plaintiff. Since the matter is to be heard as the nature of this relief sought for and the maintainability of the suit in the forum which is placed before the court, office to register this case as civil miscellaneous for present, issue notice to the defendants on IN number 2 and 3. Lord, we were served with the notice on IN number 2 and 3. But then there is a amendment carried out by the plaintiffs themselves, striking off the OS as miscellaneous, and it is numbered as 115/2010. When, my lord, this is a miscellaneous petition and the application is filed, my lord, the matter went on, my lord, to be heard by the learned judge. During the course of the hearing, Lord, at a stage when the objections are raised by us stating that it is not in the form or the prescription as under section 92, they come up with 2 sets of plaint along with the memo after 2 years of filing of this petition. So, my lord, on that ground technicalities, my lord, the application is rejected. That is what, my lord, it has been reasoned by the trial court. And in filing the application under order 1 rule 8, which was not the necessity because it was not a representative suit to be filed under order 1 rule 8. It's a suit under section 92. Independently, leave is to be sought by the court. It is their own thing. They have filed that under order 1 rule 2. Then there is a that the learned judge repeatedly refers to a ballpoint mentioning of 92(1) that is inserted subsequently without the leave of the court. This is the manner in which, my lord, they have presented and acted with the court.
So what are you doing from 2012 till 2024?
Kindly see, my lord,
With
kindly
this-
see inquiry number.
No, with this MFA.
No, we have approached, the court has not, my lord, heard the matter.
Look,
No,
let
this-
us- let
this-
us see
this
the- Let
MFA.
us see the docket proceeding.
This, my lord, that argued before 2-3, my lord, presiding officers. And, my lord, subsequent to that, there is some office objections, my lord, that is, my lord, 104 section D has raised and amendment has been sought for. Kindly see in page number 187. We have approached this honorable court in earlier occasion. That not because of my fault, that not that I have not argued.
Till 11/7/2017, steps were not complete. You have not taken
Yes,
steps.
there are several defendants, my lord, steps has been taken. There are several, my lord, owners because they are the parties who have purchased property from the first defendants are the party.
Not, yes, you have not furnished the peer. It has been adjourned from time to time. That's what the docket shows. The order shows.
Even now, they are not served probably, my lord, if I'm right.
No, all of them they have served, then that steps has been taken and ultimately that
For the first time in 2018, you have come up with a petition for substituted surveys.
yes. Because there are about 10, 19 different defendants. And earlier occasion, my lord, that not that, my lord, inquiry number 1, we have approached this honorable court and we have sought, my lord, the direction to consider my application also. That not that I am not vigilant or, my lord, the plaintiffs are not hurried to get it the justice to the general public. We have approached earlier occasion before this court. And this honorable court was directed trial court to consider application. Suddenly, my lord, on technical issue, it is rejected. Inquiry number 187 may kindly be seen. This honorable court was pleased to direct it. Apart from that, my lord, that
What the relief that you sought in 2024, does it remain to be the same in from 2012 to 2024?
yes, well, because, my lord, insofar as property which is, my lord, this honorable court granted interim order not to create third-party interest in respect of the property. And, my lord, the Pitadipati first prayer may, my lord, has to be considered. Otherwise, rest of the things, my lord, has to be considered.
As framed by you, the plaint, no, as of now,
Please.
the relief, all the relief that you are seeking may not be the same.
But, my lord, in the case, my lord, my respectful submission is that. In case, my lord, that is altogether.
No, we'll do you file a separate suit now.
No, my lord, because, my lord, already this, my lord, only technical issues. Again, new procedures.
So when
Because,
the-
my lord,
But the
what
petition itself is not granted to you. Where is the question of granting an interim order?
no, my lord, my order 39-192, my lord, insofar as, my lord,
No. This court,
this court, my lord, granted interim order not to create third-party interest in respect of property, initial stage when we have filed, and thereafterwards process has been taken. Kindly see the order sheet. That,
prerequisite.
my lord, all these way, my lord.
A prerequisite under section 92 is the permission of the court.
Yes,
Unless and until there is a permission of the court, you cannot maintain a suit.
yes.
Unless that permission is granted, question of granting any interim order or any further orders would not arise.
Yes.
Now, your case is at the stage of that permission itself, which was not granted by the court.
Yes. But, my lord, insofar as, my lord, all the step notice was issued, 2 years has elapsed to serve notice there, and then, my lord, this application considered. No, my lord, the advocates on record are there in the suit. And, my lord, to consider my IA on merits. That's all, my lord, I am saying, if at all.
If all your intention is only that to protect the properties, what will have, if whatever is a new cause of action and all the other things, what has happened from the last
My lord,
2012 to 2024?
But
You can as well.
But this honorable court has protected, insofar as, my lord, selling of these suit scheduled properties is protected by virtue of an interim order. Apart from that, my lord, that all the process has been done and this appeal is pending.
We cannot pass such an order where your permission itself, no, whether the court has to decide.
No, my
whether
lord, on
this
technical
litigation-
issue, on technical.
whether this litigation, not technical issue, then where is the appreciation on the merits of it? No, they have also raised several grounds with regard to your bona fides and filing this petition.
No, I'll establish, if your lordship hearing on merits, my lord, I'll produce trust deed, whether it's a public prima facie, if I am able to, I'll establish, then, my lord, kindly see the documents which paper book which you have produced, whether it is a charitable trust or whether it's a public trust, all these things, my lord, your lordship can hear on whether on order 1 rule 8 itself, if so, my lord, required to hear.
Say that he should not be a Matadipati. No, he is not a Matadipati.
No, he is,
No,
but my respectful submission is, by virtue of criminal case, he has not been removed. This honorable court has appointed administrator, but if at all he
is not now, he is not a
he
Matadipati.
is not.
That's a principal prayer which you are seeking.
No, my respectful submission is he has not removed. He has not removed, but by virtue of criminal act, he is in jail. That's all. But he has not removed by virtue of, therefore, my lord, the first prayer, my lord, will be decided.
Tell the court what, because even if an interim order, this order this order will go. Even if the matter is remanded, this
Yes,
order
ma'am.
will go. It has
Yes.
to be decided independently.
Independent.
So what is the difficulty for you to institute a new suit?
My lord, I have, my lord, because this is a public trust. And my lord, all the way, my lord, that we have, my lord, interim order is operating till in this court.
So
No, my respectful submission, kindly, please hear me, because, my lord, I substantiate before this honorable court that insofar as technical issue is concerned, before your lordship, whether, my lord, those technical issues to be considered, that's all is there. If at all, my lord, your lordship is hearing on merits, this, because, my lord, another, I am a public, because, my lord, I am devotees of, I have no, my lord, I am not taking any income from the mutt, but I am devotee, donator, and all these things. If at all press exercise has been directed to me, once again that I have to make press exercise. Under those circumstances, on merits, let the trial court, what is the hurdle to them to consider on merits?
What is the exercise you have to do? Tell the court.
Please, my lord.
What is the exercise you have to do?
That once again, my lord, that we have to file a press petition, and once again, my lord, they will produce all these things. And apart from that, all these respondents, 19 respondent has been served, and now they are, by virtue of order that they have not sold. Then again, my lord, that notice has to be issued. Order 13 and 1 and all these things. Why press exercise? I am asking, my lord.
No, please come to your plaint. We will see what is the relief you sought.
Yes.
And what is
Please,
happening.
please,
and
please,
why it should be there.
please, with great respect to this court, my lord, that I can argue on merits, my lord, kindly.
Yes, please come.
Please. Prayer which we have sought in page number 127, Lord. Prayer.
Yes.
To declare that the second defendant is unfit and unsustainable to continue as Pitadipati, and to remove him from the place of Pitadhyaksha or Bhattadipati as the defendant. Defendant number 1. For appointment of new Pitadipati of defendant number. For framing scheme for the proper administration of defendant number
So
1.
A, B, C cannot be granted by the court under the changed circumstances.
No, because, my lord, can be granted, because, my lord, this is a different criminal issue is against them. And, my lord, by virtue of criminal, my lord, act, he is under the, my lord, custody, judicial custody. Apart from that, there is no order came to be passed by the court. This honorable court, because he is in jail, nobody is looking after the mutt. Therefore, court has appointed administrator.
Now, do you think that the learned judge will do something as long as the orders of the High Court with regard to the temporary arrangement or pending?
My lord, within 4 months, Supreme Court directed to complete the, my lord, entire the trial. That is there by virtue of Supreme Court direction. This honorable court, my lord, the division bench of this honorable court appointed a my lord, administrator for a time being. If he succeeds, my lord, all these issues to be decided. If he succeeds and my lord, convicted, my lord, then that is different issue. I am not saying that there are.
No, when the procedure is contemplated for a period of 2 years, why you did not comply with it? When a procedure is contemplated, how the plaint has to be
My
filed.
lord,
and-
here, then my lord, kindly see that one page which is the trial court record. Page 271, I have marked that. The court has said, my lord, admittedly, my lord, that I have produced that, and my lord, kindly see. The order itself speaks that I have, my lord, produced that in page number 27, but ball pen and it is mentioned, but the order sheet speaks that the provision that judge just simply said that there is a ball pen change. In his order itself, there is a changes in ball pen. No, I'll show that. Miscellaneous, OS has been made first, and then, my lord, it is a miscellaneous. That is no other changes. And the order sheet of the court itself, there is a correction, I'll show. I have not made correction after filing this. 2 set of plaint filed along with memo. before this honorable court earlier directed. And all these things let the trial court consider and pass orders. What is the problem with him to, my lord, once again argue before the trial court on merits? And there is if I am able to prima facie establish, then my lord, the court has to consider.
What are all these writings?
That all is right. Kindly see the order sheet, then my lord.
The order sheet, no, don't tell what is wrong, right and wrong with the court. When the court is asking what is this, you have to tell the court. At page number, what is this, the plaint, what are these written? When were they written?
This is, my lord, while filing itself, because that's, my lord, root district place. And, my lord, that is wrongly typed as OS. Then while filing itself, my lord, that they have made miscellaneous, while filing miscellaneous petition, which is while recording the order sheet itself, it is clearly stated that, my lord, the miscellaneous petition, a notice has been issued. Hogiri, pass over.
Please come.
Page 89 may kindly be seen for a moment.
Yes.
88. This is, my lord, order sheet. Order sheet I will show, which is written by the court itself. Certified copy which is obtained. Order sheet, my lord. This along with my complaint. Order sheet also I have produced.
Yes.
88, my lord.
Yes.
In the court of principal district judge, miscellaneous 115. This is typed by, my lord, the court order sheet, my lord. Here, 89, my lord, the plaint under section 92, section 17, CP 71 Trust Act in duplicate has been presented by BC Shivkumar advocate along with wakalat, valuation slip, verifying affidavit on 28/6/2010. The plaint praised judgment and decree as against the defendant. The declaration that the defendant so and so, this prayer has been typed. Then, my lord, list of documents has been processed memo, PF.
Yes, please come.
Therefore, my respectful submission is, my lord, let merits let it be considered. Because this is public interest litigation, and my lord, court has, this honorable court division bench has told clearly that on technical aspect it can, on merits, and Supreme Court judgment also referred while passing the order, which I have brought into the notice of this court, because once again, my lord, Supreme Court has referred on technical aspect, it cannot be rejected. And I have no personal interest.
Agreed by the,
Please, my lord.
agreed by the orders passed in miscellaneous number 115 of 2010, dated 29th, agreed with the orders passed in IA number
number 2.
My lord, para 16, 1 second, my lord, Supreme Court has clearly hold that on technical aspect. And my lord, that is page 16 of my compilation. The 3 judgment of Supreme Court has been referred, and on technical aspect, my lord, consider.
IA number 2 under order 1 rule 8 and another IA is
Order 39.
39 rule.
number
IA 3.
IA number
That is, my lord, connected appeal.
IA number 1 is IA number 2 and 3
Yes.
or 1 and what are the 2 IAs?
2 and 3.
2 and
IA
3.
number 2 under filed under order 1 rule 8 and IA number 3 filed under order 39 rule 1 and 2 CPC came to be dismissed by order dated 29th August 2020 to 2012. Agreed thereby the petitioner for the trial court is before this court. The facts of the case are The petitioners are the members of the Veerashaiva community. And they are the different devotees of the defendant number one mutt. They are interested in the upliftment, care, cause and title, cause and development of defendant number one mutt. It is a case that the Matadipati is misusing, managing, and misappropriating the funds and is not administering the mutt in a proper way. In the petition, they have stated about the properties that are sold by the Matadipati. According to them, there is no requirement to sell the properties. And they've given a list of the transactions and the properties that were sold. The relief that is sought by them is seeking a declaration that the second defendant is unfit and unsuitable to continue as Matadipati and to remove him from the place of Matadaksha or Matadipati of defendant number one. Number two, appointment of new Matadipati of defendant number one mutt. 3, for framing a scheme for proper administration of defendant number one mutt and its properties, including the suit scheduled properties. Next, 4, direct the defendants number 2 to render account of defendant number one mutt and its properties for declaration of the alienation made by the defendant number 2 in favor of defendant number 3 to 11 as null and void and not not binding on the first defendant mutt. The suitors, as it is, according to them, the trust is the mutt is a public, or registered as a public trust. As such, they have filed an application under order rule 8-9, or order 1 rule 8, seeking permission of the court, and also order 39, restraining the, what to do? Restraining?
The defendants from creating third party.
Restraining the Matadipati from creating third party rights. And Matadipati and other defendants from creating any further third party rights. The trial court, by order impugned, had dismissed both the IAs filed by the applicant. While dismissing the applications, the court has observed that miscellaneous number 115 of 2020 is an independent and separate application under section 92 CPC. Then it has to be accompanied with the plate. Apparently, miscellaneous number 115 of 2010 application, if it is considered as an application under section 92 CPC, it is not accompanied with plaint. Plaint that ought to have been filed along with the miscellaneous number 115 of 2010 on 28/6/2010 was filed on 25/8/2012. Belated filing the plaint cannot be construed that it is an accompanied plaint to miscellaneous number 115 of 2010. Then how the respondents could know the allegations that are going to be made in the plaint so that they could vindicate, agitate and argue on the application under section 92 CPC to the extent of taking grounds about its maintainability. This right which the respondents have got, that they could not vindicate it as the plaintiffs have not accompanied the application in miscellaneous number 115 of 2010 with the plaint. Therefore, when the application under section 92 CPC is not accompanied with the plaint, in case leave is granted, the plaint is going to be registered as original suit, then under that circumstances, even miscellaneous number 115 of 2010 is not maintainable. When miscellaneous number 115 of 2010 is not maintainable, then IA number 2, which is in the nature of interlocutory application, is also not maintainable. And accordingly, court had dismissed the application aggrieved thereby, they preferred appeal before this court in the year 2010. Initially, there was an order passed by the court directing the defendants not to create third-party rights,
Yes.
not to create third-party rights. Thereafter, the matter underwent several adjournments till 2019. The respondents are not served. Several times, the steps were not, the respondents, have, the appellants have sought time for taking steps. And finally, by way of a substituted service, the notice is served on the applicants, on the respondents. Next paragraph. Then counsel for the appellant petitioner submits that the trust is registered as a public trust. And on technicalities, the court had dismissed the petitions filed by the petitioners, appellants. It is submitted that when an application filed under section 92 stands on a different footing, and when it is when it is in the interest of, in the public interest, the court on technicalities cannot dismiss the petition. Learned counsel had relied on the judgments of this court and also the Honorable Apex Court. He had relied on Venkat Ramaya Setti versus Uttama, reported in ILR 1996 Karnataka 549. And he had relied on another judgment in case of P. Vishwanathan versus Bangalore Club and others, ILR 1999 Karnataka 2016, that technicalities must not interfere with justice, and the plaintiff must be given an opportunity to remove the deficiencies and remedies, and should be given an opportunity to remove the deficiencies. He had also relied on another judgment of this court in case of Professor M.S. Padmarajaya and others versus Commissioner Bangalore Mahanagar Palike and others, reported in ER Karnataka 2007, 6, AR Karnataka R1. Relying on these judgments, then counsel submits that this court as well as the Honorable Apex Court has consistently held that when a suit is filed under section 92 of the CPC, without going into the technicalities, courts have to consider the same independently and in the pursuit and in the interest of justice. It is submitted that when the vast properties of the mud were disposed of, were alienated, and there is a clear misappropriation of funds. It's an issue of concern with regard to the files of the mud, and all those aspects were not considered by the court, and mechanically on a technical aspect, it is dismissed. And it is submitted that the order may be set aside and the matter may be remanded to the trial court. The trial court may be directed to decide the case on the merits of it. Next paragraph. Learned counsel appearing for the respondent for the respondent, defendant Mutt, for the respondent, not defendant, the respondent Mutt submits that when I call along with the miscellaneous petition, when they have to file the plaint, when along with the suit, the same was filed in the year 2000, the suit is in the year 2010, and the application is filed in the year 2012. The court had rightly observed in the order that unless and until the plaint is filed along with the miscellaneous petition, and unless and until the same is, when the notice is ordered, unless and until the defendant is aware of what are the allegations that are made against the defendant, he would not be in a position to controvert the same. He submits that whether when if there are any bona fides on the part of the appellants herein, they would have filed the application, filed the plaint along with the miscellaneous application in the year 2010 itself. According to the land council, there are, in view of the disputes or rather as the appellants or at loggerheads with the defendant, they have come up with this suit, with this petition only for only to settle their personal scores. And there is no public interest involved in this. He submits that at this point of time, after 10 years, remanding the matter, after more than 10 years, 12 years, remanding the matter would not serve the purpose, and the appeal liable to be dismissed. Expert, having heard the land counsels on either side, peruse the entire material on record. The miscellaneous petition is filed under section 92 of the Act, raising several allegations against the defendant trust and the misappropriations that are made by the Matajpati. The suit is filed in the year 2010. Nobody can dispute the fact that what is the procedure contemplated under section 92 of the Act. In this case, it is also an admitted fact that the plaint is filed along with plaint is filed in the year 2012, and the suit is filed in the year 2010. The prerequisite for maintaining the suit under section 92 of the CPC is it should be a public trust, and they should make out a prima facie case, and basing on the same, the court would grant permission to the leave, will grant leave to the applicant to pursue the suit. When a suit under section 92 of the CPC is of a suit of a special nature, which is for more of a public cause, the court, as it is settled by the by catenary of judgments of this court and the Honorable Apex Court, the court ought not to have dismissed it on more on a technical grounds. if in any of the, if there are any technicalities which were not complied with by the plaintiff as well, the court could have granted permission to the party to comply with the same, and ought to have considered it in the light of section 19 or 2 of the act. Whether it is a public trust, a defendant is a public trust, whether the plaintiff had made out a prima facie case, those should have been the considerations of the court. The remaining technical aspects would always be rectified when if the plaintiff is given permission to do so. Unfortunately, a suit that is filed, a petition that is filed alleging misappropriation in the year 2010 is pending before this court till 2024. Right from that date till now, much water has flown. If at all, the kind of allegations that are made by the appellant herein against the defendant are true, it would have caused much loss to the mud and to the public trust. Right, in these 12 years, all these things are of a matter of concern. Coming to the scope and ambit of this appeal and the petition filed by them. In the considered opinion of the court, the trial court had went on more on technicality and dismissed this application. Dismissed the petitions. The court, now you are compared with the plaintiff is now there on record.
That is what the record findings recorded, not after 2 years.
No, it is there. There is no dispute that as of now, as on 2012, the plaintiff is there on record. You have filed your objections after the plaintiff is filed? You have not.
Yes. After plaintiff applied, they have filed objection.
You have not filed the written statement.
Only with the
Objections, application has been filed.
Because allegations you will know from the plaintiff.
As on the date of the order, everything complied.
It is submitted that the objections are filed. If the objections are not filed, the defendant shall be given an opportunity to file the objections, and after considering whether there is a prima facie case in favor of the applicant, then the court shall consider, basing on that, the leave shall be, the court can grant the leave, and thereafter, the other applications that are filed by the applicants shall be considered by the court. In that view of the matter, the order impugned before this court is set aside, and the court shall hear this matter and decide the suit itself as expeditiously as possible.
In view of this, another appeal also maybe
In the light of same, both are there.
connected, correct.
So
Much.
accordingly, both appeals are disposed of.
Much.
Not this suit.
Not the suit, miscellaneous application.
Much.
Suit and
No, miscellaneous application. Yes, next.
Till number 3,
But I represent the petitioner.
Engineer VR.
Yes. What is this matter?
But the petitioner is the husband of the respondent.
Hmm.
That the respondent had filed a petition seeking restitution of conjugal rights against the petitioner, which came to be allowed. That against which, my lord, the respondent has filed execution petition before the family court seeking execution of the restitution of conjugal rights.
What is he? What is the husband?
That he is a meter reader in Bescom.
Then what happened to that?
But now, my lord, NBW has been issued against the petitioner hearing. But that order has been challenged by the present petitioner.
my lords finds the,
So what is wrong with it?
my lord, at one stretch, my lord, she wants the husband to lead the life with her. At another stretch, my lord, she alleges that the husband and his relatives are harassing her for dowry.
No, no. As far as this petition is concerned,
Please,
so the court has issued NBWs.
please,
When it can be executed because you're an employee,
please.
when you're not honored the restitution.
On the earlier occasion, my lord, his salary attachment warrant was issued,
Hmm.
which could not be executed by them.
Hmm.
Thereafter, my lord, they had sought for issuance of NBW against the petitioner herein, and the court below has issued NBW against him. Earlier, salary attachment warrant of the petitioner was issued. My lords may kindly finds it at page number 21, my lord. Page number 21, typed copy of the order sheet.
The-
Order sheet
Read
dated
from the-
29/8/2018,
Read from the reasons.
please. But there is no reasoning in this.
Let's see.
This is only an order sheet which is maintained by the,
No, page number 29.
please, my lord. The evidence of PW1 adduced through affidavit as
You
well as,
filed any petition for divorce?
no, my lord, no, my lord.
So you will not file for, you don't want divorce, you don't want to stay with the wife.
A dowry harassment complaint is filed, which got referred for police to
Then you have you
investigate,
questioned that restitution order.
my lord, which was challenged before this honorable court in MFA.
What has happened to that?
My lord, that came to be withdrawn. That
Hmm.
came
Then-
to be, that came to be withdrawn.
You can't have all the.
My lord, at one stretch, my lord, she wants her husband to lead the life. At
Did you
another
appear
stretch,
before the court?
Lord, before to passing of,
No, did you appear before the court?
no, my lord, I have
Then
not appeared. I have not
You
appeared.
don't appear, you don't do anything,
Even not
you
filed
file
application.
you file appeal, you get, yes.
Even not filed any application for recalling the order before the trial court, my lord. Because it is maintenance amount, my lord,
Even, my
execution
lord,
has been
if the
filed.
NBW is executed against the petitioner and if he is kept in prison, but the purpose will not be served.
No, it is not
Purpose of, the
that.
purpose of the judgment and decree
Why
passed by
the
the,
salary could not be recovered?
Yes, my lord, definitely it will require. My lord,
Huh?
but because this order has been questioned before this honorable court and they have filed memo stating that the writ petition is pending, therefore could not able to get.
No, it is not that. He says that an application is filed for recovery, you can, why you want this arrest?
Because my lord, I have filed the execution, NBW has been issued. There is no any wrong in that. FLW has to
Appear before the
issue.
court,
please, my lord, we will appear.
appear before the court.
Let
Yes,
impugn
my lord,
order
that
may
is
kindly be
better.
quashed, my lord. I will appear before the court and
No, what we'll say is, we'll pass an order now saying that you, when is it posted?
I am not aware, my lord, because long matter.
this honorable court had stayed the further proceedings, my lord. Under that circumstance, it is
Yes,
being adjourned.
therefore, my lord, it
So
has.
we'll modify that order.
Please,
We'll modify, we'll
Please.
see, you appear, and then we will close this.
please.
And with the payment, my lord, payment kindly may be ordered, my lord.
What payment?
That payment is withheld by virtue of stay order, my lord.
Which is the payment? How much
The-
is that?
Because my lord, interim maintenance continuously available to her. That is not paid by him.
That is a different proceedings, my lord.
No,
They have to
you are
update
not
it.
paying that also.
But
Yes.
it's a different proceedings.
No, it is not different proceedings. A
This
party.
execution
You
petition is
cannot-
only
let it
filed.
let it be a different proceeding between the parties, and that too in a matrimonial matter of this nature. You cannot take advantage of, because that is other
But
proceeding.
I
this is
don't have
non-proceeding.
instructions whether they have.
Please
filed.
ask your client, let us understand. It can't go on like this.
Yes.
You don't, now, in one order passed by the court, you don't obey that. And in the other way, you want orders from this court.
But in fact,
all-
my lord, against the
it's
restitution
about-
of conjugal rights judgment and appeal was
Litigant cannot
preferred.
be permitted to play with the process of the court. Please get instructions from your client. What is the state of affairs?
Please.
Why were you not present, Mr. Counsel, for respondents? Finally, you have come today.
Yeah, my humble request, my lord, the last.
2-3 occasions you are not there.
Yes, my lord, last.
Yes. When do you want?
Next week, my lord, any date.
Pose this matter on 29th August.
Till then interim order may kindly be.
interim order earlier granted is extended. Come up with some positive,
please,
this thing. Otherwise,
please.
tell your client that it will be confirmed, this order
Please.
of the trial court. Yes.
For appellant. Chip, man, kindly permit to withdraw them.
Rajendra Prasad.
Take that.
Liberty may be granted, your lords. Suit valuation is below 10 lakhs, your lords.
That you should have understood by the date of filing, and you wait till from 2023 to 2024
Sorry.
for filing this memo.
Sorry.
The office has raised the maintainability of this appeal as the, what is this? As the appeal do not lie to this court. The memo is filed seeking to withdraw the writ petition with the liberty to approach the appropriate court. Considering the memo is taken on record and considering the reasons stated, the appeal is dismissed as withdrawn with the liberty to move, with the liberty to move the appropriate court. Registry is directed to return all the records to the petition.
Cell number 5,
Please.
Kiran Gowda M. For appellant, S.J. Kumar.
Well, senior counsel is on his way. Let the other side start once.
Yes, pass over. Yes, next 7.
Cell number 6, Adjournment 7. Somnath, Deepa J.
My lord, a memo along with the list of documents was served upon us yesterday, my lord. A week's time may kindly be granted to
What are the
examine.
memos?
Those documents are assets and liability. It was their duty to submit assets and liabilities in the writ petition. They had not done that. What was in the trial court, I submitted again. That's it. They are trying to say for that sake that if they want to take date, I'm okay with it, but not for this reason.
They want a reason.
For a week's time may be granted.
Why?
My lord,
Interim order in your favor,
no, my lord, it's a preliminary
no
here.
interim
It's
order.
coming for the first time.
post this matter.
29th.
Let it be on 10th of September,
It is
10th of September.
much obliged.
Cell number
Yes,
8,
At the request of land counsel for the petitioner in 21834 of 24. Yes, next.
Ma'am, both the matters.
Both the matters.
That
they are-
is, request is whose? Yes.
cell number 8,
Kindly pass
Prasad
over.
Payas,
Seen held up in another court.
Anil R.
Mhm.
for rest-
Kindly pass over.
We pass over again if you,
Every day this is becoming this is a process every day. Ask him to come. Yes.
Cell number 9. Somsekhar KM. For appellant.
Kindly pass over.
No, everybody needs wants a Passover. Yes, Passover.
Cell number 10. S.A. Sudhindra for appellant.
This matter, my lords. Last occasion, my lords, your honors had directed the parties to be present. My party is from my lords. The other side.
What is that? Let's see.
Cell number
There is a counsel for the respondent. There is scope for settlement.
Yes, my lords. No,
Where
that
did
is-
the court ask them to appear?
Today, my lords.
No, there is no such order.
No, my lords, last occasion I made a submission that any settlements are. My lords, the dispute is, my lords, now they have squatted on the property and they have made a construction. Subsequently, they have filed an affidavit. Only ground floor was required to be constructed. The one more tank room is there. For that reason, I made a submission of violation of interim order. Subsequently, I requested them, anyway, you have made a construction. I don't mind any disturbing you, provided let there be some settlement. Now, my lords, I have surveyed the property. My 12 by 48 square feet, they have objected my property. So they already constructed. For that reason, any settlement is, let they propose any settlement. For that
Where
reason,
is
I
the counsel?
not come, my lords, today. Last occasion, they themselves made a submission that will make the parties
The
to be present.
respondent party.
respondent.
Where is
both
the
are not-
advocate asked?
No, my lords, he is my party,
Where is the?
appellant. He is the
he's not-
appellant. Respondent has not come. Neither the party nor the advocate are come before this court.
Inform him, will pass off.
Please, ma'am.
Yes.
Till number 11.
That the Passover matter you call, they are there. Earlier matter, this 8 and 8.1.
8 CJ, number 8. Till Prasad Payas.
How many times this matter is heard by the court?
My lord, the last time, my lord, the adjourned,
This time we will not adjourn. Whatever it is now, right now I'll pass the order.
No, last time, my lord, I paid a check, posted a check for the 14th. My learned friend said the check
what
will
has
not clear,
happened? That
the
is,
check has been cleared, my lord.
Is it clear? Now, then what is, tell me the details of the amounts.
My lord,
What is the amount granted by the trial court
trial court, my lord, has granted amount of rupees 17,000, my lord.
per month?
12,000 for the minor, 5,000 for the minor and 12,000 for the mother. So before this honorable court, my lord.
1 minute. Now, what is the date of that application for maintenance?
Application for maintenance, my lord, was filed. That annexure. And they has filed the petition, only that application was filed, my lord.
Do you have the date?
Yeah, it's filed, my lord, on 23/5/2022.
23/5.
2022.
When is the interim order by this court?
This court has granted the interim order on 18/11/2023.
Granting how much?
50,000, this honorable court called upon me to pay 50,000, my lord. Interim order was granted. Thereafter, my lords have heard this matter and called upon me to pay how much I'm going to pay. So I submitted, my lord, I'm going to pay 5,000 to the minor child, what was ordered by the court. So far as the mother is concerned, I'll pay 3,000. At the rate of 8,000, my lord, this honorable court directed me to pay the entire arrears.
So right from the petition.
Right from the petition.
So, like from it's 8,000, when is, you said the petition is on 23/5/2022.
Yes.
Then it is,
So my learned friend has calculated, I think it comes around 2,08,000. So I've paid whatever years my learned. Yeah. Yes.
total 27 months. 27 months till now. 27 months. So 27. 27 into 8. Is 2 lakh?
2,08,000, man.
You paid the entire 2,08,000 as of.
Entire amount as on today, as on the.
That is honored, the check is honored.
Yeah.
That day you were reluctant to take the check.
Yeah, he took the check, say that.
No, something or the other your client got.
The check will bounce. That was his apprehension.
I was thinking it may bounce.
No, but anyhow it happened. Good for your client. Yes. So please come to the merits of the matter.
Yeah.
What is your income?
My lord, the 2 applications are filed, my lord.
Now, what are these 2 appeals? One is, both are.
Yeah.
One is?
One is, my lord, maintained under 125 to IA number 2. That I called in question. What happened, my lord, when the case was filed? I was not represented by my lawyer at that point of time, my lord. So I was unable to file my objection to IA number 2. Since I have not filed the objection IA number 2, the order was passed, my lord, calling upon me to pay 17,000. Subsequently, I came on, new advocate came on.
We'll do one thing. No, let him continue to pay. No, till now he has cleared.
He has to continue.
No, he has cleared the arrears till now
Clear
at
the arrears.
8,000, at 8,000. Now, let him continue to pay 8,000. Let the trial court with all his.
8,000, what will happen, my lords? Because in Bangalore city, two people has to survey. She is staying in her parental home. What, nothing is possible in 8,000, my lords. That is a single digit number. If I gave to the opposite party 8,000, will they possible to survive?
All these questions you can't ask the court.
No. Just to think, my lordship, because 8,000 is not possible.
Yes.
The family court has ordered for 17,000, not to half of that. Below that it happened. No, it's not possible, my lord.
Yes, that's your submission and record. Yes. What is the income?
My lord, my income is 10,000. I produce my assets and liability. What happened, my lord? Subsequently, I filed my application as a objections and also requested the court take the, I'm hearing on that IA. And also I filed an application 127, my lord, due to change circumstance, I was unable to represent. So the court said, my lord, I'll have to file a separate petition. So therefore, my application was not considered under 127. So for us, my lord, before my lord, so what will remain for consideration is the orders passed on IA number 2. IA number 2, my lord, orders were passed without.
What is the other IA to recall?
Other IA, my lord.
IA number?
The recall PW1 for the purpose of cross-examination. Since when they filed their affidavit, since I did not file my objections to the main petition, my right to cross-examine them was taken away. Then I made an application, I filed an application, kindly permit me to cross-examine. The trial court did not, family court, my lord, did not consider.
Opportunities has given to them. They are not utilized, my lordship. They are blaming the family court presiding officer. They are not given the opportunity.
Let him submit. I'll hear you also.
Lord, why should I blame any court? I have produced the entire.
Don't answer to his queries.
Entire order sheet was before the court. Thereafter, my lord, I filed an application, my lord, permit me to cross-examine PW1. Since I did not file the objections, my lord, the court said, my lord, that I will hear on this IA. Without hearing the IA, my lord, court has posted the matter for judgment. Against that, to IA number 7 and 8, my lord, I filed the second writ petition. These are 2 writ petitions before my lord. And after hearing my lords, my lord said that I will remand the entire, all the application matter. I mean, until then you pay at the rate of 8,000. So I undertook before the court, I say I'm willing to pay at the rate of 8,000. So I will remand all the matters and then let the family court hear based on the new circumstance. The family court hear.
Yes.
My lord, before considering his applications of IA number 7 and 8, my lord, he has to continue to pay interim maintenance till disposal of the petition. And he sought for set aside the order 11/1/2023. It cannot be set aside, my lord. It cannot be set aside. It's interim. It is a right of the respondent. Duty of the petitioner. He has to pay the maintenance. How can he set aside this order passed by the family court judge? He has not utilized the time given, and he is blaming the family court judge in all the grounds of 30 paragraphs of ground, blaming the respondent, blaming the family court judge, not utilizing the time given by the family court. It is his fault. He is a defaulter. He is having enough money to pay maintenance, but he is evading payment of maintenance, and he is approaching this honorable court for decreasing the maintenance ordered by the family court. He is having money to pay fees. He is having money to pay everything to do, but not to pay maintenance to respondent and a minor child.
Yes. Please come. Is it getting recorded? Agreed with the order passed in IA number 2 dated. Give the next matter.
Mm. 11/1/2023.
Where is the other order in the second writ petition? Yes. What are those IA numbers?
7 and 8.
7 and 8, ma'am.
agreed with the order in I number 2 dated 11th January 2023 and the order dated 23/8/2023. The husband is before this court by so and so judge. Husband is before this court. The wife had filed criminal miscellaneous 341 of 340 of 2022, seeking maintenance of an amount of rupees
50,000.
50,000 per month for herself and the daughter or son,
Son, minors.
and for her son. The trial court by order dated 11th January 2023 had granted an amount of rupees 17,000 as maintenance, 12,000 as maintenance, 12,000 to the wife and 5,000 to the daughter. Altogether, a maintenance of an amount of rupees 17,000 is granted. While granting the maintenance, the trial court has observed that
Para 8 and 9, my lord, of the impugned order.
that the wife had not produced any documents to show that the respondent is having properties worth of crores of rupees and is having financial ability to pay maintenance at the rate of rupees 50,000 per month for herself and the child. Considering the prima facie material placed before the court with the affidavit of assets and liabilities of the petitioner along with the responsibilities of the respondent to maintain his wife and child, maintenance amount has to be fixed. The court has observed that the respondent is, husband is working in RJS Polytechnic as technical officer and drawing salary of rupees 1 lakh per month. And he's also carrying on business in the name of Edge Frost Systems Private Limited. And the wife had declared that she is in need of 20,000 per month. The husband had not filed his statement of assets and liabilities before the trial court. Then the court has come to the conclusion that the husband is bound to pay rupees 12,000 per month for the maintenance of the wife and the child. Bound to pay maintenance and accordingly granted 17,000, that is 12,000 and 5,000. Coming to the IA number
7 and 8.
7 and 8. At what page number? Which page number?
Page number 50, my lord. The IS, my lord, filed.
Not order.
Order, my lord, page number, the filing, my lord, it's in page number 50.
The
Order, my lord,
husband had
page number
filed
52 and 53.
IA number.
Case is posted for judgment.
IA number 8 and 9. IA number 8 is filed.
Under 151 of the CPC, my lord, to recall PW1.
You open the stage and permit the petitioner to cross-examine permit the husband to cross-examine the wife. IA number 7 is filed to recall the order dated 24/5/2023 and the permit the husband to cross-examine PW1 and for such other PW1. This application was not considered by the court and it is observed that
My lord, page number 52, my lord.
for considering IA numbers 6 to 8, case is posted for in spite of specific directions dated 28/6/2023, respondent failed to make payments towards maintenance for considering IA number 6 to 8. Hence, case is posted for judgment on 4/9/2023. agreed by those two orders, passed by the court. The husband is before this court. As these two applications arising out of the criminal miscellaneous number 340 of 2022, these two writ petitions are disposed of by way of a common order. Next para. Learned counsel appearing for the petitioner husband submits that the petitioner could not file his statement of assets and liabilities before the trial court. And according to him, his income is only 10,000. He's working as a AC mechanic.
AC mechanic.
He's working as a AC mechanic, and as stated by the wife, he is not working in any, he's not
Polytechnic.
working in a college. He's not working in a college, or he is having any other company. As he has failed to, as he could not file the statement, this statement of assets and liabilities, this order has been passed. He submits that if an opportunity is given to the petitioner, he would file the statement of assets and liabilities. It is submitted that when his income itself is 10,000, he won't be in a position to pay he's not in a position to pay 17,000 as maintenance. He submits that as initially a stay was granted by this court, on condition of paying 50,000. Thereafter, this court, considering the submission made by the petitioner that he is ready to pay 8,000, right from the date of petition till now, the amount is calculated, deducting the 50,000 that is already paid by him, and at 8,000 till now he has cleared all the arrears. He submits that he'll continue to pay 8,000, and the matter may be remanded, and the court may be directed to consider the interim application for maintenance.
One submission, madam. Before considering this application by his family court, he has to pay maintenance in family court without pay before first week every month, my lord. He is a defaulter in everything,
What did you write?
either in attending the court or in payment of maintenance.
Maintenance, and also the basing on this, a statement of assets and liabilities filed by him, and also the other IAs that are pending before the family court. Next part. Then counsel appearing for the respondent wife submits that the petitioner was never vigilant in pursuing the matter. He never utilized the opportunities that are granted by the trial court. He submits that when an application is filed seeking interim maintenance, he ought to have filed a statement of assets and liabilities, which he conveniently has not filed. He submits that even in the marriage card, it is shown that he is working as a lecturer. According to him, the husband is having all the means to pay the maintenance, but only as he is not inclined to pay, and he is avoiding, and also he is coming up before this court, seeking, questioning the order of maintenance. He submits that when he is filing applications, court has specifically observed that unless and until the maintenance is paid, the court will not consider his application. In spite of the same, he has not paid the maintenance, as he has been not pursuing the matter vigilantly, and he has failed to comply with the orders passed by the court. Court had rightly passed an order, and either the maintenance that is granted or the order in the IAS, wherein unless and until he pays the amount, that the IAS will not be heard, and rightly had posted the matter for judgment. He submits that both the wife and the daughter cannot live, a son cannot live with the 8,000 as that is submitted by the counsel for the husband. And if he wants a matter to be remanded, he shall pay 17,000 on by fifth of every, by first of every month. And if it is agreeable for him, then only the matter can be remanded. Otherwise, he is not entitled for any relief from this court. Anything else?
That's all.
Having heard the land counsels on either side, there is the material on record. There is no dispute about the fact that the respondent or the wife and the son. The wife had filed the petition seeking seeking maintenance and sought interim maintenance of an amount of rupees 50,000. The husband, though the summons was served on him, had failed to appear before the court and had not filed his statement of assets and liabilities. Having no other go, basing on the abundance of the wife, the court had granted an amount of rupees 17,000 as maintenance. Thereafter, the applications that were filed by him were not considered by the court, as he is not paying any maintenance to the wife. When an order is passed by the court, unless and until such an order is complied with by the party, the court was right in not considering the applications as per the powers vested with the court under section 151 of the CPC. Now, the petitioner has questioned the order of granting maintenance of an amount of rupees 7,000. Now, he has filed the material before this court to show that his income is 10,000, which is denied by the land counsel for the respondent wife. Unless and until there is an inquiry on that by the court, whether the income of the husband is 10,000 or as stated by the wife, it is 1 lakh, that cannot be decided. For that, filing of the statement of assets and liabilities is has to be filed. If if any of the information that is stated before the court in the statement of assets and liabilities is not a correct statement, the court can always take up, initiate the proceedings for perjury against the party who has misrepresented before the trial court. When before this court, the material is placed saying that his income is 10,000. At this point of time, this court cannot direct the husband to pay an amount of rupees 17,000 as maintenance. Hence, in the considered opinion of this court, the matter has to be heard by the court. For that, the order impugned in I number 2, dated so and so, has to be set aside. And till the application is decided, the husband shall continue to pay 8,000 as maintenance.
Because 8,000 is single digit. She is not possible. He is suffering from starvation from
The
date of marriage.
shall pay 10,000 till the application is decided by the trial court.
First week of every month.
Just wait, that
Interfering every time when the court is dictating order.
what did you write? Decided, and once and as already the arrears are cleared, and the trial court shall consider the IA numbers,
IA number 7 and 8, my lord,
IAs number 7 and 8.
and IA number 2.
IA number?
2, IA number
That
2.
will be set aside.
Yeah. And
So
7 and
IA
8.
number 7 and 8. 7 and 8. Hence, the court is passing the following order accordingly. The order dated in respect of IA number 2, dated so and so, by so and so, is set aside. And the matter is remanded to the trial court till the application is decided.
I have to file objection to IA number 7. In
Fine.
family court, my lord.
Fine.
Continue.
IA number, yes. Till the application that of interim maintenance is decided, the husband shall continue to pay an amount of rupees 10,000 by 5th of every succeeding month. Number 3, in the pending IAs, wherever the objections are not filed by the wife is at liberty to file the objections. Next, The,
May I make my one last? For cross of PW1, it has to be happening in family court itself. Because many, in my cases, what happens in that family court, the presiding officer will order for commissioner to do outside.
that also this court will tell now in this order. Let them pass an order. Now the court cannot tell all that. Now with all this interference while the order is dictated, that's only it is not good for you. Now I forgot what to dictate. What is that the court wants to say?
Throughout, my lord is interfering when the
Please,
court
please wait.
dictates.
Yeah, the court is saying that.
Yes,
Why
ma'am.
do you comment? Yes, what is that? Objection, the husband shall file his statement of assets and liabilities before the trial court.
Already filed, my lord. Already filed.
The court shall consider the statement of assets and liabilities filed by both the parties and decide the application. Next, if any of the statements, any of the details that are placed before the court with regard to the income, if the said information is not correct information, if that is pointed out before the court, appropriate proceedings shall be initiated by the, shall be initiated against the party who has misrepresented. The IA that is filed shall be, for the interim maintenance shall be disposed of within a period of 2 months from the date of receipt of the copy of law.
Submission, my lord.
Accordingly, both the petitions are disposed of. Yes.
Can it be 8,000, my lord, because my income is only 10,000, my
My
lord.
lord, in bank,
Income is
nothing
only my
possible, my
10,000.
lord.
2 months.
And I
2
filed
months.
an application restitution of conjugal rights.
My lord, I have filed a claim as divorce.
If both of you want to, what will the trial court judge do with all this?
Same, my lord, every time, my lord, this is the interference. Not even allow me to make submission before any court. Always.
Months.
interfere.
2 months, it will be decided. Hardly it makes 4,000 difference. Yes. What is that? Yes.
Number 10, my lord.
Uh,
The side.
Yes.
Transferment of compensation in respect of land acquired.
Mm.
The learned presiding officer has not taken consideration of the trees and fruit plants while passing the award.
Please come to that order.
Lord,
Please come to that order.
Yes.
What is the extent of land of the petitioners that is
2
acquired?
acre 10 guntas,
2 acres, 10 guntas.
2 acres 10. Your lordship, may I
You are
declare-
not aggrieved by the compensation.
Even
paid to the-
compensation, we claim 30 lakhs. 15 lakhs and add is awarded.
Per acre, how much?
Per acre 15 lakhs and add. Your lordship may kindly see the compensation fixed.
Page number?
Notes. Compensation is at rupees 15 lakhs 25,880 per acre. It is at page, operating portion of the order at page 20,
Page?
page 20. Ink page 20. Internal page 9.
1,000 per acre with solatium of 30% less. the amount
30%.
spent. So
Less the amount already received.
the loan is also entitled for interest at 9%. Yes.
Your lordship may kindly see the land acquired is abutting to the national highway, leads from Mysore to Bantwala. And it was already, it has lost the agriculture character except coconut plants and arachidonic plants, and the fruit plants are available. The rest of the lands have been already formed layouts and allotted to the respective parties for residential accommodations. When such was the matter, the compensation awarded is lesser side. Apart from that, your lordship.
No,
may
for that purpose, what are the documents that are filed?
Your lordship may kindly say exhibit P12.
Exhibit P12.
It is pertaining to the award is passed in the said judge
that?
order. Exhibit P12.
In respect of the adjacent lands,
The acquisition was pertaining to the 2003, whereas exhibit to P12 concern. Present acquisition, which is before your lordship, is 2006.
So per year, 15% of market value has to be taken as enhanced value.
How much is given in this?
In 15 lakh, other 12 lakhs, in that matter, 12 lakhs was given.
12 lakhs, 12
Nine.
lakhs, 958 is acre.
Yes, ma'am.
Oh.
Here in
So it is
15 lakhs.
exactly after 3 years.
After 3 years, 15 lakhs has been awarded. My submission is even if as per the judgment of the Honorable Supreme Court, it is taken for consideration. Per year, 15% has to be.
So then how it comes? How much it comes if it is?
It comes to
15%?
almost to 29 lakhs million.
Where is the judgment?
Your Lordship may kindly say that judgment right now, I'm not having. this.
We'll have it with the judgment. We'll
Please,
consider if that's the case.
Monday.
Monday.
May I request Tuesday?
And the request you can answer for the petitioner pose this
Please.
matter on Tuesday.
Till number 10.
No, my learned friend is telling Monday is holiday. It cannot be, it's not applicable.
Tuesday,
Tuesday is coming.
Tuesday.
7, 8.
Yes.
Appear for the appellants in this matter.
Till number
What has
10.
happened? What is the proposal that you have given? There should be something. Without anything, you can't say that there is compromise.
Facts are like this, my lords. The site which they have constructed, partly 18 feet by 45 feet is they have constructed on my survey number,
Client
which
has
I have
come to the
purchased.
court? Your client has come to the court?
She is not in station, she went to Assam. Her daughter is carrying the 5 minutes and take care of her, she went to Assam minutes. And she.
No, why don't you give your proposal?
My proposal is, my lords, now I had conducted a private survey. In that survey, I came to know that 18 feet by 45 feet, they have squatted on my property. I've already filed a suit for declaration, injunction, comprehensive suit, even for possession. Now, my only request is, what my client says is, I don't want to go on with the matter. By anyway, they have already constructed in the position of the property. If any compensation is given as per the market value.
What is the compensation?
My lords, 10,000 square feet is the market value.
So how much it comes to?
It comes to somewhere around 60 lakhs.
60.
60 lakhs, 60 lakhs.
We will argue on the merits of it.
No, let's, I will
I'm-
talk with my senior and get back to you.
I'm okay with whatever, at least let them come near the proposal, ma'am.
It is submitted, land council, for the appellant submits that already the respondent defendants have encroached the property of the appellant and constructed. He submits that if they come up with a settlement for settlement whereby if the market value for the encroached land is paid, is ready to compromise.
Very well.
Then counsel for the defendant, the respondent shall come up with instructions, pose this matter on 2nd of September.
Highly obliged.
Yes.
Number 11.
Well, in this case, this is a defendant's appeal. They have not made any objections to the application for interim order. Or I made an application or 49 Rule 27. Produce certain result documents also. They are not coming up before this court at all.
When it has come up, let's see. When
My
they-
only grievance is the suit for injunction was filed. And the trial court, without considering the correct measurement and the schedule of the property, allows the application of the interim injunction in favor of the plaintiff.
So it is not listed. 19/7/2020.
Last time,
Counsel for the petition, appellant is present, no representation for the respondent. If you have urgency, we'll take up tomorrow.
I am, your Lordship may kindly have it on 3rd or 4th. I got some person.
Yes. Post
And
on
interim
4th.
order of status quo may be extended.
Post on 4th, no representation for respondents, intermod audio granted.
No objection is filed to the applications also.
Who filed no objections?
He has to file objection to the application for interim order. And even the
Yes,
application
yes,
of
yes,
41/27,
yes.
Number
Yes, next.
12.
interim order may kindly be extended.
Intermod audio granted is extended to the next date of.
Oblige, your Lordship.
Yes, 12.
Till number 12. Chandana, please. Mana,
Maybe passed over, seniors held up.
Abhinav Ramanan.
On the last petition, if your lordship recollect, matter was passed over thrice. I'm not complaining. Today I have some inconvenience in the afternoon. Maybe taken up in the first week or the last 28th.
So on the last date, on their request, it was adjourned to today, my lords.
No, that's not.
You were not here, so please don't make that submission. I was here.
If I'm wrong, I'm sorry.
No,
but
no,
my
that's
col-
not true. You
Okay,
see-
if there's
Okay,
some
it's okay.
inconvenience, it may be taken up tomorrow, my
No,
lord.
I know him well. I
Yes.
know.
Tomorrow, please.
Tomorrow there is some inconvenience.
Then it's collected, come on Tuesday.
Tuesday, madam. Wait.
Yes,
27
next,
A.
at the request of learned counsel, the appellant,
Wait.
was this matter on Tuesday, is 13.
Serial number 13,
Appear for the-
Nanjareddy PN. 13,
appear for the plaint.
Yes.
Vipin Hegde.
Oh, yes.
Let the petitioner purchase 30 guntas.
It's a appeal of the defendant or the plaintiff?
Plaintiff's appeal,
Plaintiff's appeal. What is the suit for?
suit for injunction.
Your case is?
My case is that I have purchased 30 guntas of land in survey number 33. And they have also purchased 1 acre 3 guntas,
Survey number 33, 30 guntas.
30 guntas. Out of 2 acre 3 guntas. So 1 acre 3 guntas they have also purchased. So I'm in possession of that 30 guntas. Now, my lord, when they are interfering with the possession, my lord, I filed the suit for injunction. The trial court granted initially in order of temporary injunction,
Trial court granted ad interim injunction.
ad interim injunction. Thereafter, my lord, they filed application, that objections and all. They ultimately, my lord, this order came to be passed under by dismissing the application.
Please come to the order.
Yes. Page 10.
When did you purchase?
Millard, 2016, that is Millard,
2007,
22/7/2016. It is a
22/7,
2016, it is a converted land and sketch also was there. And ever since then, Millard, I have been in peaceful person and enjoyment of safe property. And Millard, when page 15, Millard, the reasons assigned by. The plaintiff, may I read? Para 14, I think. Reasons. The plaintiff company contended that they are the owners in possession of scheduled property and they acquired scheduled property from the vendor through a registered sale deed dated 22/7/2016, defendant without having any right, title, and interest, trying to interfere with the peaceful possession and enjoyment of schedule. And hence the necessary to restrain the defendant from interfering in his possession. So the defense of the defendant is that plaintiff is not at all the owner of the scheduled property. The plaintiff claiming the ownership of scheduled property through the created fabricated documents, and hence plaintiff will not acquire any ownership over the scheduled property. Prior to alleged sale transactions of plaintiff, the original owner of the property has executed the agreement of sale dated 27/9/1989 and 20/12/1991 with the defendant and his wife, so and so, and received entire sale consideration amount and put the defendant and his wife in possession of the scheduled land in part performance the agreement of sale. Hence, there is no any merit in the application. The plaintiff seeking relief of permanent injunction against the defendant in respect of the scheduled property on the basis of their rights of ownership and possession acquired through sale deed dated 22/7/16. It is specific contention of the defendant that the plaintiff in collusion with L. Venkatesh, the alleged predecessor in title, and others has filed the suit by creating several documents prejudice to the interest of the defendant and his property with a sole contention to obtain an order from the court, and based on the said order intends to take possession of the property belongs to the defendant. The material and record disclose that the vendor of the plaintiff, Venkatesh, had filed suit in OS number so and so against Hari K.V. Naidu and the plaintiff herein. In that suit, the said Venkatesh pleaded that GPA dated 10/6/2008, sale deeds dated 3/5/2012 and 22/7 are illegally created and fabricated documents. On the basis of those documents, plaintiff hearing claiming ownership over the scheduled property. Further, the
Material on record discloses that the defendant also filed a suit for injunction against L. Venkatesh before the Court of Additional Civil Judge. After hearing, the defendant has passed an ad interim order.
While in the plaint, have you disclosed about all these suits that are filed by you, against you, in respect of the very same property, by your vendor against you?
Allah, yes, yes. It is there. Yes. In the
Let's
written
look at the
statement,
plaint. Please come to the plaint.
it is, in the written statement, it is stated, but
No, not the written statement. We'll look at your plaint. Those are the important factors which need to be disclosed by you when you're seeking a relief of injunction.
no, I have not filed any suit against others.
No, no, please come to the order. You have filed. That's what the court records. What is the name of your client?
Milad Ajnath Suppliers Private Limited,
Represented by?
represented by its authorized representative Santosh.
Please come to para number. Come to 16, para number 16.
Of the judgment, Milad. Yes. Plaintiffs seeking relief for permanent injunction against the defendant in respect to real property on the basis of their rights, ownership and possession acquired through sale deed dates on. It is a specific contention of the defendant that the plaintiff, in collusion with L. Venkatesh, the alleged predecessor in title and others, has filed the suit by creating several documents produced to the interest of the defendant and his property with the sole intention to obtain order from this court based on the said order, intends to take possession of the property.
Yes, further.
The material on record disclosed that the vendor of the plaintiff, that is L. Venkatesh, had filed a suit in OSM against the Vanhari and the plaintiff. They have filed.
Plaintiff herein.
I have not filed.
No, it is filed against you in
Yes,
respect
yes.
of the very same
Yes.
property. Next, please further read that.
In that suit, the Venkatesh pleaded that GPA dated 10/6/2008, sale deeds dated so-and-so, are the illegally created and fabricated documents. On the basis of those documents, plaintiff herein claiming ownership over scheduled property. Further, the material on record disclosed that defendant also filed a suit for injunction against L. Venkatesh before the City Civil Court, and after hearing, the defendant had passed an interim order injunction against this.
So against your vendor, the defendant had filed a suit, there is an injunction, and your vendor denies your title to the property. He files a suit.
Not my vendor, vendor's vendor.
Vendor's vendor. Against you and your vendor also, he filed a suit.
Yes.
And what are the documents you have filed to show that you are in possession of the property?
But I filed all the documents indicating a lost
Not the sale deeds for possession.
possession, yes, madam. Sale deed one document, encumbrance.
When is the injunction in respect of the very same property granted to the defendants?
That is there, not this property, madam. Last may kindly say, in respect of 1 acre 3 guntas, not against this property. Sale deed, my lord, you lost may kindly see, sale deed is not disputed. Only thing they are claiming that they're illegal created, whatever it is, that ultimately the court has to adjudicate.
No, the identity of the property is in dispute.
Yes, that's exactly.
So at this stage, how can injunction be granted? He is also, no.
No, what he says is, yes, filed suit against that suit is pending.
No, your vendor's vendor is the
Mm.
owner of the entire extent.
Yes, yes.
Is it so?
Correct. No. 2 acres 3 guntas only. He has purchased 1 acre 3.
Point out. Let him finish.
Yes.
Okay. He has purchased 1 acre 3 guntas. There is no undisputedly, he has purchased that. I am not disputing.
No, this L. Venkatesh.
As your lordship rightly said, the only thing is that the identity. Lordship may kindly say, this property comes here. There is a nala here. My property is there. He is claiming, what he is claiming is, he has filed suit to Millard for specific performance against the old, what is that, agreement of sale and all.
That suit is pending, that's what he says. So by virtue of that, he is claiming this my property belongs to me. Unless the sale deed is there, transfer of title is passed on, he will not get in right.
Let's look at his, the written statement. Where is the written statement?
Page 27. Para 2, the defendant submits that it appears that the plaintiff in collusion with Venkatesh, the alleged title predecessor, title and others, has filed the above suit by creating several documents produced to the interest of the defendant and his property, with malified intentions and ulterior motives, with sole intention to obtain order of so on. Para 3, the defendant submits that the plaintiff deliberately suppressed the fact pendants of earlier suits pertaining to the land bearing some 33/1, Medal OS number.
No, this earlier suit you are referring to, this is OS number
3623.
3623. Is pertaining to which land? Yes, Mr. Counsel.
That is different.
For the respondents. OS number 3623 of 2023 is pertaining to which land?
Pertaining to certain
Extent of?
extent, my lord, the entire extent, my lord, actually it was 2 acres. In that, my lord, 1 acre 3 guntas I have already bought, I have purchased. In respect of the remaining portion of the land, I have filed a suit for specific performance that is pending before the court.
When did you file?
Lord, that suit was filed in the year 1995.
1995,
that suit.
What was the order granted in that, that suit?
In that, my lord, there is an interim order not to alienate the property or create third party rights.
No, one aspect is, in respect of that property, you filed a suit. But
In
there was
respect of the property that is 1 acre 3 guntas which I have purchased, for which I have a sale deed, I filed a suit against L. Venkatesh. Lord, in that suit, an interim order was granted.
No. 1 acre 3 guntas is not in dispute. No, about the remaining extent, you filed a suit for specific performance. The order, is it your case that the possession was delivered to you in the specific performance suit?
Yes.
Did you say so?
And in fact, my instructions are that this thing is that the suit itself has been decreed now. I can place that fact, my lord, because we have not got.
No, where did you say in this written statement that it is your case that in respect of that suit scheduled property in the specific performance suit, possession was delivered to you? Where did you say so in the written statement?
That, my lord, because I am not appearing in that suit.
No, whoever, like whether it is stated or not.
Lord, in this written statement, my lord, what I have stated is that in respect of this 1 acre 3 guntas of land, there is a dispute and I have filed a suit for specific performance.
No, he is not saying, claiming anything in your 1 acre 3.
Yes.
In your 1 acre 3 guntas, he is not claiming anything. He is claiming in respect of other, what would be the remaining one? How many guntas?
30 guntas.
30?
Actually 1 acre.
Huh?
1 acre. Out of 2 acres 3 guntas, 1 acre 3 guntas he has purchased. There is no
Which extent you purchased?
I have only 30 guntas. 10 guntas is the landowner. I only 30.
In fact, they are trying to say that this 30 guntas is the other land, but according to you, Lord, this 30 guntas which they have purchased, it is coming within 1 acre 3 guntas. According to me, they are claiming that land which I have purchased for 1 acre 3 guntas which I have purchased.
That is your case. Please come to that. Come to that particular averment in the written statement.
Yes. From para 12, my lord.
No, he is not a party, he was not made a party.
am not a
when
party.
the purchaser in that suit.
Their specific performance, my lord. He is not a party.
No, I filed an application. 1 second. I filed an
Now, let me come to para.
I filed an application for impleading.
Yes.
That was rejected.
30?
Lord, para 12. The defendant submits that the allegations claimed in paras 9 and 10 of the claim that the plaintiff is the absolute owner of so.
Yes.
Point of. come to para 13, my lord. The defendant submits that defendant is the sole and absolute owner in the possession and development of the property bearing survey number 33, new survey number 33/1, measuring 1 acre 3 guntha situated at Matrimonial village, so and so. The defendant submits originally the land bearing survey number 33, measuring 2 acres 1 guntha, including 9 guntas situated at so and so, belong to one A. Pillappa, son of Arsappa, and said land was granted to A. Pillappa, so and so. By the land tribunal, Bangalore North Taluk, and the land tribunal has issued grant certificate dated 38/1980, and same is reflected in form number 8, index of land and record of rights and subsequent grant of land of the said property. The revenue records have been transferred in the name of A. Pillappa, son of so and so. The defendant submits that he said A. Pillappa executed general power of attorney dated so and so in favor of Jacob Pancharan Mathai, son of P.M. Mathai, in respect of land bearing survey number 33, measuring 1 acre, situated at Matrimonial village, Yeshwanthpura Hubli, so and so, delegating the powers to do all acts, deeds, things, or so and so. Now, kindly come to the next paragraph. The defendant submits that said A. Pillappa executed GPA dated 20/12/91 in favor of Jacob Pancharan Mathai in respect of land bearing numbers, survey number 33, measuring east to west 220 feet, north to south 172 feet, in western side 25 by 225 feet, that is 3 guntas, situated at Matrimonial village, Yeshwanthpura Hubli, Bangalore North Taluk, delegating the powers to do all acts so and so. The defendant submits that defendant has purchased the said property from A. Pillappa, son of Arsappa, for a valuable sale consideration, while sale deed dated.
Please come to page 38,
Page
38, page 12, internal page 12. That it is numbered as page 12.
Yes.
You're telling about the sale.
Yes,
deed.
yes, yes.
As an
Agreement.
Shall I read from the beginning?
Yes.
Lord? To an extent of 1 acre, and has entered into an agreement of sale dated 27/9/89 with this defendant and his wife Aliamma Jacob, and received advance sale consideration and put this defendant and his wife Aliamma Jacob in possession of the said 1 acre of land in part performance. I was put in possession in part performance of the agreement of sale, and the daughters of A. Pillappa have also executed the said sale agreement as consenting witnesses, and A. Pillappa, son of late Arsappa, during his lifetime, had agreed to sell eastern side of 1 acre land.
Please that order copy, the judgment and.
That judgment, my lord, I will place it, my lord.
That,
will
my
make
lord.
it clear. In fact, my information is that the suit had been posted for pronouncing of judgment. I do not know whether, my lord, because the trial court advocate, a different advocate is there. He has not given instructions to me. I will place that judgment, my
The
lord.
request of land counsel, the respondent posts this matter on 3rd of September.
Till then, my lord, there was an interim order throughout in this.
The order is there.
Not here, before the trial court.
The order was there. Thereafter, it was vacated on my application.
Yes, yes.
Therefore, my lord, there is no
In
interim order.
persons of this judgment, the agreement of sale only,
Now it can't be, now it
Yes.
cannot be granted. Yes,
when it is possible.
third September.
Very.
14, my lord.
Yes. Huh?
Number 14, my next matter. 29th.
Why? Have you informed the other side?
I have responded.
Can be adjourned. Post this matter on 10th of September.
Serial number 16 minutes. Serial number 6, kindly on 28th or 29th minutes.
That's what the court said. You can't make mentions now. One is starting and everybody is, there is a specific mention in the cause list also.
I'm not senior counsel, personal inconvenience. The other side is also here.
At the request of land counsel, the appellant post this matter on 12th
Thursday.
of September. Yes. No adjournments, please.
Please.
Madam, 34.
21.
ಆಗಿಲ್ಲ.
21 ನೋಡಿ ಮೇಡಮ್.
ಮೇಡಮ್ 29 ಅರ್ಜನ ಇದೆ. 29 ಅರ್ಜನ ಇದೆ. ಆಗಿಲ್ಲ ಅದು. ಓಕೆ.
38.
ಯಾವ್ದು ನಾಳೆ?
Proceed ಮಾಡಿ ಸರ್ ನಿಮ್ಮ ಮೊಬೈಲ್.
Court officer?
ವಾಟ್ಸಪ್.
Court officer? Court officer?
ಅಪ್ಪಾಜಿದ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ.
ಓಕೆ ಓಕೆ.
ಇನ್ನೇನ್ ಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು
ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಪ್ಪದ ನೆಸಿಟಿ ಇಲ್ಲ.
ಹ್ಮ್.
ಯಾಕೆ ನಿಮ್ಮ ಹೆಸರು ಖಾತಾ ಬಂದ್ಬಿಟ್ಟು
ಅದೇ ಹೇಗೇನಾಗ್ಲಿ ಅದಕ್ಕೆ ನನ್ನ
ವಿಲ್ಸನ್ ಎಲ್ಲಿ ಬರುತ್ತೆ ಇದು ಸಬ್ ರಿಜಿಸ್ಟರ್ ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಬಂದ ಇಲ್ಲೇ ಬಂದ್ರೆ ಇಲ್ಲೇ ಮಾಡಿಸ್ಬೇಡ.
ಹೌದಾ
ಶಾಂತಿನಗರ್ ಹತ್ರ ಅಲ್ವಾ ನಮ್ಗೆ.
ಕೇಳ್ತೀನಿ ಚೆಲ್ಲಿಯವ್ರಿಗೆ ಕೇಳೋದು.
ನೋಡಿ
ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ನೋಡಿ ಬಿದ್ದು.
ಅದೇ ಅವ್ರು ಅಲೋ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು.
ಅದಾ ಅದೇ ಮ್ಯಾಟರ್ ಕಾಲ್ಡ್ ಔಟ್ ಐ ವಿಲ್ ಟೇಕನ್ ಅಪ್ ಅಂತ. ಇನ್ನು ಕಾಲ್ ಔಟ್ ಆಗಿಲ್ವಲ್ಲ ಅದು. ಈಗ ಆರ್ಡರ್ಸ್ at 2:30 ಕಟ್ಬಿಟ್ಟು ಇದು ಕಟ್ಬಿಡ್ತೀನಿ 2:30 ವಿಡ್ರಾಯಲ್ 2:30 ಆರ್ಡರ್ಸ್ ಮಾಡಿದ್ರು. ಆಮೇಲೆ ಪಾಸ್ ಓವರ್ ಆಮೇಲೆ ಪಾಸ್ ಓವರ್ ಒಂದು ಐತೆ ಸೀರಿಯಲ್ ನಂಬರ್ 5. ಸರ್ ಅಲ್ಲ ಸರ್ ಅದು ಯಾವತ್ತಿತ್ತು ಹೇಳಿ ಅದು 14ನೇ ತಾರೀಕಿಗಿತ್ತಾ? ಮೇ ಬಿ ನಾಳೆ ಪೋಸ್ಟ್ ಆಗ್ಬೋದು. ಅದು ರೀ ಅಪ್ಲೋಡ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ಸುತ್ತೆ ನೋಡಿ ಡೇಟ್ ಅದು ನೋಡಿ ಒಂದ್ಸರಿ.
The memo is filed.
Muni Reddy,
I appear for appellant, my lord.
For the MFA number one, the appeal is stated that OS number 8038 of 2022 is withdrawn as if this appeal has become infectious, accordingly dismissed as. Accordingly, the memo is taken on record and the writ petition is dismissed as withdrawn. Yes. This is at 2:30. Call it.
orders matters at 2:30. Serial number,
Yes.
serial number 35. Serial number 35,
Same office objections.
party in person, Ravi B.
Party in this, yes, made any mention about this in the morning? The
No.
Party in person was there. 40, yes. Office objection shall be complied with within a week, or else the appeal stands dismissed without further reference to the court.
Serial
It's
number
36.
36.
Yes.
Memo for
Hearing for appellant. Filed on 2nd hour. Matter is settled out.
Memo is filed, seeking to withdraw the appeal, stating that the matter is settled out of the court, same, taken on record, dismissed as withdrawn. Next,
serial number 37.
Hearing for the appellants, PP is filed in respect of 3 respondents left out, added respondents.
yes,
R86, Lakshman, 87, Anand, 90, Rangaswamy.
accordingly. 1 minute, this, as per the order, as per this court. The appellant had taken out paper publication in respect of R86, R87 and R90. Accordingly, the same is accepted. Notice to R86, 87, 90 is held sufficient. Next, I have 1 of 2023 for impleading. What is this?
Pardon?
No, this notice is for the implead parties.
Whether notice has gone to the impleading application.
Now, we have sent it by RPID several times. So far as the service before trial court was served on the same addresses. But in this appeal case, they have shifted the houses, do not know this.
What has happened? Take out that IA number, give the order sheet. No, first of all, notice is ordered or not? 1 of 23 for impleading, 1 of 20 for temporary injunction. Statement of objection. IA number 1. Notice itself is not ordered in IA number 2.
Again, number 2.
Yes.
Madam, this is, notice was, notice by
Not
P.
ordered. Last order is on 12/7/2024. That's on IA number 1 of 24.
1 of 24. Madam.
Yes. This is why your implead petition is IA 1 of 2023.
Yes, yes, my lord. This is. Thereafter, the service by RPID is could not be served. So I failed IA 1/24 and RFA Rule 20 by way of substituted service by PP. It was allowed by Kannada Prabha.
Please state out what is this IA 1 of 23? Hmm?
23 is
What is he saying then?
1/23 is concerned, seeking to add respondents.
That is what I'm asking. That no notice is ordered till now in that. Notice is not ordered in IA 1/23.
1/23, they added, so the RPODs came back, court process, therefore 1/24 by substituted service, it was ordered on last hearing date. That is why I filed PP in the Kannada Prabha.
So that, first of all, notice should be ordered in IA number 23. Where is that? When is that ordered? It is not ordered. It has never come up before the court.
Last time I was present, I don't know.
IA number 1.
1/24.
Yes,
issue notice on IA 1 of the order.
that is in IA number 1/24.
Yes.
Hmm. Then now all of them are served now.
All are served, all 10 parties.
What is
served.
this petition?
This is agreed, this is, we have trial court sued for a partition.
No, whom you want to implead?
Out of 10 respondents sought for impleading, 7 were served, 3 could not be served. So these 3 apart from, so therefore all are served, all are required to be impleaded.
Please come. IA 1/24, 23 is filed. To implead. The sons, grandsons and great grandsons of the proposed is. This court has ordered notice to the respondents. And all the respondents, all the implead respondents are served. I've seen the same. IA number 1/2023 is allowed. And the petition should carry out the necessary amendment to the court. Yes. That's what I said. Yes, next.
Cell number 30 for 38. 38. I know that. 38 urgent, 39.
38 is your matter.
Yes.
Morning, they said the council is not well. Yes.
The 27A.
So 27, my lord, I am not on 30,000. 28, my lord.
It's already signed, order is signed.
Then on that day, my lord.
Yes, 39.
Cell number 39.
May it please your leadership, I appeal for the appellant.
Buster.
I'm the 4th defendant in the underlying suit. By way of IA3, which was allowed on 12th of July,
Paper
I
publication.
was granted leave to serve the respondents by way of paper publication that's been undertaken and it's on record. The contesting respondents have been served to the counsel in the trial court as well. They've not entered appearance. If I can persuade your leadership to just look at the order, the impugned order.
So no, no, notice is complete now.
Notice is complete.
But then let it come up for admission.
Please, if I can just point out one aspect, the coordinate bench of this
One
honorable
minute.
court.
As per the orders passed by this court, the notice is taken by the appellant by way of substituted service on respondent number 5. And also filed a memo to that effect. Accordingly, the same is accepted. A notice to R5 is held sufficient. It is as per the orders passed by the court dated 14/3/2024. They served the copy, they served the notice on the council appearing for R1 to R3.
R1 to R.
R1 to R3.
R1 to R3.
Then what about R4 is not there?
No, R4, R5 have not entered appearance even in the trial court.
So pose this matter for admission on Tuesday.
Good.
Yes, next.
Cell number 40. That is the matter where legal services.
40 is asking. Are there any panel advocates in the Legal Service Authority?
Legal Services Authority panel councils. There nobody is there.
It is submitted by the party in person that on the last occasion he had sought time on 10/6/2024 to engage a counsel in spite of his best efforts. He is not able to engage the counsel. Hence this court appoints Srimati Manjula D. And the registrar shall send the papers to the council. Yes. Pose this matter, print her name, pose this matter on September 18th. Yes, next.
Cell number 41. Raghunath MD.
Appear for applicants. This is appeal for to sell the trust property permission. The paper publication has been done on 13/7/2024 to Kannada Prabha and the New Indian Express newspaper.
Please come to the cost title.
I know.
Come to the cost title. In MFK.
Yes, madam.
Who are the respondents in the MFK?
Nil, madam. Nil.
Three.
No, madam. Nil. Respondents are nil.
And then for whom you are taking notice?
To sell the trust property, I am public notice, madam.
Public notice.
Public notice. Madam.
What is the order? This is coming up for the first time.
Yes, ma'am. The impugned order is dated 24/1/2024.
Where is the memo? He submitted that as per the order dated 8/7/2024. He has taken out notice in Kannada and English daily newspapers of Kannada Prabha, and he has filed the memo along with the copy of the publication. Accordingly, the memo is taken on record. Yes.
I humble request the date may be fixed for admissions.
Let it come on 29th.
29.
Obliged.
Post for admission on 29th.
Obliged.
More matters are there. 29th.
Cell number 42. Ketan Yadav.
Await service of notice, post after surveys,
Lordship, a short date may be given, my lords.
4th September.
Sure. Wait a minute.
Cell number 43. Somshekaraya RP.
Office objections of respondent on respondent's IA. If the office objections on IA number 1 of 23 is not complied with within a week's time, IA 1 of 23 stands dismissed without further reference to the court. Next,
Cell number
44.
44. 44.
This is appeal for the petition, Malada. Needful is done, Malada. Regarding.
Already done.
Please, Malada. Regarding the payment, Malada, I taken DD for I taken DD, Malada, to the Register of General, Malada, instead of paying the amount, Malada. Because, Malada, respondent not appeared before the trial court, Malada, and also last occasion, Malada, before the trial court, I was due, Malada. Maybe permit to 1 week time may be granted, I will deposit before the trial court, Malada, or before this honorable court.
What is the order now? Why is it? It's coming up for what?
For payment and steps was not taken to the.
Furnishing of so and so to issue notice to respondent.
I already
That
taken.
is done.
Please, Malada.
Yes, not taking of hand summons.
Serve the copy through RPD, my lord, but he is refused to take the copies, my lord. Advocate on record, advocate on record. Before the
Who
trial,
asked you to take it by RPAD?
before the trial.
Who asked you?
No, my lord, I send the.
Then shouldn't do it. What the
Yes, ma'am.
court says that you have to do.
Yes, ma'am, I will
Yes.
prove, my lord. 1 week time may
Take
be.
the hand summons.
Yes, my lord. 1 week time may be granted.
For complying with the office objections. Same, a week's time is granted.
Like interim
Court
order.
order.
Interim order granted.
Interim order granted is extended till then. Yes.
Please,
Number 45. Sagar V. Shastri. 45.
The petitioner, your lordship.
Architect
Your
of
lordship had
Karnataka.
granted an interim order.
Hmm.
Your lordship had granted an interim order, conditional interim order, and the subject to payment of the interim maintenance, your lordship. And the needful has been done. I've also served a copy on the advocates appearing in the trial court. I filed a memo, 2 memos to that effect.
It is submitted that as per the orders passed by the court, the amount is deposited. Fine. Could have filed it for the registrar.
We did.
Huh?
We did, but we also filing a memo.
No,
here.
it's original is here.
We file it in the registrar here.
The carefully sent it. The DDs shall be deposited with the registry. The counsel for the petition, petition is directed to deposit this DDs before the registry. It is submitted that they've already served notices as per the orders passed by the court. Yes, pose this matter.
Your lordship,
On-
interim order made.
Pose this matter on October 15th. Interim order earlier granted is extended till then.
Cell number
Take it and
46.
place before the, this deposit before the registry. Yes.
Cell number 46. Adab Singh Kapoor.
The petitioner's, the council is on VC.
Yes, Ladyship, this is actually a case in which I have sought for the early hearing of and time-wise.
No non-compliance of office objections. What's happening to that first?
Ladyship,
That's how it has come up. It has come up in orders today.
Ladyship, the point is that non-compliance at para 31 and 32 is the way it was filed in the guardianship petition. It's a guardianship petition. Those 2 paras are missing in the original petition itself. And that same petition was filed right up till the apex court in the same fashion. So there is no such para which is missing.
What is the office objection?
The office objection is on the point of paras being missing. Para 31, I shall read it out. Yes, it says that para numbers 31 to 32 of Annexure A to be filed. Now, Annexure A is my guardianship petition, Ladyship. And the para 31 and 32 was not even there in the original petition filed by the council at that stage.
No, it's not one objection. There are so many objections. Court fee of rupees so and so to be paid, jurisdiction to be stated correctly at cost title, address for service to be stated at petition, annexure and para numbers to be stated at verifying affidavit, age proof of deponents not tallying with the cost title, annexure to be mentioned at prayer, para numbers 31 to 30.
Yeah, this is para 7, Ladyship. 8.8
to be filed. Better copy of annexure A, B, C, D, F, and G to be filed.
that we have.
Copy of lower court
Okay.
records, all annexures to be filed. That's what are the objections.
Ladyship, then I have
My
the
lords, we
Ladyship,
have
give me-
complied with all the office objections as well, my lords, and that is a matter we did today. We have complied with all the office objections.
Yes, I was informed only para number, objection number 7 was the thing which had to be clarified.
Partly complied with the office objections.
Yeah, para 7, Ladyship, is point number 7 is the only one which I was told, Ladyship, because paras 31 to 32 of the annexure.
Where is annexure A?
Yes, Ladyship.
Page number?
Yes. Annexure A, yes.
Page number, sir.
Yes, I'm 28, Ladyship. 28. 28 to 51, yes. So Ladyship will see there is no para 31 and 32 in the original, and the language is fine, is a continuation.
Now, page number 42,
Yes, Ladyship.
para number 29, 30. Then when
Yes.
you come to para number 43, it is 33.
Yes, Ladyship.
That's what we were asking.
Ladyship, that is true, but this is the way it has been filed in the original petition itself, in the guardianship court.
Meeting with
This is
the-
what this defect has been raised 2-3 occasions by different courts, Ladyship. And everywhere we have said the same thing. The same guardianship petition was filed in the contempt.
Office objections at paras, with regard to para number 31 and 32 of the annexure to be filed is overruled as it is submitted with the learned counsel that what papers have been filed before the trial court, the same are filed before
Yes.
this court.
Yes.
And this court also perused para number 30, para number 30, and immediately after para number 30, the number is given as para number 33. It appears that the mistake of the number, the given to the paras. Yes. Yes, come post it for preliminary hearing tomorrow.
Leadership. Grateful.
Yes, next.
Cell number 47.
My lord, I'm appearing for petitioner. My lord, the office has raised two objections that I have not produced the acknowledgement for having served the copy on the council appearing before the trial court. My lord, I have served the copy.
For the respondent?
Yeah, I have filed my wakalat.
Yes.
And I am ready with the statement.
Demand draft bearing number dated for a sum of rupees
4 lakhs.
State Bank of India. That is also filed here.
Yes, my lord.
The petitioner shall file the DD. Is permitted to take back the DD and file before the registry. Learned counsel so and so submits that she is filing wakalat. She has instructions to file wakalat.
Yeah,
on
I have
behalf-
already filed it.
You already
today.
filed.
Filing
She
my
has filed
statement of
wakalat, she has already filed wakalat on behalf of respondent. Registry is directed to reflect her name. Pose this matter for admission for preliminary hearing. B group, I think it should come up in B group.
One more
Post-
thing, that this court has stayed all the proceedings in the criminal case. So the. proceedings-
Tomorrow. Yes, next.
Cell number 48.
My lord, and but the petitioner, the copy is sent to the council before the trial court, my lord, by RPD and also courier. And yet to be served on the recording, my lord. Notice,
It is stated that
the 3 weeks time, my lord.
Notice is to be served on the respondent. Pose this matter on 17th of September.
Cell number
Not
40
17th, 18th of September.
18th.
Yes, 49.
49.
For the petitioner, my lords, in this
Babu.
case, we have drawn the DD, my lords, but they haven't taken because we haven't furnished the certified copies. We haven't furnished the certified copies, my lords. We have received the
On
copies today.
filing of
If
memo
opportunity
for
is
having
there, I would
taken out
submit the
notice.
DD today, my lords.
Have you taken the notice from the council appearing before the trial court?
We have for the petitioner, my lords, in this case. We
That's
have
what you
served the
only have to
notice.
take notice, sir.
We have already submitted them the notice, my lords, in the last
Huh?
date. We have already issued the notice to the via court in the last date, my lords.
Have you filed a memo before this court?
No, yet not yet.
Do that.
Sure, my lords.
As per the orders passed by this court dated 15/7/2024, the council of the petition shall file a memo to that effect within a week's time. Pose this matter on 10
The
September.
extension of interim order.
Cell number,
Yes, 50.
cell number 50. Sriram V. Okay.
Not 50. No, come back to the passwords.
Pass over. Cell number 5.
In that.
Advocate is appointed in your case.
Manjula D.
Advocate is appointed in your case.
Manjula D.
He'll tell you.
Head Legal Services.
Yes.
Cell number 5. Passed over matter.
Pay for the appellant's counsel.
Kiran Gowda M.
Yes.
It's
Any synopsis, and all the documents filed by the plaintiff and the defendants, the trial court.
Pass on. Yes.
we are also filing a memo along with the documents that was filed.
Yes. Take that one. What is the
Not suit for bare injunction. Notes with regard to access to a 4 feet passage. Notes through my vendor's property, notes to my property. Now, notes the suit is for bare injunction. We had the benefit, notes of an ex parte interim order of injunction. Thereafter, notes IA has been decided. My application, notes for temporary injunction has been dismissed. Challenging that, notes it's the plaintiff's miscellaneous appeal.
Who is the defendant?
Notes defendant, notes is the owner of the adjacent property. Now, my lords, in the compilation that we passed on, there is one sketch, my lords, if I can take my lords to that.
Give that. Here it is. Page number.
Lords, page number 40, my lords.
Yes.
Lords, in page number 40, there is a 30 and 31, my lords, are two site numbers. 30 and 31, the entire, my lords. My lords, the width 33 by 105 is the total length, my lords, 103 of the entire property. It was a composite property, my lords, owned by one person. Thereafter, my lords, the back portion, that is door number 31, that has been purchased, my lords, by the plaintiff. My lords, behind that, there is a conservancy lane. My lords may see a lane on the left side. That is a conservancy lane, so it cannot be used as an access. My lords, on the right side of the page, just below the page number 40, Sheshadripuram first main road is the main road. Now, my lords, there is a small gate there written, my lords, get it. From there, my lords, I have a 4 feet passage which is access to my property. Now, my lords, this entire front portion, that is door number 30, the entire portion, my lords, has been purchased, my lords, by the defendant herein. In between, my lords, what had happened was, one,
How do you reach the main road?
well, it's main road through this passage itself.
Oh, you will come to this passage?
And reach the main road. So this passage, my lords, is my access. This passage is my access. Now, my lords, what happened was, when the defendant herein has now purchased the entire scheduled property, my lords, from different vendors, because the front portion, beside the passage, there is a shop, my lords. My lords, there is a shop. There are two shops in front, but only shop G+2 is there, only shop that was purchased by one person. And in that sale deed, my lords, there is existence of this passage that was shown. Thereafter, my lords, he has sold it to another person, and then that portion also is purchased by the defendant herein. And the other portions of the property, the entire door number 30, my lords, is also been purchased by the defendant. After the defendant purchased the property, my lords, they were seeking to, they have obtained a plan for demolition, my lords, and reconstruction. And my lords, they have demolished the entire building that was existing, old building that was existing. And from that point in time, there is interference, my lords. We are not able to access this portion.
That property.
Please, my lords.
Your vendor is the owner of the entire extent.
Please, my vendor, my lords, was the owner. One Subbamma was the owner of the entire extent.
What way that sale deed is filed?
Lords, that sale deed is filed. Lords, that is one composite property. Subbamma was the owner of both the properties.
When was it first sold in two portions?
Lords, the first, the 1991, my lords.
1991. Subbamma sold in 1991.
Please, my lords. The front portion was sold. The one
back portion, she was having it.
She was having it. Then it was.
He did not sell the whole thing.
No. I will complete. I will complete.
That's what he's saying.
I will complete.
You can submit. Let him.
No. Let them reserve the right to reply, my lords.
Not sell the whole thing. That's all my suggestion.
No, that's what you.
That's what I said.
Only half of it is sold. That is 30 is sold. Not 30.
No. Portion, front portion, that shop portion.
Shop.
Not even half.
Shop portion.
Lords, can you allow me to complete, sir? Lords, the first sale deed, my lords, of 7/2/1991 was in respect, my lords, of 25/10, that shop portion. Thereafter, my lords, on 18/4/2007.
Yes.
The portion which site number, door number 31, my lords, was sold to me by the son of Subbamma. That is the back portion. Then, my lords, we got an approved layout plan on 25/9/2009, wherein, my lords, this passage is shown as the access to the main road. That is the next document. Lords, in the meantime.
When did the defendant purchase?
Lords, the defendant purchased the property under two sale deeds, my lords.
One is that 1991.
On 27/2/2020.
27/2.
2020.
Oh, he has purchased this door number 30.
Please, my lords,
Hmm.
except the front shop portion.
That was already sold in the year on 7/2/1991.
That was sold to some other person.
Not the defendant.
Not the defendant. And defendant purchases it, my lords, on 21/3/2024.
From whom?
From one Srinivas and Narsimha, 2 people.
Then when did Subbama sold this to them?
Not Subbama sold this. Not 14/2/91.
Hmm.
Subbama sold it, my lords, to one Sampath Kumar. Sampath Kumar in turn sold it to Srinivas and Narsimha. And in 2004, my lords, 2024, defendant purchases the front portion. That is the shop portion. Before that, my lords, on 27/2/2020, defendant has purchased, my lords, the other portion.
This sketch you filed, what
Please.
is prepared by you?
Not sketch that has been filed by us. Please, my lords, this is a prepared by us. Now, my lords, one interesting fact is the defendant's vendor who filed a suit against me seeking for a mandatory injunction to close that passage. That suit is pending as on date. Now, defendant steps into the shoes of her vendor, but defendant now is denying me that passage. And my lords, I had the benefit of an ex parte interim order of injunction, temporary injunction. Now, my lords, the trial court has dismissed my application.
What has happened to the suit? Which year that suit is filed?
My lords, that suit is filed. That suit is pending, my lords, at the stage of evidence.
Which year is that?
Lords, 2018, my lords. 5018 of 2018.
Any order is passed, any interim order in that?
No, my lords.
No interim order?
No interim order.
When did this defendant purchase?
My lords, defendant purchased
2020.
on 2 dates.
On 2020.
Please, my lords. 27/2/2020.
Hmm.
And it was during the pendency of
Is that part of this compilation?
Please, my lords, at page
The
number
suit filed
28.
by the vendor.
Page 28
28 of the same one?
of the same. Kindly see, my lords, page 33. 28 it starts. The prayer is at 33. Lalita Chandrasekhar, my lords, is the vendor of the defendant.
So as per this plaintiff, your vendor has accepted that this plaintiff is using the passage. That's what it is.
No, that's why your lordship will take my synopsis.
No, come to the document and read that document.
Sir, page 28 of our compilation.
Recently, during the month of June 2018, that you please read, para number 9.
Please. Para 9. May I read, my lords?
Yes.
Recently, para 9, page 32. Recently, during the month of June 2008, the defendant number 1 has opened a gate towards the backside of his property, directly into the plaintiff's property, which is evident in the photographs produced. The gate is fixed directly into the wall of the plaintiff's building. He is claiming a right to use the passage of the plaintiff's property to access First Main Road, contrary to the undertaking given by the defendant to build a compound wall as per final settlement dated so and so. The defendant number 1 along with defendant number 2 is a relative of defendant number 1 are threatening the plaintiff to remove the water tank from the passage. The defendant number 1 does not have any right to use the passage of the plaintiff's property, yet they are using their muzzle power to cause disturbance in the plaintiff's property. Frequently, they get into quarrel with the tenants of the plaintiff. My lords, in one of the sale deeds,
I understood them.
Please.
Let us hear.
Make a submission. In the sale deed as purchased, your lordship, there is no mention of passage. Your lordship will kindly see, he purchased it.
Now, as of now, everything has to be decided by the court after a full-fledged trial. What is his right, whether he's having right or not.
All that is considered by the trial court. If your lordship permit, I read only 2 paragraphs in the trial court.
Yes, please come to that. Yes.
Draw your lordship attention to page 29, internal page 18.
Yes.
Paragraph 59.
Yes.
Subsequently, Srimati Lalita Chandrasekhar has sold the property number 30 in favor of the defendant, along with the B should be purchased. The plaintiff's right to use the purchase has been denied by the required owner by way back in the year 2018. In the suit in voice number 50 of 2018 was filed. Thereafter, the plaintiff did not seek any right for declaration.
This is correct.
Please.
This finding is correct of the trial court.
Lords, as I had the access to the passage.
No, no, you can't maintain a bare suit for injunction at all now. Because they have already denied that you have no right to the property.
No, my lords.
And they have filed a suit.
No, they have filed a suit seeking for mandatory injunction for me not to use.
There in that, they have already denied your title and to the property, that passage,
Please,
saying
my
that you don't have access to that.
They admit,
So how can a bare injunction suit be
I'll come to
maintainable?
that. They admit 2 things. Number 1, that I had access to a passage, that I have put up a gate. Now their entire suit in that case was, they are denying it, they are denying the right of the passage, my lords, after the purchase. But on the basis, my lords, of the, if that was the case, they could have, they are saying that they had kept a water tank there. So therefore I was trying to remove the water tank. It was a suit, kindly see the prayer in the suit. It is a suit for mandatory injunction to remove the gate. I had access through a gate.
No,
now,
in
please.
the suit for mandatory injunction, they've already put forth their case.
Please, my lord.
Saying that you are not, you do not have any right to use that.
They put forth their case, my lords. Matter is.
No, no,
please.
that is there. That will be
Please.
decided by the court. No,
Please.
you have filed a bare suit for injunction.
No, my lords, during the pendency of the suit, 2 things happen. During the pendency of the suit, my lords, the larger portion of that property, door number 30, is purchased by them. And my lords, in the smaller portion where their vendor sold, when they purchased in 2024, what they do, my lords, in the respect of the smaller portion in their vendor sold it, there is reference to this passage. But while they purchase it in 2024 during the pendency of that suit, they don't show the passage in their sale deed.
Not about his, even his vendor has filed a suit.
No, his vendor has filed a suit, but in his vendor sale deed, there is existence, right? The northern boundary is shown as a passage. But while they purchase it from their vendor.
Let us see that document.
Please, minutes. Notes, this is at page number 795 in my compilation.
Page number?
95.
Yes.
And the schedule is at 105.
Yes.
My lords, I'll just read the boundaries, my lords. This is the shop situated in the ground floor. This is 25 by into 10. East by first main road, Sheshadripuram. That's the immediate road. West by private property belonging to Subamma, the other side, my lords. North by, this is the northern portion, passage. And thereafter property of respondent number, property of 32 belonging to late. That is the next property after the passage. Now kindly see the sale date. This is by Sampath Kumar, who had purchased it from Subamma to Srinivas, my lords, and Narsimha. Now when Srinivas and Narsimha sell this property to the defendant herein in 2024, during the pendency of that suit, the document starts at page 134. And schedule, my lords, is at 148.
Yes.
At 148, my lords, B schedule is this property. north by, bounded on, east and west is the same, north by property of Shilpa Prakash Angadi, that is the defendant's name is shown. But kindly see the sketch at page 150.
Yes.
Passage is shown, my lords. There is a passage on the left side. What they have purchased is that rectangle portion in the just adjacent to the road. And beside that there is a passage and then the main property starts. But in their vendor sale deed, there is reference to this passage. But while purchasing in 2024 during the pendency of that suit, they don't show the passage as the northern boundary. And what they do, my lords, is now they get this entire khata amalgamated. Now the entire building is demolished. And that is where the interference starts. Till that time, I was not, even, my lords, when my vendor filed a suit, Lalita Chandrasekhar filed a suit as against me in the year 2018. My lords, they did not have any interlocutory, any temporary orders as against, interim relief as against us. But I was enjoying this the beneficial use of this passage till, my lords, they demolished the entire property. And now they have, and there I'm not been allowed access to this passage. So therefore, I had to file a suit.
We'll
And
continue reading it.
there is one more, my lords, interesting thing. We were able to, this was not part of the trial court document. We were able to get a deed of amalgamation that the defendant has executed.
Please continue reading from there, page number 19.
Please, ma'am.
The entire plaint, the
Please,
plaintiff's
I'll
claim is
continue
not
reading.
based on easement. Page number 19.
19. Well, it's internal page 19 of
The order.
order.
In the entire.
In the
plaint.
entire plaint, the plaintiff claim is not based on easement. His claim is based on the passage left by the erstwhile owner while selling portion of the property to one Sampath Kumar. Either in the sale deed of Sampath Kumar or in the sale deed of the plaintiff, there is no prima facie recital about the said passage to use by the plaintiff to gain access to his property. The defendant has produced the photographs. Admittedly, A schedule property towards the western side, there is a conservancy lane. Facing A schedule property, the photographs produced by the plaintiffs would depict that the plaintiff's house constructed in A schedule, elevation is towards conservancy. He has also made provision to park his vehicle. Subsequently, dispute arose between the parties. The survey also conducted and measured the A schedule property and the defendant property. As per the report of the Assistant Executive Engineer BBMP dated 13/5/2024, as per the sketch, the plaintiff has encroached a portion, an area measuring 2 into 33 in the property belongs to the defendant. Therefore, prima facie, the plaintiff has encroached the defendant's property and sought for temporary injunction by suppressing material fact. The defendant, after purchase of the property, has dug a borewell and excavated mud to the depth of 5-6 feet in the entire extent of property number 30 and appears to have taken steps for footing to raise pillars. It appears after obtaining temporary injunction, plaintiff has constructed compound wall and plastering work has been done as it could be depicted from the photographs. No doubt, as per BBMP bylaws, the conservancy cannot be used as an access. However, the plaintiff building elevation towards conservancy put up a gate, made provision for parking vehicle and using the said conservancy to gain access to his property. Thus, prima facie is not used the B schedule property to gain access to the A schedule property. Under the circumstances, the plaintiff failed to make out prima facie case and balance of convenience is not in his favor. If the order of temporary injunction is not granted, he will not be put to any hardship. As such, answered point number 1 to 3 in the negative. Now, my lords, for demonstrating the prima facie case, their entire case was behind my property, there is a conservancy lane. In terms of the BBMP bylaws, my lords, conservancy lane cannot be used, my lords, as a road access. That is the law. There cannot be any estoppel against the statute. Now, my lords, it is their case that I have access to conservancy. Let him use that access and there. But the fact that your vendor, even your own documents show that there was existence of passage.
What is this finding that you have encroached the land?
Lords, what they're saying is the assistant. If my lord sees the sketch. Measurement was made. Now, my lords, the entire property was there. I was put in possession, my lords, long back, and I had built up my door number 31, my lords, on the basis of a sanction plan. I put up construction. Now they are saying that the width of the property is 33. There is a 2 feet encroachment to that. If that is the case, my lords, then they have to file a suit, or we have to give it up. That is a different aspect of the matter. I don't know why that was bought. That was not even an issue. The issue is with regard to the passage. Now, my lords, a report is called for. Insofar as this passage is concerned, except that, well, let's kindly see page 40 for a moment. I'll show where encroachment they're actually saying.
40 of what?
40 of my compilation.
Yes.
Well, let's at 40. Lords, the entire composite property measurement is 33.
40 years.
Please, my lords. 33. If my lords is just beside the lane, there is a measurement shown of 33 feet. Then, my lords, on the top of the page, just on running the entire length, the length is 103, the entire composite property. Now, my lords, I was sold 33 into. My lords, I was sold 33 into 40 by the original owner. That is my portion. That is door number 31. The rest of the property, my lords, belongs to them. All I'm claiming, my lords, is for a 4 feet passage from here. Now, my lords, their trial court places reliance on a report with regard to a BBMP stating that I am in excess by 2 feet across the length in the other way around. Now, my lords, in a composite property, if there is division, and my lords, if a compound wall is put at particular point, and there is a my lords, issue with regard to measurement there, that issue cannot be used, my lords, to non-suit me, my lords, in so far as that is not even an issue there. How can you non-suit me, my lords, on the basis of my issues, my list is with regard to the passage? Now, my lords, if according to them I have encroached, that is a different cause of action for them to take possession in accordance with law. If 2 feet actually I have encroached there. Now, my lords, they have kindly see the next plan, my lords, for a moment. The next page. Page 41. Lords, this is the sanction plan that was granted to me by the Broad Bangalore Managra Palike, after which, on the basis of which I have made construction, my lords, of the property. Kindly see, my lords, just on the right side, there is a seal, my lords, duplicate. Below that, there are some seals. On the left side of that, there is a small sketch, my lords, which shows a common passage.
Where do you get that?
My lords, on the right side of the page, we have this seal is there, duplicate. Below that, my lords, on the left side here. On the left side, that is the sketch of the property. Now, my lords may see conservancy lane is there. This is not to scale. Conservancy lane is shown, and then site in question is marked. Then there is a common passage, and then the first main road is shown. And then kindly see the left.
Year was this?
Please, my lords.
Which year was this?
This was in 2009. 25/9/2009.
Where will you see the passage?
My lords, passage is.
No, there is that duplicate. After that, some signatures are there.
On the left side of that, there is a small sketch.
Site in question, common
site in
passage.
question.
Common passage.
Then conservancy lane is shown on one side, and then the first main road on the other side. Then my site is shown. Then along my site, then the common passage. Though it's a 4 feet passage. It's a very small passage. Compared to the site, it's a very small passage, but in the sketch, it's shown like that. Now, my lords, on this side also, this also may kindly be seen. Same thing.
Common passage.
There is a common passage that leads, my lords, to the first main road. And their own documents also show there is an existence of a passage. My lords, therefore, their vendor suit is pending as against me. And now, my lords, therefore, my lords, I'm entitled to temporary injunction is what I'm saying. Lords, one fact may just, one additional, I'm sorry, my lords. Lords, we have just got one document, which is a deed of, now the defendant purchased it in multiple, lords, in under different sale deeds. So she has now gone for a sanction plan after amalgamating the entire, all the other sites, lords, with regard to the property number. A deed of amalgamation that was registered by the defendant, we're able to secure it, lords. It's not part of the trial court record. I just pass it on, lords. It shows existence of a passage in our own document. It is of 25/3/2024. And this is unilaterally executed by the defendant herself as a deed of amalgamation of her own properties for the purpose of securing a plan. If my lords may see this document, now schedule C, item number 1.
Let him say what.
Please.
Yes.
When I come to my office, they pay me 55, then I take period.
Yes.
I'm giving from para revenue. The plaintiff has delayed upon your few steps for construction of the building in the year 2009. Paying common pathway is going towards north of the property. According to plaintiff, by showing the common pathway, then only the BBMP authority has granted sanction to construct the house. First of all, the first sanction plan is not attested by the SQL owners. The SQL owners are not party to so far alleged
common as a concern. Therefore, premises is said that approved plan cannot be essentially binding on this owner. The premises are trying to confirm and be dated 5/11/2008, executed by legal heads of the late legislature, confirming the sale is executed by legislature in the complaint. In the said sale, also there is no premises reference about the use of in fashion is proper. The defendant has scheduled a settlement deed dated 5/11/2008. It was executed on the date of the execution of the confirmation deed by the legal case of the legislature. Plaintiff has not referred to such settlement deed in the plain or proceeding copy. Thus, the plaintiff simultaneously withheld the important material document and suppressed the existence of the settlement deed. The plaintiff is secreted the settlement deed. In page number 3, paragraph 2 of the settlement deed reads as follows. Whereas the intention of the settlement, the second party specifically agrees and undertakes to raise the at least for the ceiling height along 33 feet from north to south along the east side of the said property. Therefore, it is 40 feet from east to west measured on the said property. Very useful number 3. It and K in a walk in the 27 first main road sector of Bangalore. At the point of demolishing of the existing building at number 31 and or within 2 months of its agreement. So by virtue of the amount that decided, the plaintiff the rate of access to this property has been accorded. The plaintiff has not questioned said to be so far.
The settlement deed is executed by whom?
Both the parties, my vendor and him.
He is a party to that settlement.
I have produced that your lordship in the documents I have produced.
Yes.
Your lordship going to take compilation documents.
Yes.
Page 105, your lordship.
Take away that process from the continuously found. 105.
505.
Yes.
When this deed of confirmation is made and executed on this 15th day of November 2008 at Bangalore. They are all
Petitioners, the plaintiff's name is?
Plaintiff's name is Kumar Raja. You will find it, at 1006.
Kumar Raj.
Herein also referred to as first party, which comes the mean and include the legal in favor of Kumar Raja, son of so. Perumal said, and here in also referred to as second party, which comes the mean and include the legal and so. In final segment, in consideration of the final segment, the first party received 11 lakhs in the following manner. 18/4/2004 executed by the first party. Where the included in segment is 10 parties specifically agreed and undertakes rising a three-quart in ceiling height along 13 feet along the east side of scheduled property, including 40 feet from east to west measured on the said scheduled property. Bearing municipal number 31 situated being ward number 27, first kind of data from Bangalore, 5,020 at the time of demarcation number 31 or within 2 months of executing this. This is what has been extracted by the learned in that order. And
So as per that, the passage shouldn't be used and you should construct a wall.
then you will also be trying to see there was never a passage. You will also be trying to make out a case for a passage. In that respect, I am drawing your lordship attention. One of the letter written by the father of the plaintiff in the BBMP that has to do with your lordship.
Yes.
Yeah, 120.
120? Yes. This is written by the plaintiff's father to the BBMP.
Yes.
What is the crux of that?
The subject is, this is written on 9/7/2018. That is the date you are. They said, I have kept a water tank in the passage, we are not able to use the passage. That's what he says. This is 9/7/2018, your lordship. Then your lordship will kindly see, and notice was issued on the basis of that letter, and I have replied to that lengthy letter.
It's
Then
122. 122.
Yes.
Is your reply?
Yes, sir. Then I come to your lordship for page 128, your lordship. This is an endorsement given to me by the engineer who says that there is no passage in the page 129. 13 Sankhya, your lordship, page 129.
129 is what?
This is the endorsement issued to me by the estate engineer of the BBMP, stating that he has measured the property and there is no passage. That is clearly he has stated that. This is on 13/5/2024.
Yes.
ಸಂಪರ್ಕದಾರಿ ಪ್ಯಾಸೇಜ್ ಏನಿದೆ ಎಂಬ ವಿವರದೊಂದಿಗೆ ಮಾಹಿತಿ ಒದಗಿಸಲಾಗಿದೆ. Your lordship will kindly see another aspect which I want to give your lordship consideration. And page number 29, 139 ಒಂದು ಸ್ಕೆಚ್ ಮಾಡಿದ್ದಾರೆ ಇಂಜಿನಿಯರ್ ಅಸಿಸ್ಟೆಂಟ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್. ಅದನ್ನು ತಾವು ನೋಡಿದ್ರೆ your lordship will kindly see conservancy road, conservancy open to 30 feet road. The right side your lordship.
Is it?
The conservancy road which you cannot, is 130.
Page number?
130, next page, 130. Sketch prepared by the assistant executive engineer, Gandhinagar subdivision. The area says conservancy opens to 30 feet road. This is conservancy, 30 feet road. Therefore, this 30 feet road is there, and that is what the trial court get observed. There is a gate left, he uses this road, not the first way station Viparam. And your lordship, all this happened in 2018. And your lordship, that's why your lordship will kindly say, what he is trying to do is now. And if I can submit your lordship, your lordship will kindly say, interim order was vacated on 5/7/2024. MFA was
5/7/2024.
MFA was filed on 12/7/2024. First time MFA was moved before your lordship on 19/8/2024. Why he waited is, giving a complaint against me to the BBMP, he wanted to have a demolition, he filed a petition. That petition came to be closed. Thereafter,
Why it is closed?
it is closed because your lordship, he wanted one thing, that BBMP should find out whether I am constructing the building in accordance with my plan. My construction is in the first floor only, whereas his 3340. What he purchased is 3340. He has constructed 5-floor buildings, which is not entitled. 3340 is the best is entitled for ground floor, first floor and second. 5 4-floor buildings, only to put me a pressure to agree for all this, he has initiated the proceedings in the BBMP. BBMP has given me a notice and I have replied with him. After he paid in that decision, he moved this MFA. And your lordship, I have constructed first floor, I have everything the photos. These photos was taken on 17th August 2024, the dates are there.
What is this photograph at 137? What is this photograph at 137?
Construction of this compound walls.
Construction of?
137 you will also.
Hmm.
The 5-floor buildings he has constructed and the road which opens I brought your lordship consideration. Not only conservancy.
No, the passage which you are referring to from, you will find from where? Passage which is referred.
There is no passage.
No, if at all, this alleged passage,
Behind this building.
this which is in orange color.
Yes, your lordship, orange color building is constructed by him. Behind that, he said there is a passage, because behind that only my property comes. From there it is a passage. If I.
No, but shops and all are adjacent to your property. That is not.
Your lordship, kindly see.
I think this is your property.
This is my old property which I have demolished. Now I
Ah.
am constructing.
Correct. So this orange is your property.
Yes, that is-
Old building it was demolished.
Yes. Yes. Then what is it? It's all demolished now.
Yes, you are. I have demolished, now I am constructing. And the letter written by the plaintiff's father to BBMP 6/7/2018, which I read to your lordship, there it clearly says.
Come to this 140.
Yes, sir. If we have demolished it, the adjacent building is better.
Where is the plaintiff's building? That's not seen in this picture.
142.
142.
I'll show, I'll just show. 142 may kindly be seen.
142.
That's
He has
142.
constructed a compound wall.
The house,
Model is constructed this compound wall. 5 buildings your lordship, he's trying to put a gate there, because not removed. That is what was observed by the trial court. After obtaining entry model, that is what he has done.
Lords, 142, I'll explain according to us. 142 may
What
kindly.
do you say about the settlement date?
Lords, insofar as the settlement deed was concerned, Lords, what had happened was after I purchased the property, the original vendors, my lords, children started raising dispute. So, my lords, there was a confirmation deed that was executed, my lords, by the children of the vendors by taking money. In the confirmation deed that was registered, my lords, the consideration was not shown. So, a separate settlement deed, my lords, was executed. In that settlement deed, my lords, one clause was incorporated that I should just build a wall there. There was a gate that was in existence.
No, if you build a wall in between on the northern side,
Please, my lords.
then there is a question of accessing it.
No, my lords, with the gate, with the existing gate is there, they wanted.
Please read it again. Let's
Please.
read that.
Please, my lord.
Number.
Lords, but can I just show 142 for a minute, my lords? Because that will give the context of the settlement deed, 142. Because the photographs, I just want to give the correct picture, my lords, of what exactly is on the ground there.
Yes.
142.
Yes.
If my lords see 142, my lords, the dug up portion is seen there.
Yes.
That is the portion, my lords, where they have already dug up, and that wall that was constructed, according to us, it is constructed by him as a retaining wall. The portion, the constructed portion, my lords, behind that is my property, the back portion. And I had access to this portion through a passage here. And the existence of the passage, my lords, as it was earlier when the building was there, my lords may kindly see this. That was how the passage existed, my lords. That was how the original passage existed. It runs through the entire thing.
Whose property is this?
Plus, that was a property, my lords. That was the front portion.
This one.
This passage was from the main road to the back of the property, my lords, on the back side. That is my property. Now, what he does is he has purchased the entire front portion. That 4 feet passage, if he leaves out, that has to be left as an access to my property, because conservancy cannot be an access. Conservancy by law cannot be an access. So there cannot be any estoppel as against.
Why your house is facing that conservancy?
Lords, that, my lords, as per the plan, they have taken the plan, my lords, plan was taken and they have constructed it, my lords. But I need access to the property to the main road itself. That 4 feet is what I have
Oh,
access.
From any property, there should be some source of title.
Please,
to have an access, to have a road or anything.
Please, my lords.
Just because there is something on the front side of your land.
Please, my
you can't access it. It cannot be accessed from somebody's land.
No, my lords,
No, that's why. With all
from
this,
day one, it was.
with all these facts,
Please.
not day one, please come to that.
A confirmation deed.
Yes, very
Please.
good. Page number?
111.
Confirmation deed mechanisms, 111. Now kindly see the parties for a moment, my lords.
Not 100.
No, not my, their compilation. No, the same thing, my lord, same thing, 111. Lords, parties are, my lords can see the parties. Lords, Girish C. Balola, they're son of late Chandrasekhar, and the other brothers, my lords. Kindly see serial number 5 is Lalita Chandrasekhar. She was a plaintiff. Now, my lords, Kumara Raja, my lords, is the plaintiff. Now, kindly see, I'll just read, my lords, the recitals at page 112. Whereas the first parties are sons and daughters of deceased Chandrasekhar to inherit the estate of the deceased left by him. Whereas the deceased father of the first party is late B. Chandrasekhar, executed an absolute sale deed in favor of the second party through a GPA dated so-and-so in favor of B so-and-so on 18/4/2007, which was entered before the sub-registrar of Gandhinagar in so-and-so. With property, the municipal number 31, situated at BMP Ward number 27, First Main Road, Sheshadripuram, Bangalore 20, more fully described in the schedule here and below. Whereas late Chandrasekhar acquired the scheduled property through his mother as only successor, as his mother acquired by way of purchase through a registered sale deed, bearing document number so-and-so, dated 12/10/1946. Whereas a settlement was arrived at between the first parties and second party after the death of late B. Chandrasekhar. Whereas in view of this settlement, the first parties agreed to confirm the sale and to relinquish the right in the scheduled property and release themselves from any claim and confirm the sale executed by their father's GPA in favor of the second party. This is the context. Now, my lords, the main portion, the addendum clause. Now, this deed of release witnesses as follows. It was basically a release deed, my lords, by them. The first parties do hereby confirm the sale deed executed by their father through GPA dated so-and-so in favor of Bri Prakasham in favor of the second party and registered as so-and-so pertaining with property, the municipal number so-and-so, release themselves from all the rights in the scheduled property and they are relinquishing all the rights without any kind of ambiguity in favor of the second party. The first party hereafter has no claims in any matter towards the second party pertaining to the scheduled property. No consideration is part between the parties for executing this deed of confirmation. Now, my lords, kindly see the schedule also. Schedule, my lords, refers to 40/33 property, that is municipal number 31.
It doesn't refer to any of those passages.
Any of those passages. Now, kindly see the document that they have read, that is the final settlement deed at page 105. This is the document on which reliance is placed. Now, this is an unregistered document which is produced by them, my lords, along with the written statement. Final settlement deed, same parties.
This is approved by you. Which
Please,
is
my lords, I have signed
accepted
this.
by you.
I have signed this, but I'll just show what is the tenor of this document. I'll come, my lords, straight away to my lords, in page 107.
Yes.
My lords, the third recital. Whereas in view of this settlement, the first parties agreed to confirm the sale and relinquish the right in the scheduled property and release themselves from any claim and confirm the sale deed executed by their father through GPA in favor of the second party. Final settlement witnesses followed. In consideration of the final settlement, the first party, that is received, they have received rupees 11 lakhs in the following manner, in addition to the sale consideration of the sale deed dated 18/4/2004, executed by the first party's father. Whereas in fulfillment of this settlement, the second party specifically agrees and undertakes to raise a brick wall to ceiling height along 33 feet from north to south along the cast side of the said scheduled property, enclosing 40 feet from east to west measured on the said scheduled property, bearing municipal number 31 situated at so-and-so, at the time of demolition of the existing building at 31 or within 2 months of executing this agreement. Now, kindly see.
You said about some gate, it is not here.
Please, my lords.
You said that you will place a gate there.
No, we had a gate there.
No, but it says that now you should close it.
No, that is what it says, paragraph number 2. Now, 3 and 4 may also be seen. The first parties have no objection in the second party in obtaining the Kata BBMP in favor of the second party without causing any delay. the first party shall withdraw the case bearing number so and so pending before CCH-20 Mayolo unit filed by the first party's father against the father of the second party, and deceased vice versa, the second party shall withdraw the case pending before. This was in respect of the sale.
So again, schedule is shown.
Again, schedule is shown, my lords, 40/33. Now, my lords, on the basis of this settlement deed, now, my lords, there are two documents. One is a registered confirmation deed, whereby, my lords, they have confirmed my title to the property after taking a consideration. Because consideration was not shown in the registered document, my lords, an unregistered document was executed.
Even in that document also, your passage is not shown.
In my schedule, my lords, I will be fair to the court, and also it is borne out of record that in my documents, my lords, passage is not shown. But in the documents of the adjacent property, on the basis of which I am claiming properties, in their documents, passage is being shown. And not only that, the suit was filed by Lalita Chandrasekhar seeking for enforcement of this settlement deed, stating that I have not closed the passage. Kindly see the suit that I just now read, my lords. Kindly, for a moment, my lords, I'll just take my lords to that document. The compilation I had filed, my lords. Sorry, my lords, you are making my lords juggle compilations.
Yes.
Page 28, my lords.
Yes.
In page 28,
yes.
Lalita Chandrasekhar is the first party, number 5 in that case, and my lords Kumara Raja. Now, kindly see, my lords, the prayer in that, my lords may also see the prayer at 33. There was a gate then. At 33, my lords, get it, my lords. A judgment and decree of mandatory injunction directing the defendants to remove the gate fixed by them in the plaintiff's property and further build a compound wall to close access from the defendant's property to the plaintiff's property. A judgment or decree of permanent injunction restraining the defense or anybody claiming under them from interfering with the plaintiff's peaceful possession
So
of the
what do
suit.
you say about, what do you say about this deed of settlement?
My lords, this deed of settlement was executed, and my lords, thereafter, my lords, I had not closed the gate.
Right.
My lords,
This is an agreement, either you should deny it.
Please,
or
my
that
lords.
you have not signed.
No, my lords, we have in the written statement that was filed in 2018, at that point in time itself, it was denied. And my lords, the suit is pending. Now, my lords, the gate is in existence. It is born out of her own, their vendor's own pleadings. Now, the passage, I had access to that passage also is there. Enforcement of settlement deed suit is pending as on today from 2018. The matter is still at large before the trial court. Now, my lords, I had the benefit of a passage. Now, subsequently, my lords, the vendors purchase, and in respect of the front portion, my lords, where that shop portion was purchased, 25/10. There also, my lords, existence of passages.
So about the settlement.
Please, my lords.
Have you stated about the settlement with the.
My written statement is also there, my lords. My lords, in my plaint, I have not stated, but I have stated about this suit in my plaint. This suit.
Not about all these, the respective.
We have stated about confirmation deed. We have stated about the confirmation deed, my lords. Regarding settlement deed, we have not stated anything in the suit, but in my plaint, it is not stated. I have stated, my lords, pendency of this suit has been stated in my suit. So the fact that this suit is based on, my lords, the settlement deed itself, my lords, has been stated, but the settlement deed per se has not been, the word settlement deed has not been used in the plaint, my lords, in the suit papers. Now, my lords, my submission is this. Now, my lords, as on today, my lords, insofar as the existence of a passage is not in dispute, now kindly see the amalgamated deed. Now, the sketch they had shown, my lords, for a moment.
Not see the document which is not part of.
Please, my lords, therefore, my lords, I put it, if the court, my lords, it was not part of the pleadings before the trial court.
Look into it.
Please, my lords.
The legality of the order.
Kindly now see their compilation of documents, my lords. Just 2 documents I will show. My lords, they refer to an endorsement of at page 128 of the BBMP. Now, my lords, they are saying that a sketch has been prepared at page 130. Kindly see that sketch, my lords.
No, I'm, while passing this order, I'm not going to consider all that.
Please, my lords. Lords, the
BBMP things I'm not going to consider.
Please, my lords, because it is they might have got it done, and my lords, it is on this sketch a finding is given by the trial court that I have encroached 2 feet.
Yes.
It is, but in this sketch, kindly see the passage at 130. That passage is there, but the trial court says my lords, for a moment, just I'll show, my lord, because this sketch has been relied upon by the trial court. At page 130, my lords, 2 feet encroachment, the fact that there is a 2 feet encroachment is put against me. But the fact that, my lords, the passage is shown is not taken into consideration. Please, my lords. Lords, as on date, the position is this, my lords. The portion that they have purchased, the larger extent, my lords, they have demolished the entire portion. And my lords, the passage also, my lords, was demolished at that point in time. And therefore, my lords, at that point in time, the cause of action arose for me because I was using that passage. And my lords, I had the benefit, my lords, of an ex parte order of injunction. Thereafter, my lords, insofar as they are making allegations against me in respect of my plan, but that is a separate issue. Insofar as their plan was concerned, their sanction plan was suspended. Then that was challenged by them. And then there is an interim order of stay and they're proceeding with the construction. That is a different aspect of the matter, whether I have violated my building or he is violating in construction. So only thing, my lords, is even assuming for the sake of argument that 4 feet passage will always fall part of the setback because it is on the corner. So they cannot touch it for the purpose of construction. So therefore, my respectful submission is, if there is a direction, my lords, for expeditious disposal, my lords, until then, status quo could be maintained only insofar as the 4 feet passage is concerned.
Yes, number suit is of the year 2024, no urgency.
No, my lords,
For that to be
we
disposed
can, in fact, my lords, because the settlement date is of the case is of the year 2018. Both are, my lords, before the city civil court. In fact, my lords, both the issue that arises, because their defense is the settlement deed, a suit based on the settlement deed is also pending before the court by their vendor. Therefore, my lords, both the suits have to be tried together. For that, my lords, will file a miscellaneous petition.
What's happening? Continuously talking in the court. Don't understand they are disturbing the court. Yes.
Please, my submission, my lord, says that both the suits, in both the suits, the issue of passage is an issue. And their defense in this case is the plaintiff's case, my lords, on the basis of which they assert right in that case. So, my lords, we could take steps, my lords, for the purpose of consult. That is at the stage of evidence. My written statement has been filed. Only IA has been dismissed as of now. So, if status quo is maintained, my lords, issues could be framed, my lords, and we will take steps, my lords, because it's before the same court. We will file a miscellaneous petition before the principal city civil judge and seek for expeditious disposal.
Please come. Anything to add? Agreed with orders passed in I number 1 invoice number 2932 of 2024, dated 5th of July 2024. The plaintiff is before this court. The appellant plaintiff had filed a suit a suit for injunction restraining the defendant from interfering with the peaceful possession of the suit scheduled property. It is the specific case of the plaintiff that the property bearing old number 18 and 19, new number 30 and 31, First Main Road, Seshadripuram, Bangalore, originally owned by one Srimati Subhamma, who purchased the same in the year 1946 through a registered sale deed. The property originally measured east to west 103.5 feet and north to south 33 feet, bound on the east by First Main Road, west by Conservancy Lane, north and south others property. After purchase of the property, she constructed a building consisting of 3 floors towards the main road. Subsequently, out of the total extent of the building, she sold a portion of the building towards northeastern side of the building, measuring 25 into 10 feet in the ground floor, along with undivided share in the land in favor of one Sampath Kumar. It is the case with the plaintiff that while selling the property, the erstwhile owner had left 4 feet common passage towards the northern portion of the said property, that is towards northern side of the property, sold to Sampath Kumar to have access to the other portion of the building and also to the tail-roofed house constructed in the western side of the property, abutting the conservancy. Thereafter, her son had sold the western portion of the property which was having a tile-roofed house abutting Conservancy Lane, executed an absolute sale deed through his GPA holder on 18/4/2007 in favor of the plaintiff for a valuable consideration. It is the case that the existing passage from First Main Road was used as access to reach the soon scheduled property, which runs from east to west, having a width of 4 feet. As on one side of it, there's a conservancy lane. The same cannot be used for having any amenities, as the same cannot be treated on par with the road for any purpose. It is stated that after the death of Chandrasekhar, his legal representatives executed a confirmation deed with respect to the sale deed executed in favor of the plaintiff on 5/11/2008, thereby accepting the absolute rights of the plaintiff for the suit scheduled property. It is stated that after the death of Chandrasekhar, his wife, with an intention to extract more money from the plaintiff and also pressurize him to part with the property, started to give one or other trouble to the plaintiff by obstructing its way from the passage. When the plaintiff did not heed for the said tactics, she had filed a suit, case number 5018/2018, arraying the plaintiff herein as defendant, and she sought for a mandatory injunction, alleging false and concocted reasons, indirectly claiming rights of the Schedule B property. It is stated that the no interim order was granted by the court. During the pendency of the suit, on 27/2/2020, she sold the property towards the eastern side of the Schedule A property without any intimation to the court and without having any permission from the court in favor of the defendant herein. It is stated that in the said sale deed executed in favor of the defendant herein, the passage was not mentioned. Thereafter, the defendant herein had filed an implete petition in the said suit, and the same was dismissed. It is further stated that the plaintiff defendant, being a penalty-like purchaser, started demolishing the entire building. At that time, the plaintiff cautioned the defendant as to the existence of a passage and the water meter installed by the PWSSB. But the defendant has intentionally damaged the water meter and in fact destroyed the entire water connection. Then the plaintiff approached the jurisdictional police and lodged a complaint. But the police have not registered a complaint. It is stated that the cause of action for the suit arose on 17/4/2024, when the defendant started demolishing the building and damaging the garden properties such as water meter and restricted the movement of the plaintiff over the passage from First Main Road. And on all subsequent days, when the illegal acts continued, within the jurisdiction of the court. The defendant herein had filed a written statement. There is a written statement.
So long the compilation.
They are not filed in like.
That's the new compilation.
Along the FFA, they are not filed, only plain.
Where is it?
It's page number
Page number?
one, my
Page
lords.
number 89 is my comparison, page 89 to 91 euro. 92 to 104 euro, my return statement.
They have filed a detailed written statement. It is a case of the defendant that they have denied the passage as stated by the plaintiff that is existing. And they have stated that in the confirmation deed dated 5/11/2008, produced as document number 6, along with the plate, does not disclose about the least common passage as contended by the plaintiff. Even in the schedule of the body of the sale deed dated 18/4/2007 or the confirmation deed dated 5/11/2008, there is no mention of the passage as contended by the plaintiff. The plaintiff has access to his property from Conservancy Lane, abutting 30 feet road leading towards Second Main Road, which is situated towards the western side of the Schedule A property, and the same is being used by the inmates of Schedule A property building for their ingress and egress. The passage is exclusively used by the defendant and her tenants in the building that was purchased by the defendant under the sale deed dated 27/2/2020. They have also mentioned about the suit filed by their vendor seeking injunction, seeking mandatory injunction. And also about the confirmation deed dated 5/11/2008, which is a final settlement. As for the same, plaintiff should raise a brick wall to the ceiling height along the 33 feet width of his property, which delineates his property from the property held by the plaintiff and her children. Not the plaintiff, property held by the plaintiff in the other suit, that is the vendor of the defendant in this, and the children. It is stated that the vendor has put a water tank of 2,000 liters in the passage of her property, since there is no provision for a sump to provide water to the entire building. In the month of June 2018, the plaintiff had opened a gate towards the inside of his property, directly into the property held by the vendor of the defendant to claim use of passage, and said gate was fixed directly into the wall of the building that was held by the vendor to claim right to use the passage of 4 feet situated in the property. And they have also referred to the proceedings of the BBMP. It is the case that the plaintiff, taking advantage of the fact that the defendant had demolished the whole structure and had excavated mud from the property belonging to her in order to lay footing to raise pillars for constructing the building, rushed to the court and suppressed material facts to obtain an interim order from the court. And it is the case that the plaintiff had encroached the property, which is evident from the report of the BBMP. It is stated that the plaintiff has not come to the court with clean hands and is not entitled to the equitable relief of injunction. In the said suit, the plaintiff had filed IN number 1 seeking injunction. Where is that application?
So we had also filed a rejoinder to the return state, just to.
The plaintiff has also filed his rejoinder. Then where is the,
Page 42.
in the suit? IA number 1 is filed under order 39 rule 1 and 2 CPC to issue an ad interim order of temporary injunction restraining the defendant interfering with the Schedule A and B properties in any manner pending disposal of this. The said the IA came to be dismissed by the court by order impugned, wherein the trial court had observed that the plaintiff's right to use the passage has been denied by the owner, erstwhile owner, way back in the year 2019 in OS number 5018 of 2018. Thereafter, the plaintiff prima facie did not seek any right of declaration in respect of the B scheduled property till now. The present case is filed for permanent injunction. No doubt, as per the judgment relied on by the plaintiff's counsel, a suit for bare injunction without claiming right of easement is maintainable. In the entire plaint, the plaintiff claim is not based on easement. His claim is based on the passage left by the erstwhile owner while selling portion of the property to one Sampath Kumar. Either in the sale deed of Sampath Kumar or in the sale deed of the plaintiff, there is no prima facie recital about the said passage to use by the plaintiff to gain access to his property. Court has also referred to the report of the executive engineer BBMP dated 13/5/2024. And as per that, the plaintiff had encroached an area measuring into 2 into 33 in the property belonging to the defendant. The court has observed that the plaintiff who had encroached the defendant's property had sought for temporary injunction by suppressing the material fact. The court has also observed that after obtaining a temporary injunction, plaintiff had constructed compound wall and plastering work has been done as it could be depicted from the photographs. No doubt, as per the BBMP bylaws, the conservancy cannot be used as an access. The plaintiff building elevation towards conservancy put up a gate, made provision for parking vehicle and using the said conservancy to gain access to his property. Thus prima facie, he has not used the B scheduled property to gain access to a scheduled property. Under the circumstances, the plaintiff failed to make out the prima facie case and balance of convenience is not in his favor. If the order of temporary injunction is not granted, he will not be put to any hardship and accordingly dismiss the application. Filed seeking injunction. Agreed thereby, the plaintiff is before this court. Then a senior counsel appearing for the plaintiff submits that in the sale deeds of, he does not dispute the fact that in the sale deeds of the plaintiff, there is no mention about the passage. But according to him, in the previous sale deeds, there is a mention about the passage. It is stated that when the vendor of the defendant had filed a suit against the plaintiff seeking a mandatory injunction, stating that the plaintiff has erected a gate and using the passage, that itself shows that the plaintiff is having access to the same. And whether the right of the plaintiff and other things have to be decided during the course of the trial, and he is entitled for the injunction as sought in the IA. The senior counsel had drawn the attention of the court to a sketch that is placed stating that as per the sketch, there is a passage. Then he had also drawn the attention of the court to a plan which is of the year 2008. In that, according to him, there is there also, the plan also shows the passage. It is submitted that the passage and the plan of 2008 itself shows that there is a existing passage, and the plaintiff and the vendors have been using the same to access to the main road. It is submitted that if the plaintiff had encroached any part of the land belonging to the defendant on the other side, it is for the defendant to file to initiate appropriate proceedings, and that cannot be a reason to dismiss this application filed by the plaintiff. He submits that the encroachment as alleged and this is right to this passage are unconnected things. He further submits that if an injunction is not granted in favor of the plaintiff, it would cause irreparable loss to him, as he has been using the said passage from several years, and now if he is not permitted to use the said passage, his access to the main road is completely curtailed. Further, it is stated that the deed the confirmation deed is an unregistered document. When they have taken a plea with regard to this confirmation deed, that is the vendor of the plaintiff and the vendor of the defendant herein, they have denied the same. It is, but however, he do not deny the fact that there is a final settlement deed, which is a registered document. No, there are two things.
Confirmation is
Confirmation deed on the same day both are executed.
Confirmation is.
You agree final settlement because you stated so in your.
No, confirmation deed I have stated. About final settlement, I have not stated anything. In my written statement in the original, the 2018 suit I have denied.
About the confirmation deed, no, stuck off that. About the confirmation deed, they have stated so in their print. But as far as the final settlement is concerned, they have denied it.
In the written
In
statement
that
in 2018.
the written statement that is filed in a suit in the suit of mandatory injunction that is filed by the plaintiff's vendor. It is submitted that the plaintiff could make out a prima facie case and balance of convenience. And also, if the injunction is not granted, it would cause irreparable loss to the plaintiff. All these aspects were not considered by the trial court, and case that the appeal has to be allowed, and the plaintiff is entitled for injunction. Land counsel appearing for the defendant submits that the documents which he is relying on, that is a sale deed, which confirms which is his title to the property, do not contain the passage as stated by him. And even the settlement, the final settlement on which final settlement or confirmation is yours.
Confirmation.
Even the confirmation deed which he is relying on also do not contain do not show the passage. He submits that the trial court had rightly dealt with all the aspects. When the defendant's vendor had denied the title of the plaintiff to use the property, to use the passage in the earlier suit, now again he cannot come before the court and file a suit for injunction. Necessarily, if there is any title to that, he has to seek a declaration declaration to that property. Though they're talking about the easement, the relief that he sought is a suit for bare injunction. He had drawn the attention of the court to the settlement both to the confirmation deed and also the final settlement deed. And basing on clause number 2 of the said final settlement, he submits that it was agreed by the plaintiff that he will raise a brick wall to ceiling height along 33 feet from north to south, within brackets, along the cast side of the said scheduled property, enclosing 40 feet from E to W, measured on the said scheduled property, bearing municipal number 31, situated at BBMP, ward number 27, First Main Road, Sheshadripuram, Bangalore. At the time of demolishing of the existing building at number 31, or within 2 months of executing the agreement. He has also drawn the attention of the court to the schedule of the said final settlement and also the confirmation deed. Basing on these, then counsel submits that the plaintiff has no right or access to the said passage, and it is the property belonging to the plaintiff, and they have been in possession of the property. And the plaintiff had come to the court by suppressing the material facts. Next para. And he's not expert. He submits that the trial court had rightly considered, and this and the appeal is liable to be dismissed. Next, having heard the counsels on either side, reduce the material on record. This is a suit filed by the plaintiff seeking a bare injunction, restraining the respondents from interfering with his passage to the plaintiff be scheduled property. According to the plaintiff, though he has purchased the property in the year 2007. 7 or 8?
7.
Huh?
7.
He has purchased the property in the year 2007.
On 18/4/2007.
On 18/4/2007. 2007. Though the boundaries of the said property, they do not disclose that there is a passage, but according to him, in the vendor's documents, this passage is found, and he has been using it. He has mentioned about a confirmation deed, which is executed on
58/11. Five 11/2008. 5/11/2008.
5/11/2008 between the vendors of the defendant and the plaintiff. On the same day, there is a final settlement deed that was entered into between the parties. While filing the suit, he has stated about the supplement while filing the written statement, or while filing in the plaint, he had stated about the confirmation deed, but when it comes to the final settlement, there is no mention in the plaint. There is no mention in the plaint. After the defendant had filed the written statement, he has stated about a final settlement which is executed on the very same day. Now it is submitted by the land council, the senior counsel for the plaintiff that in the suit that is filed in the suit for mandatory injunction that is filed by the defendant's vendor, they have denied the same. They have denied the same. Also, it is undisputed that about a confirmation deed or the alleged final settlement deed, there is no mention about the same in the plaint that is filed. When the earlier suit is filed seeking mandatory injunction and the plaintiff's vendor has denied the title to the right and title of the plaintiff to use the plaintiff herein, who is a defendant therein, to use the said property. And pending disposal of the said suit, now this suit is filed seeking injunction. And this also, it's a suit for fair injunction. The defendant, now the court had taken note of a particular clause in the final settlement, wherein he agreed to put up a brick wall to the ceiling height along with 33 feet from north to south within 2 months of executing the agreement, which is a crucial factor which has to be brought to the notice of the court when he has filed a suit for injunction. All these should have been a part of the plaint. As they are denying the said agreement, according to him, it is not necessary, according to the plaintiff, it is not necessary to state the same. In this case, it's a clear case of the documents that are relied on by the plaintiff, that is specifically his document, that is his right to the property, the sale deed do not contain it, and even the supplemental deed do not contain the said passage. And as rightly observed by the court, from the plan that is placed before the court, the property is having an access access towards the conservancy. The entire he has constructed the property which is the elevation is toward the conservancy, and he has put up a gate for parking vehicles and using the said conservancy to gain access to his property. So if an injunction is not granted that he would not access to the main road, that argument cannot be accepted. When the defendant is the owner of the property and he has showed by some documents that he has been some documents that he is the owner of the property and he denied the title of the plaintiff, at this point of time, the court cannot grant any injunction. Whether a bare suit for injunction is maintainable at this day under these facts and circumstances is also another issue that falls for consideration before the trial court. In the considered opinion of this court, the trial court had rightly dealt with as far as the access of the plaintiff to the conservancy and the fact that the plaintiff had not disclosed when he is seeking a relief of injunction, he should come to the court with clean hands and should state before the court all the relevant facts, which were relevant facts. The plaintiff has not disclosed all the relevant facts, and initially the court has granted an ad interim injunction. This court finds that there is no prima facie case or balance of convenience in favor of the plaintiff. In fact, the balance of convenience is in favor of the defendant. Accordingly, the MFA is dismissed. Any of the observations made by this court in this application shall not be construed as the expression of this court, and the trial court shall decide with the main suit. on the merits of it. Yes.
Still number
Read for me.
17. Still number 17, Prabhu.
Serial number?
Nagaraj, yes, still number 17.
Yes.
Yes, Nagaraj.
No representation on behalf of both the parties. Post this matter on 29th of October. Yes.
Still number 18, Sharat Gowda GB.
Appearing for the petition, they have to file memo of calculations, Your Lordship. Kindly extend the interim order, Your Lordship. Kindly extend the interim order. You have an interim order? Yes. In spite of an order passed by this court, file the calculation memo. Respondent has not filed and again sought for time. Post this matter on October 22nd. Interim order earlier granted is extended till then. Yes, 19.
Still number 19, Rajesh, 8. For petitioner, N. Kumar.
Where is the petitioner? Is there any interim order in this? No, let's go to that later. No, there is a stay. Bank statement from the year. Then we'll see it later. Post this matter. No representation for the petitioner. Counsel for the respondent is present. Post this matter on October 14th. No, the difficulty is every time we have to run the same matter. There are so many memos are pending. What is happening is one matter is coming up at least for 1 month, that after, 2 days, 3 days, 4 days, the entire list is with the same repetitive matters. Yes.
Still number 20. Latif B, for petitioner.
Challenging the interim order, interim maintenance.
How much is
Challenging the
granted?
maintenance. It's 12,000, my lord.
12,000.
12,000, 6,000 to the
income?
petitioner number 1.
What is your income?
My income is 8,000 per month. 8,000, working as a coolie.
You have not contested before the trial court.
We are contested.
Then how the court had granted 12,000 when your income is 8,000?
They are
Come
contested.
to the order.
My lordship, page number 28, point number 18.
20?
28. Point number 18, I filed an affidavit of assets and liability. showing that,
Respondent specifically denied the same in his objections. He has not pleaded any facts about his qualification, avocation, income.
Point number 18.
His mother is, have you filed your statement of assets and liabilities?
Please, my lordship, point number 18 in the same page.
Doing coolie and earning 8,000 per month.
Please, my lordship.
SSLC, cooling work at Market, Bangalore. Only wife or the child is also there?
2 children, my lordship, 2 minor children.
Minor
6,000.
children and wife.
Please. Marriage is in the year 2016 and she's not there in.
Hmm. 52:30. 2 o'clock. Yes.
Marriage is in the year 2016 and from 2019 she's living in the parents' house. I won't contest is that I'm working as a businessman who is having 5 assistants with me. Again, in the page number 61, they themselves suggest me that I'm working under a company.
How much you will pay?
Ready to pay 5,000.
Please come. Then answer the petitioner. Submits that. Though it is specifically pleaded before the trial court that his income is 8,000 per month, 8,000 per month, and he's working as a coolie. Whereas the respondent wife is educated the trial court had granted maintenance of an amount of rupees 12,000. Then counsel submits that, when his income itself is 8,000. If not, he cannot pay an amount of rupees 12,000 as maintenance to the wife. When is the petition filed? What did you pay till now?
My lordship, the order is to pay the maintenance from the date of the order, the impinged order.
Where is that?
Page number 34, my lords.
Then before what will happen before that? Anti-maintenance so and so from the respondents from the date of this order.
Please, ma'am. The orders on the date 2nd February 2024.
Second,
February 2024. The impinged order dated.
please, what did you write? Hence, there shall be stay of all further proceedings pursuant to the order passed in criminal misdemeanors number 158 of 2021 dated to 2nd February 2023 on the condition that the petitioner shall continue to pay an amount of rupees 5,000 per month by 5th of every succeeding month and shall deposit the arrears at 5,000 for a period of how many months? Nowhere in 8th month per
6 months.
for 6 months. At 5,000 per month, that is 30,000 within 4 weeks, either of it. Same usual order, you shall take out notice to the respondent. It is RPF, issue a notice to the district director to issue notice to the respondents. Yes, next.
30, 21. Sharat Gowda GB. For petitioner, Nanjunda Swami.
Petitioner in this matter had filed an application under Order 7, Rule 11D. It came to be rejected by the family court, as against which this writ petition is filed. My lord, the previous date of hearing, a submission was made, my lord, that the writ petition is not maintainable, and I need to approach. I need to file a revision petition, civil revision petition. It's a submission. I'll address that issue, my lord, as how the writ petition is maintainable. If I may persuade my lord to
Counsel is not there today. He's not the one. He is the government counsel.
Oh, I'm sorry.
I'm government.
I'm sorry, madam. Intermodal.
We'll have some other day. When counsel to
Please.
respondent is not present. Post this matter on September 10th. Yes, next.
Lord, there is an interim order. It may be kindly.
Interim order earlier granted is extended till then. Yes.
22.
22 is adjourned.
22.
22, some mention was made.
Is it
Appearing for the petitioner, my lord.
Oh, petition may be allowed. Yes.
I'm for the respondent, Your Honor.
My lord, the petitioner herein is the respondent in MC.
No, he's saying that the petition be allowed. Will allow.
Allowed. Maybe allowed.
Where is the memo filed?
Your
You
Honor.
filed a memo.
No. Just that.
Where is the order? Page number? Oh,
You filed by the I number
where is the husband? Where is the wife or the husband?
is in Australia.
No, this, even if you want, the court will not allow this application.
No, I am for the respondent. The respondent is residing in Mysore.
That's what I'm saying. Even if respondent says, still the court will not allow this application for conducting the cross-examination by video conferencing.
Because
You know, once this kind of an orders were passed, unless that there's some, that resort matter is there, no? Post along with it. That is one matter is resort, when is that?
no, already is a leading evidence. You are. That time I was putting the application for cross-examination.
What?
For cross-examination.
What is leading evidence?
My lord, the
Through video
petitioner,
conferencing.
my lord, the
Respondent
petitioner in this
evidence.
case is the respondent in the matrimonial case. He has entered appearance and he has filed his statement of objections and he has led his evidence through video conferencing, my lord. We have filed an application seeking permission of the court to conduct cross-examination through video conferencing. So that is the order that was passed, my lord.
Will pass. That along with that number. What mother and daughter? Post the heard reserved for orders along with one number is there along with that. The senior constable has appeared the other day. Yes.
Serial number 23, urgent, 24.
On the order dated 19/7, my lords had given permission for the withdrawal of the. But then the office objections had been raised, all have been complied. So if it can be expedited, that is all required.
What is to be done?
They had asked for the check to be deposited, the leaflet of the check, that is also given in this.
Amount. I have deposited the amount, my lord. They filed an application for withdrawal that amount. I was allowed, but there is some office objection raised, my lord.
What it says, non-filing of demand draft by counsel for petitioner.
I have filed. So,
Look at the cause list, that's what it says.
24, my lord, serial number 24.
Oh, 24, I am looking at 25.
24 months.
So what has happened in this?
We had filed an application for the withdrawal of the money. And then they had raised an objection, we have complied with it.
Yes.
So if it can be expedited, that is all.
What expedited? It will be done if you comply.
It's complied with, because the order
If
is-
the objections are complied with the respondent as ordered by the court, they are permitted to withdraw the money. Yes.
IO may be extended.
Interim order or a
and
grant
a
is
shorter
extended
date
till
will
the
be
next
given
date of
to
hearing.
file the objection.
Pose this matter on 17th of September. Yes, next.
Serial number 25, urgent, 26.
I appear for petitioner, my lord.
Yes.
And I have some inconvenience, my lord. And I said I also informed my learned friend.
Pose this matter on September 18th at the request of writ petitioner.
Serial number
Interim order may kindly be extended.
Interim order earlier granted is extended till then. Yes, 27.
27.
I am grateful to my.
Here for the petition, on the last date of hearing, the matter pertaining to planters, coffee planters.
Yes, why is it
Lordship
adjourned?
have heard this matter at length
Mm.
on 3 occasions.
Yes.
Directed me to file an affidavit with regard to the employment status of the petition. And also your lordship directed me to file the bank statements of both the parties. Direction has been issued.
This pose this matter as the first case tomorrow. Because there are 3 matters, order has to be
Yes, yes.
dictated.
Because already
Now-
your lordship have already heard this matter at
So
length.
we'll dictate it tomorrow morning.
Yes.
Not tomorrow, madam.
Mm.
Some other day.
What?
Not tomorrow.
Only
madam.
for dictation. of
Oh,
papers.
correct, madam, but bank statements has to be.
Bank statements have to be, you're filing today.
Yes, my lord, both they are also filing and we are also filing. Because your lordship has asked us to file the bank statements.
As per
Joint
the orders passed by the court, but the court will not look at the entire
Yes,
bank
yes,
statement.
yes.
Please summarize that and
Yes,
file you file your objections to that or
No,
whatever.
we are not sharing because this
That's
is
a
joint,
one.
this one, they are not sharing.
No,
We are-
we are sharing. I have the.
What not sharing? Is
No.
it a private
No,
document? or
no.
what?
When they are not shared, even the passport also, which is a government property.
It's a personal this thing.
Allah, this is personal, this one this joint accounts,
I have
not
the
personal
copy.
accounts. This is,
The copy.
this is the,
Strange. Now the court will record everything.
all right.
Court will record everything, whatever that's fine. How can it be a personal one?
No, I'm giving.
As per the order passed by this court, both the petitioner as well as the respondent have filed their respective bank statements and also an affidavit filed by the wife stating that she is not employed.
It is not.
Employed. They have filed a bunch of papers. And it's not possible for the court to look into all each and every page of that bank statements.
Yes.
Whatever is the summary of it, that also should be filed by way of an affidavit.
Yes.
Suppose this matter on September 11th. Tomorrow, how is it possible?
How is it possible?
How is it
I have to
possible
go through
tomorrow?
my entire statements. And you have to go through my statements.
Allah, even now, the lordship has kindly appreciated. We have already stated we are on affidavit. Directly, not gainfully employed at all. And this is joint account of my father.
That, to that effect, it's correct. Now they filed their statement of bank statements. You are saying something that you can look at the statements and say this is what is his income, because I cannot look at each and every paper. Then when? I'm saying it's September 10th.
Yes, ma'am.
Huh? September 4th. September 4th. Yes.
4/9.
By the time everything should be concluded, that day will pass orders. September.
I am taking over the entire statement
Huh.
doing now only, my lord. He has to give it to me. I will give it. Because I am giving it. I will give it to the courthouse.
First give it to him, then you can file before the court on that day also. Give it to him first. Yes.
Till number 28, Lakshmikant K. S.C. Prakash.
Hmm.
I appear for responding.
Yes.
My lord, last occasion, my lord, that fund, my lord, stating that the amount in deposit, now he is going to deposit in the name of the petitioner, the respondent.
The son, and it would be in the name, joint name of the son and
First wife.
First wife.
Second wife.
Their money, no, it is not the father who is doing it. That is him who is doing it. And what he says, he has no right to operate that account. But he will know what is happening.
But if he requires that amount, my lord, that amount.
You have to file an application for the, because that person is a person of unsound mind or what, then the permission of the court for a big amount is required.
My lord, his signature also required.
For what?
That is, withdraw the deposited amount, not interest. Deposited amount.
Not his, you have to take the permission of the court, then he has to give the permission. That's what we will record. No, what is the difficulty? Ultimately, they are looking at it to secure the interest of that person. And then why are you not showing that?
Correct, my lord,
Now, if this arrangement is made, he's a youngster that how old are you?
my lord,
How old are you? The guardian is, how old is the mother?
mother is 50 plus, my lord.
Oh, what is his age? Is that, who is taking care?
Aunt.
Mother, sister.
Mother, sister.
Then all the more reason. Why will they give?
My lord.
No, why will they give it to the aunt?
She is looking after the.
Let her look after him. Let her look after him. Let her have the interest.
He did not pay anything till today. She has paid all the expenses towards medical and other expenses. Till today, he has not paid.
Is it that what you want is whatever she has spent till today, she wants to withdraw it? Is it her case?
No. My lord.
No, please let us have the facts clear. Is it your case that all the while she has been spending, that whatever money now they will give, she will withdraw whatever she has spent? If that is not her intention, she should not feel, she should not have any reservation with this.
My lord, she only expected the welfare of the.
Yes. And
respondent.
this court is also looking at the welfare. It is the duty of the court to safeguard that.
Then, my lord, this honorable court, my lord, permitted the petitioner herein, respondent herein, the amount in deposit with the permission of the court, then I agree, my lord. Otherwise, my lord,
Yes. Now, regularly, whatever is the interest that is derived from that deposit, that can be withdrawn by the respondent. Whenever apart from the interest, you are in need of any other amount, an application need to be moved before the court.
For withdrawal of the principal amount.
Principal amount.
Principal amount. My lord, the one more thing is, my lord, the petitioner hearing
for regular amount, for regular withdrawal of the interest, his consent is not required.
Please, my lord. My lord, in respect of the principal amount, my lord, he has no objection to.
It is for the court. He cannot have any objection.
Please, then
for the court to decide whether that is withdrawn for the welfare of that person or not. Court will order.
The court order is because I am not the party there. One thing they need to. KYC document. We are unable to open the bank contract.
No, do one thing. With all whatever now the court has expressed, with that both of you for exchanging all the relevant details, and depicting all the details, you file a joint memo before the court as how now the court has expressed. Please, accordingly begin. Yes, when can you? Part heard on 2nd of September. Yes, next. Huh? Delete from the caption dismissal.
Till number 29.
In 29, I appear for respondent number 20's counsel. Just day before yesterday, the court may recall an appeal where I was for the appellant, the court dismissed. Now I'm on the other side, and even perhaps I can say even more egregious facts in this case. 1920 will and 1987 sale deed, they are now asking for it to be not binding on them.
No, this will come right from, no. Right from 29
Yes.
to this 34.
Please.
So till when? So,
34.
till 34, it will come on the top of the list tomorrow. It will continue till.
Tomorrow, some difficulty. Could it be day after tomorrow, please?
So 29.
Could it be day after tomorrow?
Shall we have it on 3rd September?
3rd September. Very well, very well. Please.
3rd September at the request of Plan Counsel for the respondent. Yes, 30.
Tomorrow, my lords, I appear for the petitioner's counsel.
Tomorrow, 31.
Much obliged.
31.
Samir Hassan. Harshavardhan.
For the respondent. Any interim order in their favor? No. Poses no representation for the petitioner. Counsel for the respondent is present. Poses matter on 24th of October. Yes, next.
Till number 32. Rupesh Kumar.
Yes. You're for the respondent.
There are two connected maximum. Yeah.
Post item number 32 on at the request of counsel for the respondent on 18th of September. Yes, next. 33.
33.
Yes, okay. Last occasion also petitioner was absent before the court. 2 months earlier is there.
Tomorrow. 33 tomorrow.
And then
Monday.
at top of the list. Otherwise, since 3 days, it is not reached. My anxiety is not. It is again the interim maintenance ordered by the.
That is, it's coming. Let it come up on Tuesday. 33. This next.
Top of the list.
There are so many top of the list today.
2 months.
No, what is happening is why the list is not going faster. All the matter that has to be dictated or coming up on the top of the list. So for completing first 7-8 matters, it's taking a lot of time.
My anxiety is this. So that interim
Will
order.
be on that day, if doesn't reach, then on that day you mentioned at the top of the list. Yes, next. What are the other matters? Which case?
Appear for the respondent, serial number 34, my lord. 34.
34, yes. What is the permit? Why you can't make a submission on our behalf? I know that. Yes.
My lords, I kindly request my lords to list the matter on day after tomorrow, my lord. So there was an order to file an affidavit, my lord.
Yes.
I'll file the affidavit tomorrow, my lord.
Yes,
Kindly
yes.
have it day after tomorrow, my lord.
Yes.
So ma'am, 3 visitations were given. So last Saturday, Sunday and this last Sunday. So all the 3 visitations I had taken the child, I dropped him in the play area.
Asked him to come.
And he had spent time with the child. And only after he gave me a call, I went and picked up the child. So this last Sunday alone, he wanted to take the child. And when the child, he wanted the child to get inside the car and sit. So the child requested that, I be accompanied with him. But he was, pressurizing the child, saying that the court order is not that your mother will be accompanying you. So I don't want your mother to sit inside the car. I want only you to sit
Why do you
inside the car.
precipitate that like that?
So
But
the child is afraid now.
Even on that day also, I told you, he's already, whatsoever reason, whatso happened, he's not, he's behaving little in a very aggressive manner and little weird. So when that's the situation, he says that I'll sit in the car, okay, let my mother come. You shouldn't insist. A court order cannot make you to, have the bonding with your child.
Yeah, ma'am, I'm already, all these 2
Also
days.
mentioning, ma'am, that
Yes.
it
Ma'am,
is
all
the
the 2
court order.
days, I communicate through email. When she said I cannot, we cannot come to the clinic, I agree to that. I went and played with him. So what the problem is, only 1 hour, whatever he just play with me, he'll not have that 1 hour he'll play without any issue. The moment he comes out of the play area, then he's not ready to spend a single time with me. Not a minute. Immediately, he wants to speak to her, or her presence is required, and is scared. I don't know what, because when I play with him, there is no issue. The moment he comes out, and always there is her presence, and I'm not getting that. Only his time. I'm not getting it all. So it's only I'm getting the play time, not a quality time to speak. So
No, it has to go in a phased manner. Are you accepting the fact that whatever the 2 or 3 occasions, he was playing and he was comfortable?
yes, while playing, he doesn't have any problem. But
That time
even
you do not interact.
that time, like it's like continuously you
interact with
play continuously. Like it's like you have a lot of activities to
No,
do.
but still he interacts in between with you.
Interacts. There is no time to talk. So it's running around playing.
No, that he'll be playing with you.
Yes,
Or
yes.
he plays on his own.
No. We play.
Like,
Yeah.
as of now, it's happening.
Yes.
So,
So
the manner in which he was talking and how he was, so if this is happening, let it go on. What you have to understand is what is not happening for so many years, just like that, it can't happen. And
Yeah.
also we are dealing with the the emotions of a child.
yes, ma'am. I
So
absolutely
now it
agree.
is happening. Only what you're supposed to do is don't try to show that anything that is happening is because of the court order, or it should happen how you want. No, please
I never
understand.
said
If the
that.
child is, for example, both of you are together. When something has to be done and the boy is reluctant, don't you discuss them and make him understand and do it?
Yes, ma'am. So I try
that
to
way.
always try to talk to him and
Do it
understand.
that way.
But I don't see any effort from there, and to because what have this happened
No, for
because
example,
the long gap.
No, 1 minute. She is there throughout.
Yeah.
And when she is there, with him, if he is interacting with you, you cannot have any difficulty that she shouldn't be there. We'll do one thing. We'll try on the next visitation. We'll try. She will also be there. She'll
Yeah.
also be there. Then spend time with him.
Right.
And if you feel that at that, in our presence, if he is not communicating with you, or he is doing something, then we will see.
Yeah. Sure, ma'am. So the one incident I want to tell you, because the first visitation, the moment I entered the play center, he's talking about, I will only play with you if you promise me that you tell the
You told
judge.
it on the- you
I mean,
said
that is
so in
something
the
which
last
the child
petition.
is not
No,
supposed
leave
to.
it. No, here it is. No, it's not about complaint, or it's not ultimately what you want is you want to have the child and you
Yes.
want to spend time with him. So what are the possible means to do it, that has to be looked into.
Yeah.
Now you say that, no, with how he was talking in the chambers that day, and now what you say. So there is some, may not be like a great improvement, but there is something compared to that date now.
Yes, ma'am. So even these 10 visitations which I got in the 10 years is the same place, exactly same time. There is no difference in that. So to change that, at least I want to take him to some, say for example, a national park or somewhere. I mean, where we can
Take
play
her
with the
also.
nature. Yeah, I'm absolutely fine with that.
Take her also.
Ma'am, one small
But-
request. So last Sunday, I was also ready to go with him.
But he
For
didn't
2
take.
hours, he went and sat inside the car saying, the court has ordered you to convince the child. I have no role in
No,
this.
we'll see
You
now.
just convince the
this
child
Saturday-
and send him inside the car. He just went and sat inside the car, ma'am. 2 hours, me and my son, we were standing there outside the car and talking to him.
Why should
Continuously.
it be like that?
Ma'am,
For 2
ma'am,
hours,
1 hour I
ma'am.
was just speaking to him
It's
to
not-
convince.
this is
And
not
he
the
just-
way-
I didn't
You
spend
please
inside the car.
understand why the court is giving you so much of time. That you have to understand. How many times there was an interaction in the chambers? At least 7, 8 times.
Right.
And how many
2
times the
times.
matter has come up before the court? Both of you have to understand that. No, just one order I can pass, saying some order and letting you parties do whatever you want to do. But that's not the whole whole, the exercise the court is doing.
Right.
The court is concerned about the child and at the same time about, your affection towards the child. That is also important for the court.
Right, right.
So how,
Ma'am-
how do you suggest? Ultimately, what has
As
to
you
happen
said,
is,
we'll have to consider the emotions of the child also. Now he's
The-
comfortable. No, when I left and went, the child is playing with him. So slowly, we'll go step by
oh,
step.
that
Like,
tell the court, instead of telling the problem, tell the solution.
ma'am, let him continue his visitations rights every alternate week. Let him play and spend some
And
time.
alternative week.
Ma'am,
because-
I also get only on Sunday mornings to spend time with him.
Saturday is
no,
there.
Saturdays I am working, no ma'am. I am in a
Evening.
profession where ma'am,
Evening.
I work throughout, I am a doctor. So I have my clinic and
In
I'll be
that
attending
case,
my
then on
patients.
Saturday, let him,
So-
because he has the time.
Yes.
And you are working throughout, then let him spend time with the father.
Ma'am, he's getting trained with football, so he has to go for that also. So little bit here and there, it will be there. Whenever he has to go for that, I am taking him for that also. So Sundays will be where he's totally free. He doesn't have any classes on Sundays. So he's taking few tuitions
In
also for the
Sunday,
languages.
On Sunday, on a Sunday, give him some time.
Ma'am, I am dropping him and going, ma'am. I'm not sitting there. My presence is not there at all.
Even if you want also, no, that not alternative, already the time that he's getting is very less. And that again, alternative, it becomes a very, there's a long gap. When you have to build the relation, long
even-
gap will not do.
Ma'am, even I will have some plans with him. So please
Then happily,
consider
then he
that
will take
also,
care the
ma'am.
whole week. You meet him on Saturday and Sunday. No, that can't be. You can't have both the ways. Child is with you and you say, I spend time with him on Sunday. Then what about him? The whole week he is not with him. You have to just place yourself in his position. Then you'll understand the pain of him. No, even when earlier, when the orders were passed, the court always was trying to consider your case also. You said because of the court orders and all, from a long time, he didn't go to his, is it so? The great grandmother and all. It's the same case. So court said, no, in those time, no, the visitation, let him go and enjoy. Here it is, ultimately, that this has to go to a logical end, and particularly both of you are educated. And whatever the day that I saw him his behavior is something which is which I cannot say that it's just an emotion of the child. That's why even when you file this memo for withdrawal, I didn't accept, because you can't use the whole process for your advantage when it is disadvantageous to you. It has to be the manner in which he behaved that day. I thought that I will shift the custody to the father, because that's the only option. So what is now according in the opinion of this court, you please tell the court, and you also make all your endeavor from your side that how the father will get the visitation or the bonding will develop. But it not like whenever it's convenient to the boy and you. It should be
No, ma'am, I'm not saying like that.
it should be convenient. It should be
what
on
I'm
to the end. And even I told you last time also about the maintenance or other issues. If you fairly come forward with all that, we'll also make him to accept whatever, not accept, will also his advocate will convince him to do something like whatever, not to, wherever you are entitled for something he's not doing, we'll tell him that. And he's entitled for the visitation of the child. How it should happen. And that kind of, that negativity the boy has, it should come down. And whatever he has done, I don't think that is the intensity I saw on that day. It is something which I think he has not contributed to that level.
Ma'am, there is zero contribution from my side also, ma'am. You have to trust me on that.
But you shouldn't, child, we
Never
all
speak anything
know
negative in
the
front of
the whole endeavor of the court is to take care of the child's interest. But that doesn't mean that he can, how we were shouting at him. Is it, like if the child is growing up in a manner which is required to be, he wouldn't have shouted. He wouldn't have called his father Sarath. Even if I remember the name of Sarath, is not because I don't remember any client's name. It is the manner in which the boy has shouted at him. I was surprised, like that is something, it is not normal. And you shouldn't you shouldn't even accept it, because that's not the way a boy is supposed to behave. He has no right to talk to his father like, first of all, make him say whatever he say, call him Papa or whatever is, let him say. Why is he taking his name? And I'll post, when do you want?
My lord, day after tomorrow, my lord.
Day after tomorrow, we'll take up the matter. By that time, please tell the court how the thing should be. And however both of you say, basing on that, we'll pass some more orders. And it should go on. Yes.
Thank you.
Serial number?
Grateful, my lord.
All this serial number 50. Calculation. Post this matter on 24th of September.
I'm for the petitioner, serial number 50.
So 50, yes.
1 week.
1 week, take a longer date.
A shorter date.
Post this matter on 11th of September.
This memo is for WP 6686. So it is reserved for the orders from March 11th. So kindly expeditiously.
Take that. Take that. Tell her no. No. Yeah.
ಅದು ಎಷ್ಟು ಮ್ಯಾಟ್ ಅಂತ ಅವ್ರು ಫೈನಲೈಸ್ ಮಾಡಿ ಹೇಳ್ಬಿಡೋಣ ಅಲ್ವಾ? ಬಿಂದು ಈ 3 ಮ್ಯಾಟ್ ಕಳಿಸ್ಬಿಡು ಬ್ರಾಂಚ್ಗೆ.